Thank you. I declare open this hearing of the Parliamentary Joint Committee on Corporations and Financial Services into the Financial Services Regulatory Framework in relation to financial abuse. I begin today by acknowledging the Ngunnawal and Ngambri people, the traditional custodians of the land on which we meet, and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing in person and via video conference. These actually are public proceedings being audio streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request the answer be given in camera. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy, and shall be given a reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. I remind any committee members and witnesses who are appearing via video conference and who are not speaking to mute their microphones. I now welcome Ms Rebecca Glenn from the Centre for Women's Economic Safety. I understand, Ms Glenn, that information on parliamentary privilege and the protection of witnesses giving evidence to the Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
I'm Rebecca Glenn, and I'm the founder and CEO of the Centre for Women's Economic Safety.
Thank you. I now invite you to make a short opening statement. At the conclusion of any remarks, I'll invite members of the committee to ask questions. Ms Glenn.
I'd also like to acknowledge we're on the unceded lands of the Ngunnawal and Ngambri peoples, and I pay my respects to elders past and present and to all First Nations people here or watching today. The Centre for Women's Economic Safety is a registered charity operating nationally to support women experiencing economic and financial abuse in the context of domestic and family violence. We also work to reduce the impact of economic abuse by sharing women's lived experiences through education and advocacy for social, service and system change. This inquiry is such an important opportunity to identify and commit to meaningful change that will help prevent and mitigate harm from financial abuse. Too many women that we support are being propelled into poverty because of unhelpful systems and poor product design, which enable abusers to deliberately misuse products and services to the detriment of an intimate partner or family member. The impact of this financial abuse is enduring and it is compounding, affecting health and wellbeing, housing, employment, credit scores, parenting, social connections and financial security. And I'd like to share a quote from one of our lived experience panel members who puts it so well. She says, "I think it's difficult to explain to people that you can't put a dollar figure on what it costs you mentally and emotionally. He's cost me hundreds of thousands of dollars, but it's not even the actual dollar figure. It's what it costs you in your future life. I can't just go and get a home loan now because I'm a former bankrupt. That's what it really costs." You'll have no doubt read the statistics in the many submissions that have been made to this inquiry. This is a sizable problem. But I urge you to remember that behind these statistics are hundreds of thousands of individual human beings who are struggling as a result of the actions or the inactions of others. You'll also read many quotes and case studies, and behind each one lie much larger stories of abuse and injustice. What women tell us is that navigating a way out of a relationship with a financially abusive partner and or family member is complex. It's exhausting, it's demoralising, it's like a full-time job with no pay and without the satisfaction. We believe that financial and economic abuse are under-recognised drivers of women and children's poverty in this country, and is contributing to homelessness, especially among older women in Australia. We've made 37 recommendations in our submission for action that can be taken by individual financial institutions, by the finance sector, regulators, state and territory government and the federal government. But this work is complex and it cuts across many more sectors. If we want to get serious about efforts across government, industry and the community sector, we would establish a new national body focused on financial abuse to drive and coordinate this work. And at least 9 of our recommendations could be taken up by such a body. Other key actions needed to address financial abuse in Australia include embedding financial safety by design in products and services across the finance and government sectors, and mandating what are currently voluntary actions against financial abuse, things such as implementing terms and conditions on financial products and services, requiring financial institutions to meet the international standard on consumer vulnerability, moving away from the language of vulnerability in customer-facing communications, having institutions develop investigative capacity to reduce the burden on victim survivors, and training in financial abuse for financial institutions and government agencies. I urge the committee to remember, as it hears evidence before it, that there is no one or magic solution, and I ask that no initiative or response should be judged on whether it will work for all people in all circumstances. I'm not sure that that exists. I would also like to make a suggestion to the committee to have a closed session where you can hear directly from victim survivors of financial abuse. And I'm sure that many members of the Centre for Women's Economic Safety Lived Experience Advisory Panel would be delighted to share their stories with you. Thank you.
Thank you very much. Ms Glenn, I just want to indicate that there's an article in this morning's Australian by Cleona O'Dowd, and it advises that ASIC has approved the new banking code, which and Mr Longo, the chair, says, no matter where we are, there's always room for improvement to pay close attention to expectations of communities, on consumers and the community more broadly. I guess the reality is that we have not yet seen the final of the ABA and interrogated it as a committee of the new Code of Conduct, but there's a tick off there for what they've got from ASIC. Hopefully it will attend to some of the things that were in the old code, but clearly missed the mark, or you wouldn't be giving us the evidence that you're giving. So that's just live for the committee to give further consideration to. Can I thank you for your submission? I'm sure all my colleagues have questions, and I'm going to go first to Ms Mascarenhas, who brought this idea to the committee, who embraced it unanimously. Ms Mascarenhas.
Thank you for being here today, Ms Glenn. I think that what we've seen from an Australia perspective is a national conversation be sparked around domestic violence and family and domestic violence in our communities, and I think that everyone's got a role to play. You have done a lot of work to have a look at the banking industry, insurers, as well as what governments can do. I think that everyone's got a different level of sophistication of where they're at on their role to play. Do you have views on who's more progressed on helping protecting vulnerable people when thinking about the banking industry, insurers, governments, federal and or state?
Yeah, look, and I think the banking industry in Australia has been doing a lot of work. Where we are now compared to 5 years ago is a significant improvement. As a result of the work that we've done with Catherine Fitzpatrick and Flexibility Ventures, and I know she'll be speaking with you later today, we've now seen 25 businesses, including a lot of banks, change terms and conditions to call out financial abuse as unacceptable customer conduct. That's world-leading changes right there. I think that that's a really good, solid starting point. And I think that as a minimum standard for businesses, we should see that across many sectors. But we need to know what's going to happen as a result of those terms and conditions, because they change the contract with the customer and provide an opportunity for businesses to hold perpetrators to account, and to have more discretion in how they might respond to victim survivors of financial abuse, to try and help them extricate and re-establish themselves, disentangle from the perpetrator and get set up again.
And do you have a sense of which countries are leading the way in this space compared to Australia?
I think Australia is actually doing a very good job. I mean, there are specific things that are happening in different places which we can look to and learn from. I think there's a lot of work happening in the UK around the consumer duty, which I think is, there are some parallels with the activity here. But in all of these cases, we see a reliance on voluntary codes rather than mandating action. And I think the problem is just too urgent to wait for people to slowly learn and improve to meet a voluntary code. We have hundreds of thousands of people suffering right now, and I think we need to get serious about treating this problem as seriously as it deserves to be treated. And that's why in our submission we're really asking for more mandating of standards rather than waiting for people to meet a voluntary code.
And from a sense of the scale of this issue, have you had a look at demographics from a age, location, cultural background, that kind of information?
Look, there is still a lot more research to be done. What we do know is that we see people experiencing financial abuse and problems with financial and government institutions and agencies as a result of that financial abuse across every socioeconomic group, across every age group, across every culture. What we know about cultures is that money is, in a strange way, an expression of culture. And so that may manifest and look different in different cultures. But the bottom line is the abuse and misuse of trust, and using financial resources to exert control for one person's benefit rather than the family or the other partner. So I think we've got to not get distracted by those kinds of demographics and understand this is a problem that cuts across demographics, it cuts across every postcode in the country, and requires, as you say, a cross-sectoral, all-of-nation effort.
Another thing that I'm curious to get a sense of, and I feel like you'll have good experience on this, is often in women's circles as opposed to men's circles, financial literacy is not necessarily discussed. And so I'm wondering if financial literacy becomes like a barrier when people start facing financial abuse, and whether there's a role of increasing the culture around financial literacy.
I think financial literacy is such an important life skill for all Australians, and that feeling empowered with your money is a great feeling. Feeling disempowered because of the actions of a perpetrator is awful. But I think we need to be a little bit careful. I think that financial literacy is somewhat of a seductive mirage about as a way to address financial abuse, knowing how to manage your expenses, saving for the future, understanding compound interest. These are not knowledge pieces that are going to stop an abuser perpetrating financial abuse. Where I do think that financial literacy can play a role, and you sort of touched on this, is building confidence and competence in having conversations about money. I think it can help people model healthy relationships when it comes to money. And I think it can help elevate and raise awareness about some of the warning signs of financial abuse. So excellent life skill, but it's no solution to this problem.
We have 45 minutes only with Ms Glenn, so I'm going to share the call in quite short lots, but you've got the call next,
thank
Mr
you.
Hawke.
Yeah, well, thank you, Chair. Just want to ask you a question about your submission and some of your comments. So I appreciate all of the recommendations you've made. You made lots of recommendations to government, which I think is very helpful. A lot of them I would describe as amendments to existing acts or things that you've identified are legislatively, need to be solved. Just in relation to your recommendation about a new national body, I just want to understand, I've got a two-pronged question about this. So, to establish a new national body to coordinate all of this, I can understand why that might be a good idea, but it implies to me that, you're not getting cut through the existing systems. So just want to ask why are these important recommendations? And, this is a frustration, I think, for a lot of parliamentarians and people who've been in government. Why some of these things are very obvious and need doing, and modernising our system, is long overdue. But why is this new body, in your mind, going to do more than what we've all been unable to collectively do through the existing layers of departments, bureaucracies? And I think a lot of it is just, as you've probably found, systemic. You can't get the right cut through. So I think you need to make the case for this new body, and I'll give you the opportunity to do that for us. But also, and I think you've got to be frank with us about what has not been working in relation to the existing system, which is a big question. But why can't we get some of these common sense things done through government?
So if I share experience of how we've addressed some of the problems, we have conversations with, say, a financial institution about why it's so difficult for a woman to get a mortgage when she's left an abusive partner. Maybe there's family law proceedings and she just wants to have him off the mortgage, but she cannot meet the threshold test to get one. So banks say, well, we can't do that because of what's happening with regulators over there. Regulators are after a case as well. We've got family law issues, where they might make an order about what should happen with a property settlement. But the family court is not a party to the mortgage, so it kind of sits there, not actually no action being taken. So we just kind of, it's too hard, that's outside of our remit. And so the advocates who are trying to say, well, look, can't we just get these parties together to thrash out what's involved? Most of us are in the community sector. We are not well resourced, and we're shouting from the rooftops, but we don't have the convening power of a body like a government body. And we've seen recently with the Domestic and Family Sexual Violence Commission what can happen when you have a body that actually has that credibility and convening power. People turn up for those conversations. There was a conversation with businesses earlier this week, I think it was Monday. So I think there's something really important about the convening power of a government body to bring together stakeholders who have only one piece of the puzzle. We need all of those little pieces of the puzzle being brought together by someone with the credibility and the convening power of a government body.
Do you see it as a sort of independent statutory model or a task force of government, or what? Have you given any thought to that, or are you just thinking about a new body?
Yeah, I can't say I have the expertise as to what the pros and cons of those different models would be. I'd be happy to look at the different models and give an opinion, but I don't have... But the
purpose of the body that you're recommending is system change. You'd like to see these things coordinated to produce the changes that you're recommending, and so in a government sense, yeah.
Yeah, that's right.
Yeah, okay.
I think there are sort of further advantages of a body like that is being national, having some resources, being able to commit to national campaigns to raise awareness about what this is and what it looks like. That's really important as well. And I think some of the other issues that I know have come up in various submissions is just the inconsistency of data collection. So I think there are a number of projects that such a body could undertake that would really help us build the evidence base and coordinate some of those cross-sectoral, solving some of those cross-sectoral problems.
So what do you think? I mean, federally we've had Minister for Women for a long time, and so the departments and the people that work under that, is that you're thinking they're not getting enough cut through across the federal government, or they're not? What's your experience in dealing with that, with the existing...
So could you repeat
the Minister for Women and the departments that service the Minister for Women. What's your experience with them in terms of getting cut through or change? Have you had much direct dealing with them? Because we do have them in the federal government. There are bodies that are pursuing, the interests of women, have been for some time. I'm just interested, what are you experiencing with them?
I think there's interest, but I think there's there's a question mark about what role they can play and what they can do. We're still talking about an issue that is relatively new in terms of the evidence base, in terms of the focus that it's had. As I mentioned at the beginning, 5 years ago we were in a very different place in relation to financial and economic abuse. So I think people are, in my conversations, people, once you start talking with them about the issue and the scale of the issue and the impact of the issue, they're on board. They agree something needs to be done, but they're uncertain what that might be. And I think this body would really help bring all of that together.
There's so much to be done. I guess the other thing as well, we do know, based on the evidence we have, that there's a preponderance of women affected by financial abuse. Financial abuse is also happening to older people, and there it is less gender focused. So this is really about financial experience as well as the gender experience, and perhaps that's part of the complexity of whatever a body might need to deal with.
Yeah, I mean, one of the challenges I face, we're an organisation of 4 people. I know from the statistics that there are massive impacts on older women. I know that women with a disability experience financial abuse at much higher rates. I barely have capacity in a day to do all the work that I'm currently doing, the work that I want to do, that I know is important, the work to bring together not just, across government agencies and corporate agencies, but community sector agencies working in elder abuse, working in disability. We haven't developed the kinds of cross-community sector relationships that would really help us address the issue, be able to support each other and try and remove more of those roadblocks for people experiencing financial and economic abuse, where there might be intersecting concerns. They might be an older person, they might have a disability, there might be instruments such as powers of attorney at play. So I think there's work to be done in that sector as well.
Thank you.
Thank you.
Thanks, Chair. If there's a Deputy Chair, if there's time, I'll come back for more questions. Senator Pratt, 2 questions for you, and then I'm going to come to Mr Georgianis and Senator Scarr. Do you have questions too? Okay.
Thank you, Ms Glenn. I'm keen to ask about the development of financial products that can prevent abuse. I would note the last government spent a lot of money developing the in-due system in the cashless debit card and pretty much created a product inside government banking services. Meanwhile, and so that developed a certain stigma to it, and meanwhile, mainstream banking has been really devoid of the innovation around merchant blocking codes, and we've only just got as far as now being able to block gambling transactions with cooling off periods before you can reactivate them. I guess I'm keen to encourage innovation in banking products and to make them broadly accessible by Australians, whether it's for financial abuse or whether it's if you've got a decision-making disability, or whether you're in the position of being in a legal authority of someone else's finances, but you want to give them some autonomy over their finances as well. And so I'm keen to ask you how responsive you think banks are being to what the potential is in this space, and how we can put pressure on them and what we should be asking them for.
I agree there's enormous opportunity here for innovation. I'm really excited by the prospects of it, and I think there are a number of areas that we can really think about. Look at the technology that we have now. There are ways around the highly problematic problem of joint accounts, for instance. I think that's solvable. I've worked on a prototype myself in relation to how we might solve for a joint account that maintains financial independence for 2 individuals, but allows for that ease of, all the ease of that joint accounts can provide in terms of joint bill paying and so on.
Yeah.
I think there is
offsetting your mortgage or something like that. Yeah.
I think there is appetite from banks to do this, but some of the concerns that they've had about the regulations that might prevent them from doing that, that comes back to the national body, or, and we don't need to wait for a national body. I mean, the government could convene a round table of all of those players.
So a proposal like yours, are there regulatory barriers to achieving that kind of non-joint account system? So you've perhaps got visibility of each other's accounts so that you can both make contributions to a mortgage offset, but you can still retain and control your own funds. Were there legal or regulatory barriers?
No,
Okay.
for some of the mortgage stuff, for redesigns of mortgage, for addressing joint and several liability, for looking at post-separation from abuse mortgages to allow families to stay in their own homes. They're the kinds of things where there are some regulatory barriers that need solving, but there are other things that don't. There are other things we could be getting on with today that would, I think, reflect the reality of modern day relationships, which is that a lot of relationships don't last, marriages end. With or without abuse, it can be really difficult to disentangle some of those products, and I think we can think differently about them. And I'd love to see banks take up that challenge.
If you're able to cite the numbers of any of those regs, if they're not already in your submission, just on taking that on notice, that would be terrific. Thank you.
Yep.
Thank you, Chair.
Thank you. Mr Georgianis.
Thank you, Chair, and thank you for appearing before us today, Ms Glenn. Just a couple of things. In terms of some of the recommendation of establishing a new national body to coordinate and drive action, are you aware of any work that's being done? And earlier you mentioned about the complexities of cross-government. Are you aware of any work in this direction by different agencies, governments, state jurisdictions, etc., and some of those complexities that would exist if it was put forward?
I'm not. There have been models that have looked at things like the domestic violence intervention orders and ensuring that they can apply across state boundaries. So there are examples where state and territory governments and federal government have worked together on trying to remove some of those barriers to improve safety for women. In terms of cross-government things, there may be activity and conversations happening behind closed doors that I'm not privy to, but I'm not aware of any sort of program of work to address these problems.
In terms of legislation across the states, and some of the financial institutions have been saying this as well, it is extremely difficult to operate in separate jurisdictions. How important is to have conformity across the nation, and would this body be part of that sort of conforming the laws across the nation instead of different jurisdictions, and then you find financial institutions or others who are trying to implement good things are hitting roadblocks?
I think it's a really good question. I know there is significant desire in the domestic and family violence sector for consistency of definitions and laws about domestic and family violence, coercive control and financial and economic abuse. That would be very helpful if they were consistent across the country. So, sorry, what was the other part of your question?
Before we jump off that, can I just indicate, at many of these hearings I've heard about the productivity benefit of having the similarity across the area, but it can also be a prevention for change. And right now in New South Wales, we have seen a first mover action, in fact, in terms of legislation around coercive control, right? So consistently failing is not helpful, because we probably need some innovation in this space. So if you could take on notice on the back of Mr Georgianis' really good question there, what is your view about the New South Wales legislation around coercive control? If you can reach into your networks and get some feedback for us about whether that is a good model, or you have concerns about what they've been able to do as a sort of a first mover in the space. Thank you. Back to you, Mr Georgianis.
The one comment I was just going to make on that is that as coercive control, yes, it's coming into effect in New South Wales next week. I think we'll see more legislation like that across the country. I think what we haven't contemplated enough yet, and I know some banks are already thinking about this, is now that this is at the criminal level in statute, what implications does that have for financial institutions in terms of potentially providing evidence? So I think, again, a national body that can help convene, develop some standards around that. You know, we're making this up as we go along. You know, we haven't had these laws before. We're not sure what the impact will be. We know already that there could be, you know, interactions between coercive control laws and privacy laws and other laws. So I think there is a rich territory for more research and coordination there.
And my very last question is, you spoke about banks having the ability to, or not the ability, but what they should be aiming for is to look at the intricate details when it comes to financial abuse, whether it be mortgages or separating financial assets, etc., and how that affects or the effects that it's had through financial abuse on a particular person. How would that work? What would they, through codes or banking codes, or how would you implement something?
Like a new type of mortgage?
So, no, you spoke earlier about the banks should play a role in terms of the mortgages, for example. One example where one partner, there's a separation, and even though the partner wants to take on the mortgage, can't because the bank is not allowing them to, because there's other intricate little details that perhaps they're unaware of. There could be court cases pending, etc. How would that operate through the bank in terms of getting all that information, saying it through a new banking code, where you would ask the banks in that code to basically sit down like a mediator, I suppose, is the concept I got from you, from what you were saying earlier.
Yeah. So I think there are a number of things that need to happen. One is some of those regulatory barriers around responsible lending. I think we need a carve out specifically for this instance, where someone has their housing is at risk and they already have a repayment history, a positive repayment history. So there are regulations that might prevent them from being given a new mortgage without the perpetrator on it. There are internal bank risk management processes that might prevent that as well. So I think that's where the regulators and the banks need to come together to say what's the safe way, while upholding responsible lending rules, to ensure that we are not tipping women and their children into private rental that is as expensive as the mortgage that they were already paying. So there may be other requirements around, you know, APRA sort of capital requirements that need to be considered as well. I'm not a legal expert in those things. These are some of the barriers that I have been told exist to innovation in this space, and I want to see those barriers removed. If the national body is the way to do it, fantastic. If there is a round table in 2 months from now, fantastic. I'm open to any different routes to get there. What I just want to see is those barriers removed for victim survivors.
Thank you very much. Thank you, Chair.
Thank you. Ms Glenn, are you aware of any products that anticipate a relationship breakdown, that give indications as people purchase a mortgage or engage a mortgage, that show them what would happen?
No, I would love to see that. I think that for too long, joint and severally liable has been the only way a product like that has existed, or, you know, joint tenants or tenants in common. There is no other opportunity to have a mortgage with another person. So I think that is something that's really worth looking at. There is one, and there may well be others, there is one product that I think AMP has where you can have separate individual accounts. So a couple may both have an individual account, both of which can be used as offset accounts for the joint mortgage. So that's a kind of a baby step in a direction that sort of recognises two individuals who have this joint and shared interest.
But the ownership of those accounts rests with the individuals.
That's right.
Applied to a single loan, which provides security for each of them, should the demise of the relationship occur.
That's right.
Okay, thank you very much, Ms Glenn. Over to you, Senator Scarr.
Thank you very much, Ms Glenn, and thank you for all the wonderful work you're doing, which is clearly evident in the submission. There's one topic we haven't covered to date, which I thought I might ask you some questions about, and that is the implications of our family law system in relation to particularly women who are in vulnerable positions. And there are two helpful case studies which are provided in the submission. Firstly, on page 16, and I'll just read some of this to provide some context for Hansard record. Once he moved out, he refused to pay anything towards the mortgage, so I sought a quick financial separation. My lawyer at the time said that shouldn't take any longer than 6 months, that it should be an easy financial separation as the equity in the business and the home were nearly equivalent. But my ex dragged settlement out for 3 years. Initially, I sought a hardship arrangement from the bank, but as things dragged on, they needed their payments, end quote. And then on the next page, Lily's experience, and I quote, I should have been able to buy a new property with the proceeds of the property sales, but he dragged out family law proceedings, costing me money and all these unnecessary things. So pretty much all that money went on lawyers. The private rent I pay is more than what we were paying on that mortgage, end quote. So and I'm sure other members of this committee have had circumstances where they've been approached by constituents who going through family law proceedings. There's one case immediately comes to my mind, which your submission triggered, where a constituent simply had a home and super. Those were the only issues in assets in dispute in terms of the separate property settlement. And in her case, it was going years and years and years. And in fact, she'd been waiting 12 months for a judgment from a judge and was too scared to contact the registry because she thought that might prejudice the decision. And in the meantime, the assets are just being denuded. I carefully considered the recommendations which you made. I couldn't necessarily see one which specifically engaged with that issue of potential abuse of family law proceedings leading to a diminution in assets and therefore undermining the financial security of someone who's in an abusive relationship for perhaps the rest of their lives, especially in the existing property market. So I'm interested in any comments you have in that regard as to how we might be able to, and feel free to take it on notice, tweak the family law system so perhaps the judges, the registrars are aware of this issue and the urgent need for property settlements in particular cases.
Thank you so much for your question. Family law is quite frankly, it's a national disgrace. The pain that it's causing so many women and children with those delays, often facilitating perpetrators who are and have expressly said that that is what they are doing, that I will drag you through the courts, I will cost you everything, you will end up with nothing. That is their express intent. The court facilitates them to do that. And I can't tell you the number of women who have been dragged through that. And the other thing I would say about it is so many of the women on the lived experience panel and women I talk to, have been citizens engaged in, doing quote unquote the right thing, and believed that when the relationship broke down or they tried to leave an abusive partner, that turning to instruments of government and the law, that justice would prevail when they got to, the independent umpire. And I think it's the thing that people who are not seeing it every day are so shocked by, the unjust outcomes and the, orders that are not upheld by the court or anyone. The only way if an order is not upheld is for the victim survivor to pay more money that they don't have to try and ask for that order to be upheld. So we have made a number of recommendations in response to the Attorney-General's exposure draft Family Law Bill number 2. And I know that's kind of in train now, so I'm not quite sure where things are at. But we certainly strongly support the introduction of recognition of financial abuse in family law property settlement proceedings. Shocking that it's not already, but the Attorney-General's Department is looking at changing that, and there are a number of other recommendations we've made that we think would strengthen that bill. And I would be hopeful that if all of those recommendations were adopted in that separate submission, we would see less of the kind of long-term financial devastation that that court is unfortunately enabling.
Yep. If I could just for convenience, if you could maybe on notice just provide us a copy of your submission to that process. I also sit wearing another hat on the Legal and Constitutional Affairs Committee, so I'd be very interested to see that submission, because I think this is it's a major issue in our system. Thank you, Chair.
Thank you very much. Just drawing attention to your submission on page 13 and 14 are two case studies. One involves what people might think is a sort of a low risk engagement, a buy now, pay later. An account opened without knowledge. The line of credit application done in the person's name. Perpetrator used the funds to purchase a laptop computer. The malicious intent of these individuals is pretty clear in the example. And the second one that you've got here, I think, is important for this committee because it refers to ASIC. And that is an entity that we oversee. And in this instance, if I can just read it in, a bypassing of a two-factor authentication. A woman made a company director without her knowledge by her ex-partner, which puts her at considerable risk before the law for not fulfilling responsibilities. Received a call from ASIC confirming there's a two-factor authentication process which he managed to bypass. She was ordered to give him codes without him telling her it was nothing to worry about. He managed to bypass the online security checks for ASIC and banking systems. This is a really, I think, telling example of the completely invasive way in which perpetrators of financial abuse take over the lives of the person that they are abusing. Whether it involves ASIC or something that might have slightly lower standards of privacy security checks, like buy now, pay later products, clearly people of malice are going to find a way to do bad things. Is it realistic for us to think that we can actually create a climate in which financial abuse can be turned back, reduced, minimised, or are we chasing a fantasy here?
I think it's unrealistic to think that we can stop it. I think it is realistic to see it become reduced. I think it is realistic to say currently it's not good enough. We know that perpetrators are like, they're like weeds. They'll find whatever crack and opportunity they can. However, what we don't have and what we can have is more hurdles for them to overcome to do that. Every hurdle they have to overcome to continue to abuse provides a point of evidence. If we come back to sort of laws around coercive control that are criminalising this type of behaviour, those points of evidence will become really important. So I think that the most malicious perpetrators will always find a way. But there are many interventions that we can put in place, points of friction, which will also provide points of evidence. And I think that's a worthwhile endeavour.
And we'll have questions for the banks about their observation of data, and because they see a lot of data, and whether there are predictive behaviours that they can get algorithmic functions to pick up and interrupt the behaviour early. We've run out of time to get probably a fulsome answer to this. You've noted in your recommendations matters for individual financial institutions, finance sectors, regulators, the federal government and the state and territory governments to give some shape to the complexity of it. But you also indicated that there is some international perhaps enlightenment that we can get from the US. Have you got any further information that you could provide us on that?
On what, sorry?
On the US models?
Sorry, I'm not... Oh, the innocent spouse relief?
Yes.
This is where result of a perpetrator's actions, a tax debt is created in a victim survivor's name often small businesses are implicated in that. And at the moment, the way tax law exists is that they are bound by law to chase that debt, even when they know that it is a debt that was not created by the person in whose name it is. So the US has got this innocent spouse relief, which provides the IRS, the ATO equivalent in the US, with discretion to not chase that debt. The UNSW Tax Clinic has done some significant work on what that might look like in the Australian context, and we support that work.
Have we got a sup on that from them? Okay. So the committee might seek a submission from the University of New South Wales entity. And can I indicate that these are questions we obviously should be putting to the ATO, so we'll just put that out there in public that there will be some questions coming about that. Thank you. Can I thank you very much, Ms Glenn, for the work that you do, for the quality and depth of the submission and the way you've captured the reality of people who are experiencing financial abuse. It's very helpful for the committee. We may have further questions on notice and seek your assistance.
Very happy to take further questions at any point.
Thank you very much.
Thank you.
I now welcome our second set of witnesses from the Australian National Research Organisation for Women's Safety, ANROS. Could I invite you to state your name and the capacity in which you appear? We'll start with you, Dr. Tessa Boyd-Kane.
Thank you very much, Chair, and good morning, everyone. My name is Dr. Tessa Boyd-Kane. I'm the CEO of Australia's National Research Organisation for Women's Safety, and I'm joined here by my colleague, Dr. Rebecca Goodborn, who is our Senior Project Officer. We're actually in the same room, even though on different screens, so she'll stay on mute, but we're both able to talk to you in this opportunity.
Thank you very much. And your name and the capacity in which you appear, Ms. Goodborn.
Yes, I am Dr. Rebecca Goodborn, and I'm appearing with Tessa this morning as a Senior Project Officer from ANROS.
Thank you very much. Now, I invite you to make a short opening statement, and I'm sure the committee will follow with questions. Thank you.
Thank you very much. So as many of you are aware, we've appeared before you previously. ANROS is Australia's National Research Organisation for Women's Safety, and as a formal partner to the National Plan to End Violence Against Women and Children, we've been building the evidence base about how to improve women's and children's safety for over a decade. So really what we wanted to do was make sure you have at your disposal the evidence that connects the experience, particularly of family and intimate partner violence, with the impact of financial abuse, and so that you've got the evidence for those considerations in the context of your inquiry. One of the pieces of evidence that ANROS produces is the National Community Attitudes Survey, and that evidence has helped us understand that on the whole, people in Australia understand the experience of family violence and also of sexual violence. But in fact, we know that there are parts of that experience that are really poorly understood. So for instance, people often assume that family violence is physical violence and are not aware of all of the non-physical and sometimes less serious but really compounding factors: emotional abuse, coercive control. And financial abuse is a really clear example of that. So we know that our understanding as a country of the impact of financial abuse really lags behind the broader awareness about the impact of family violence. So we wanted to draw to your attention that clarity in the evidence about the experience of family violence, including those non-financial forms of abuse. The impact of financial abuse in that context is really serious. It can occur as part of a pattern of abuse and control during a relationship while someone is experiencing family violence. It can trap people into those violent relationships. It can limit their financial independence and security as a mechanism that would allow them to make choices about how they might see that violence ending. And we also know that financial abuse can continue after separation. So we see from the evidence lifelong effects on relationships, and that includes intergenerational impacts on children in those relationships, as well as on the impacts of people needing security for housing, adequacy of employment, all of those really core financial security components that enable people to live safely, and women and children particularly, in the context of family violence. We've also seen evidence that really points to the impact of gender norms in a context where we're talking about gender-based violence to begin with. So assumptions, for instance, that money business is a man's prerogative, meaning that, and you've heard already evidence about the impacts of sexually transmitted debt as part of those pathways that trap women into financially abusive relationships. We wanted to really just highlight where we see the opportunities for financial services to play a role in tackling this problem. And I guess to start by acknowledging that financial services and institutions are already leading down this path. So we've seen work from banks and other financial institutions about how they can start tackling the use of their products for abusive purposes. And I know you're hearing later in today's proceedings more about some of the work to, particularly through Catherine Fitzpatrick's work, to really see industry-wide leadership in that context. We see an opportunity to make sure that in addition to ensuring that financial products aren't used for abusive purposes, that we also make sure that systems, policies and procedures right across the industry have that safety principle right at their heart. And so, you know, the evidence coming in other areas, for instance, technology around safety by design, as something that's really important to pick up in the ways that financial services and institutions are designing their processes and procedures, so that we're not just addressing uses and abusive behaviours after the fact, we're putting in place the systems that can really protect people and keep them safe. We also wanted to flag some of the areas that we think are well worth considering in the context of the inquiry's interest in the regulatory framework. And that really goes to the importance of ensuring responsibility and accountability right across the industry. So while, as I say, financial services are looking at the products that they control, they might not be looking at the mechanisms of the platforms that they're potentially outsourcing or that they're purchasing from other providers, even though those platforms may themselves become the basis of further financial abuse. And so we see as we see technology as the new frontier in terms of how women and children are experiencing abuse, so too we need to make sure that the technological changes and the rapid innovation that occurs in the industry incorporates that really clear accountability for system design and for platforms that are fit not just for the business purposes but for the social purposes and for keeping women and children safe in the context that we're talking about today. So, Chair, that probably gives you a broad overview of the key points that we wanted to raise for the inquiry. I mean, I guess just the only other thing to reflect that you're hearing from a lot of witnesses today who can speak much more directly to the impacts in people's lives. What we were interested in hearing was whether there are any evidence gaps that you're looking to fill that we might be able to advise you about and support in terms of where there might be other evidence to support the inquiry's proceedings.
Well, thank you very much for your offer of knowledge sharing with us as we undertake this considerable task. We only have you until 10:30, so I'm going to go straight to questions, and I might go to Senator Scarr to kick off this time if you have any.
No, I think I'm okay, Chair. I thought
The submission's pretty
submission
solid.
was very good. Thank you.
Thank you. Ms Mascarenhas?
So one of the things you talked about was tech platforms facilitating abuse, and I think the thing that we've seen is, like in the past, when we had more face-to-face transactions, that there was an ability to pick up on, I'd say, red flags. Are you seeing tech platforms actually, in the first instance, identifying the red flags, but having appropriate processes to try and identify and stop financial abuse?
Thank you. Let me start and then I'll throw to my colleague if she has anything to add. We've been running a program actually looking at sexual harassment, but one of the most recent reports from us there has looked at technology-facilitated sexual harassment. And so what I want to draw on here are some of the broader findings that we're seeing about the impact of technology and platforms. So we're seeing a couple of things. We're seeing the way technology is so integrated into the delivery of services now that it is absolutely core as a platform. And so any kind of messaging in any platform that allows, it might be a chat function that allows someone to seek help. It might be a communication function as part of a financial services product. But we're seeing that those platforms are themselves the basis for abusive behaviour, abusive messages, as we've certainly heard in terms of the way banks banks have seen some of those shared joint accounts and the sort of technology facilitating abuse through them. But the other thing that our evidence is showing is that much as technology is really core now to the delivery of business and services and to the workplace, our cultures of management and leadership haven't necessarily kept pace in terms of what kinds of policies and cultures are required around the use of those platforms. So we don't see employers, for example, understanding the full extent of technology platforms in terms of the risks that are now part of how we keep workforce safe, recognising that if we're talking about major employers, we're not only talking about customers, we're talking about staff who might be experiencing financial abuse or family violence themselves. We might also be talking about perpetrators within workforces. So we're talking about a whole lot of interacting factors where technology as a platform can be driving some of that abusive behaviour, and we need to see accountability both for the way those platforms are used and for the cultures and policies and procedures around them that really keeps pace with that rapidly changing environment.
I'm sure if Ms Goodburn would like to add to that.
No, I think Tess has really captured it very well, but just to underscore that point again about the whole of system accountability and responsibility, because you have platform software, particular elements being designed by one business and then being implemented and used by other businesses and organisations. And so, as Rebecca Glenn pointed out, you sometimes have a lot of actors who say that responsibility is outside of my remit. The way that this is being used is not actually my business. And so having that accountability shared and understanding clear lines of responsibility across the whole system is very important, particularly with technology.
I'd like to pick up on one of your recommendations, which was around recommendation, I think 5, which is around safety planning for women trying to leave violent relationships and looking beyond, I guess, the physical strategies of making sure someone's physically safe, but also incorporating financial safety strategies. I'm wondering if you've seen good examples of this happening in maybe specific states or specific organisations, and maybe the impact of not having those strategies in place.
I can certainly speak to the impact of not having those strategies in place, and perhaps we could take on notice what evidence we've got within our own knowledge, recognising some of your witnesses appearing later might also have good answers to that question. I mean, the impact we see is really clearly that, you know, it's been framed as an impossible choice, that you can't escape the violence if you're seeking to leave a relationship if you don't have the financial independence and security to do that. And so the extent to which joint accounts or joint responsibility for accounts might limit people's access to finances is a very real barrier to some of the choices they might want to make. Now, we also recognise, of course, that evidence is really clear that not everyone wants to leave a relationship when they're experiencing abuse and violence. They want the abuse and violence to end. So it's not always about pathways physically out of a home or a relationship, but the very clear connection between financial independence, financial security, and the resources that people have to ensure their own safety and to seek help when they're not. That evidence is really clear. And so the absence of that financial independence, the absence of that financial security is a very real barrier to people being able to, address their own safety concerns in the case of women, and to being able to look after children in their own right when we're thinking about the impact that that family violence has on children.
And that probably relates to one of the points that you highlighted, which was around the intersect of women's workforce participation and women's economic security. So with the research that you guys have done, do you generally see when women are participating in the workforce that they have a better financial plan for escaping family and domestic violence?
I'm not sure that that's specific link. We would maybe have to take that on notice and do some more investigating, but I'm not sure that that specific link has been drawn out, because it's very complex in this area to look at correlations between different aspects of somebody's experience and things that might actually, I guess, cause or be factors in helping somebody out. I also did want to flag or underscore again, the idea of safety planning is one part of the broader picture, and like financial literacy, it's an important part, but it won't be the answer, because there are structural and systemic issues here that are much more fundamental to addressing financial abuse and women's economic security more broadly. But yes.
So it won't be the only answer.
Yes, exactly.
Is what we see from the evidence. And so to your question about if I could break it down to your question about if you're employed, do you have a better plan? I think what we see is, violence doesn't discriminate, financial abuse doesn't discriminate. We see it affecting people at all levels of the income spectrum, from higher income earners through to people who are relying on income support payments. And then obviously we recognise the really significant role and in some cases burden of care that falls on women. And so the choice to work is itself a kind of very complex set of factors in terms of how people are able to secure their own financial means. And so that all needs to be part of the thinking if we're making sure that women have the financial resources that they need and the financial independence that allows them to plan for whatever is the course that is going to keep them safe, but then particularly to name and address financial abuse when that's part of a broader context of abuse. I think that's the other thing that we wanted to flag, is just recognising that financial abuse can be recognised and identified in its own right, but usually it's part of a much broader range of factors that are taking place in the context of domestic and family violence. So it might be part of controlling behaviour, it might be part of emotional and other abuse, so it might be part of a whole raft of non-physical forms of abuse. It's not necessarily experienced in isolation in a way that allows us to control it in isolation and assume that that has itself addressed the underlying experience of domestic and family violence.
Yeah. Thank you. If there's time, I'll come back for more questions. Senator Pratt.
Thank you. I wanted to drill down into your recommendations regarding the social security system, including, I guess, the refusal to report income shared data. Clearly, the ATO can now do, I think it's evolving that there'll be better data matching. What could Centrelink be doing to investigate whether there is coercion or abuse happening rather than fraud, and better manage that? What are there telltale signs, but they won't necessarily just see that in the cross-data matching. So how can we find ways of making inquiries with families in a way that supports the victims?
Thank you, Senator. We might take that on notice. It's a really excellent question. I don't know that our evidence has looked to that next stage. I think we've been able to identify where that gap is, but we'd like to just take some time to confer with colleagues about whether we've got evidence about what's been tested through in terms of what a good response might look like from the ATO.
And in that context, if you think there are ways we should frame questions to the ATO or the Department of Social Security and Department of Human Services, so we can get to the bottom of how to explore that would be helpful also.
Thank you. If we broaden it out, I was focusing particularly on the ATO part. If we broaden it out to think about the service system broadly, certainly there is really clear evidence about how we think about risk, and that risk takes many forms in the context of family and sexual violence. And so if we have a system that is focusing very narrowly on one type of risk, for example, in your question, the risk of fraud, it's not necessarily ensuring that system is well designed to address that other range of risks, such as being used as part of an abusive pattern of behaviour. So I think the evidence would point...
So a gender lens on developing something around fraud could help with that.
Both, yeah, a gender lens, and it goes back to that earlier point about the safety by design principles, that we need to make sure that we're not thinking about those in a narrow context only about products and sort of the tail end of a system, but we're absolutely thinking about those as core in the design of systems and the policies and procedures that sit within them, the cultures and behaviours that are enacted within them, that all of those are areas where we can do better and where we can see unintended consequences.
Yeah, so if you can take on notice posing some questions as well as any of your own insights, that would be terrific. Thank you. Thank you, Chair.
Could I also just, add there?
Yes,
I think
Dr. Goodborn.
one of the recommendations that you're referring to came out of some research from a few years ago. And I think it had a broadly applicable message there, which was that there were actually existing mechanisms within Centrelink provisions to be putting a gendered or domestic and family violence lens on assessing cases, but they weren't being used. And so we do see in a lot of our research time and time again that there are pathways and avenues that exist, but we haven't skilled people up to be able to use them. We haven't actually embedded, I think what we refer to sometimes as an authorising environment for people to actually be able to use the things that are there and the tools that are there that would be effective and could be being used.
Thank you.
Thank you, Senator Pratt. And I just noticed there's quite a few members of the public have joined us this morning. And just so that you know what's going on here, this is an inquiry of the committee that's called the Corporations and Financial Services Committee. We've got members of the House and the Senate here, and we're inquiring into financial abuse. And we have some witnesses before us. I'm going now to Mr. Georgianis.
And I should say, Chair, we have an outstanding chair in Senator O'Neill.
Thank you very much. Mr. Georgianis.
Thank you, Chair, and thank you for appearing before us today through video link. I've just been going through some of your recommendations, and they're very good recommendations, some great things in here. And just to satisfy my own understanding, in recommendation 8, you talk about specialist advice and assistance for women leaving violent relationships to secure property and funds. Obviously, on top of that, there's another recommendation talking about how we can improve child support systems and employment to prevent that financial loss that takes place. And it brings me back to the thought of if you find yourself without a job, usually you've just been retrenched or you've lost your job. There's perhaps holiday pay, sick leave, leave accrued, a whole range of things to keep you going. But when you're leaving a violent relationship and there's been financial abuse, in most cases it's $0. When you do actually make that move, and one of the first steps would be if you have no income, you'd be going to Centrelink. Does Centrelink identify or specifically have steps in place for people in those situations? And of course, financial would be the first step to try and assist that person. And the second step would be in terms of employment, if they needed to be employed to keep their financial self going. That you're usually referred onto an employment agency from that point. Do these factors are taken into account by Centrelink? Are they identified? Are they rigorously looked at to be able to find all the different avenues to assist that person who is in a very different situation from someone else that turns up to Centrelink wanting to enrol onto New Start? So a fairly complex sort of question, but it would give us a good broad overview, because that is at the coalface of the emergency period.
Thank you. And the complexity of the question reflects the complexity of the system that women find themselves in when they're trying to make these decisions. The thing that I was just conferring on with my colleague is that there is a new emergency payment that has been sort of set up and led under Commissioner Cronin as the Domestic Family and Sexual Violence Commissioner. So there clearly have been gaps in that system and efforts now to address that. We don't have the latest evidence about how that's working, but I know there's been a lot of attention undertaken by the department and others to ensure that that's available. They're also, I think the short answer to your question is often that immediate support is available by the social service system, but not necessarily by the social security system. So people can turn to social services for emergency relief payments. They can seek emergency accommodation, much of which we know is in acute shortage and crisis. We know that employment services are connected into that broader ecosystem in terms of understanding the impacts of family violence, but the availability and appropriateness of jobs is all part of that system that people turn to. So your specific question about to what extent Centrelink identifies that, we know that's part of the work that they do, but the availability and the immediacy of those responses, I think, is where there's long time been evidence of gaps.
Thank you. Thanks.
Thank you. Ms Mascarenhas.
Thank you, Chair. I understand that you did some research in relation to COVID-19 and the relationships, like intimate relationships, economic security. What I'd like to understand is that I'm going to describe as a pressure cooker environment for seeing things come up that don't normally. But what do you see as the lessons learnt that we can apply going forward to try and prevent financial abuse?
Would you like me to? I think one of the major lessons that we learned was that the relationship between financial stress and intimate partner violence is incredibly complex, because we did see some evidence of violence increasing, the severity and frequency of violence increasing, but it often changed in relationship to who was employed at the time, who wasn't employed at the time. Were they going into COVID-19 with financial stress? Did the financial stress happen during COVID-19? And we saw lots of different fluctuating factors. And so I think what we learned from that is that you have to look at both chronic and acute financial stresses and where they come into play, and also both parties in a relationship or a whole family together. What is the financial situation of everyone individually as well as together? There were some overall general messages around, pressure cooker environments, I think, as you referred to it. But one of the big lessons was there weren't any easy, correlations that we could draw, and we do need to dig down a little bit further into looking at all those different factors.
If I may, I also know that we have housing shortages at the moment, and I'm wondering if you've got some observations on domestic violence and financial abuse in context of what's happening at the moment.
Yeah, thank you for the question. I mean, there's no question the relationship between housing security and pathways to be safe and to get to safety if you're experiencing violence, that pathway is really clear. So we know that kind of adequacy of housing, adequacy of income are really core foundations to financial security, which is itself a really critical element of a woman's ability to keep herself safe. And in the vast majority of cases, we're talking about women, particularly in this context of domestic and family violence. So absolutely, the evidence is really clear about that nexus. Can I just pick up the other lesson that I think we're probably still learning about from the pandemic was what was the financial security for women who needed to draw on their super through that period. And so the impact of drawing down on superannuation very clearly gendered. The opportunity, the need, the impact that has had then on women's economic security going forward. I think that's what I mean about we'll see how that plays out in terms of those decisions made during the pandemic, but there were no question there were gender dynamics to who was needing to draw on super when that was made available as a way of ensuring financial security through the pandemic.
Can I just ask, what did the data show? You've said you found the data. What did the data show in terms of a gender display between men and women accessing super at that period of time?
Yeah, thank you, Senator. I don't have the actual numbers. Happy to provide that in follow-up, but that women were more likely to draw on their super or to be disadvantaged by the impacts of that in terms of the accumulation of superannuation over time. So that the gendered impacts of that policy are what we might continue to see over time, not just at the point of drawing on super through the pandemic.
So we know that women generally have far less in their super than men, particularly in those childbearing years, and there's been corrective policies embedded in the government's changes to support for women during that period of time. Do we have any data that shows the nature of coercive behaviours of men keeping their superannuation untouched while making their partner raid their superannuation? And I think it was up to $20,000 was quite a common extraction.
We've never seen that data, Senator. We haven't seen if that data exists.
Okay, thank you. Any other questions from colleagues? I've got a few. Oh, yeah, Senator Scarr, go for it. Yep.
Do you have all the support you need to conduct the research which should be done, or should more resources be mobilised to actually understand the depth of the problem and to delve into particular examples of the problem and how that can be mitigated? Because reading the submissions, some of the situations are incredibly complicated. So they include potentially women who've come to this country from overseas, have particular vulnerabilities because they have the added pressure of migration status, immigration status, which can be used against them. There are particular issues in some multicultural communities, which I would have thought require particular analysis. Are we doing all the research we need to be doing to fully understand the scope of the problem and therefore to develop recommendations to address the problem?
Thank you, Senator. The first thing to think about, what else do we need to know? We have very little longitudinal data. So what we've got is often short-term and very focused pieces of research that don't necessarily help us understand how this is experienced in the broad. So we absolutely have gaps around that longitudinal analysis piece. The other thing that I think your question sort of invites is the question about how do we know what works? And we see huge gaps in terms of reliable evidence around evaluation. A lot of evaluation data that isn't made publicly available or isn't shared to really drive knowledge about what works. So recognising differences in context, differences in the sort of impacts of abuse are going to shape what works. We would absolutely be encouraging more evidence and more research enabling that sort of evaluation and monitoring part of the picture. And then I think the really core question about service responsiveness and early intervention. And so how do we design and deliver services that can make the best difference to someone at a point in time where we can really reduce the impacts that the service data is really lacking there as well.
And just flowing on from that, are there other jurisdictions, overseas jurisdictions, which are ahead of us in terms of dealing with these issues, or are we all across the developed world trying to catch up at the same time with these issues?
I'd say it's a bit of both, Senator. So certainly in the context of our work as the National Research Organisation for Women's Safety, there isn't another organisation like ours internationally. So the kind of national plan focus on building the evidence base is unique in Australia. But I think your question goes to who else is leading around financial abuse and the connection between that and family violence and the service responses. And I don't think we have that evidence to know who else might be leading, but again, happy to take that on notice and see what else we can provide you.
Thank you. Thank you, Chair.
Thank you very much. I just note this morning I was reading from the Australian Financial Review a bit of an outline of criminal justice data that is now going to fold 24 different policing, court and prison systems to show how people move and interact within the justice system. That has been designed to track prisoners who are released. So we're really talking at the point where we've got high level of risk, real-time information, national data sharing, showing the immediate impacts. That justice system model is about to go live, I think, in September, and it's reporting to National Cabinet about the digital nature of information that exists and trying to put things together. Given the broad concerns in the community about violence and abuse in all its forms, have you had any interactions with ASIC, for example, the Australian Securities Investment Commission, who really have a look at financial products. Have you provided any insight to them about the financial product creation and their role in the financial sector?
Thank you, Senator. I should acknowledge I'm relatively new in this role, so I would need to check that. I'm not aware that we have, but I also think our expertise isn't necessarily clear on the sort of design and the delivery of the products. It's more in that sort of broader system impact. But no, I'm not aware that we have.
Have you had any interactions with any of the major banks about their observation and response to this, and what have you found?
Look, we've absolutely, yes, we have worked with some of the major banks, and we're interested in working with more of them, and we've seen that real willingness and interest to address the way products are being used. And then, and I think this aligns with some of the sort of technology platform facilitated abuse, need for direction, need for guidance about what works, about what else is needed. And so we're at the start of that work in terms of both the products, how you ensure that products aren't being used by abusers, but also being able to point to where the evidence talks to those broader system implications, even within one institution.
Okay, so are you dealing with individual institutions on their development, or have you got any interaction with the Australian Banking Association, the ABA?
At the moment, it's individual.
Okay. So it's a good sign that the banks are actually reaching out to try and get data and insights from you with regard to this. And, they have certainly made submissions to this inquiry, and we'll be hearing some more evidence from them next week. I guess, again, in light of the comments following Mr Georgianas's comments, we can have variation, which gives us insights in a different range of experiences, or we can have uniformity, and there's a trade-off either way. We either all get it wrong at the same time, or we all get it right at the same time if we make it a national forum. But do you think it's appropriate that banks at the moment try out unique responses to the challenges for a period of time for us to test what might be working in the real world rather than uniformity?
That's a great question, Senator. I think where we are most well placed to think about the impact of that question is to think about what do we learn from what's been trialled. So there's a lot of good evaluation data that says this doesn't work. We need to learn that as much as we need to learn what does work. And so if we're talking about a rapidly evolving space where people are trying new approaches, the most important thing from our perspective in the context of building the evidence base is that the lessons of those trials are shared. And so if that means across jurisdictions, if it means across institutions, if it means across industries, if we take the tech piece again, there is significant learning that could really support a much stronger response at a systems level if we were able to tap some of that learning. So I think that would be where our focus would be, is to encourage, not necessarily to make a call about there's one system that's going to address all of the complexity that we're looking at, but whatever is being attempted is that the lessons of that work is being shared.
So perhaps there's a very significant role right now at this period of innovation for the Australian Banking Association to actually facilitate shared learnings, because these are going to come at some cost to each of the banks to implement these changes. Can I go to the often used shorthand of red tape? Any change that happens in a system is often described as red tape. Sometimes it is things that slow things down. Sometimes it's a necessary response to a tragic minority of people who are operating. So we always have to be mindful of not imposing on businesses burdens that limit productivity. At the same time, we're absolutely determined, I think, as a community across the nation to make sure that people who need protection from financial abuse get it. So do you have any insights into what an appropriate balance of those things look like, and how mindful are you in your recommendations about not creating expectations and a burden of red tape to fix the minority position while at the cost of the majority? how much does that factor into your thinking?
Thanks, Senator. Let me start and then again throw to my colleague if she has anything to answer. I think this for us really goes back to that really key role of regulation in ensuring responsibility and accountability, and making sure that we're not narrowing our focus so much on a specific identified risk that we're creating other problems potentially unintended. And so that point that Dr. Woodburn sort of spoke to in terms of the development of technology by one company that is then used by another, and no one actually shares responsibility for what that might enable, that for us is a really clear example of where we need to do better. We need to make sure that that accountability is shared, and that those principles around safety are really core in the use of technology, in the policies, the processes that industries are using. And so the role of regulation there we see as really key, not necessarily on specific individual products or individual approaches, but making sure that those kinds of principles are upheld.
And Ms Glenn, our first witness, gave some evidence about voluntary versus mandatory codes. Do you have any thoughts about that?
I think...
Dr Goodborn.
Thank you. As we've already flagged, I think one of the key things with a move from to any mandatory requirements is thinking about the potential unintended consequences of doing so. Who is going to be affected, who is going to be impacted, and in what ways? Because we do see in systems where there are particular people who will already be disadvantaged, that might exacerbate particular disadvantages or marginalisation. So we have to have a very keen eye to that whenever we're going to introduce anything mandatory, I would say.
If you have any further thoughts on that, like we're talking in great generalities here, and you know, like I think we're all aware of the general problem. Like the thing is, this committee has to make some very solid, careful recommendations. So if you want to think about that and give us some more specific responses, that would be helpful for us, I think.
Thank you, Senator.
Could I just ask you about the intersection between gender pay disparity and the perpetuation of financial abuse? What is it that can be done to further reduce the economic dependence of survivors on perpetrators? And feel free to take these on notice if you want to.
Yeah, that is a big question. Yeah, we'd be delighted to take that on notice and provide further evidence.
A couple more if I can. This year's budget, in this year's budget, the government announced a up to $5,000 in financial support as part of the Leaving Violence program. What impact do you believe this policy will have?
Well, certainly there is evidence about that lack of financial resource as a barrier to women making choices, whether that's to leave a relationship or just to find a secure place to stay while they're thinking through their options. There's also evidence about barriers to the kinds of help that can make a real difference. So, for instance, legal assistance. And so the immediacy of a payment that is available to support those needs is a very real, that need is very real. We would hope that that payment is able to be used in that way. And then obviously there's all of the associated costs of living if someone is no longer in the home or is no longer having access to the finances that they had. So there's a whole range of immediate needs that we would hope that payment is able to go towards.
If I can just go to your comments about acute and chronic abuse. Sadly, there have been some reports that an example of acute abuse is an increase of a 40% jump in domestic violence that typically occurs in New South Wales on state of origin football nights. That is a horrifying statistic. And it points to an acute response, and generally that is related to a physical event. Do you have any insights for the committee into the nature of financial abuse, which seems naturally, in my view, to lead to sort of a chronic and ongoing form of abuse rather than the acute one? Now, it's often the acute things that gather people's attention and drive change, but this... Is it fair to say that financial abuse is a chronic form of long-lasting abuse, and because of that how do we need to approach this in a way that is different from identifying acute forms of abuse?
Thank you. If I may clarify quickly, I was referring to acute and chronic financial stresses earlier, but I definitely, the tenor of the question, absolutely. Financial abuse, the evidence that we do have shows the lifelong effects that it will have, and those continue well into somebody's adulthood and impact on other areas of their life as well. As Rebecca Glenn talked about, you have housing, custody arrangements, relationships with your children and family. So it is a very fundamental, or has very fundamental impacts on your life for its entirety. But I think we could probably speak to that further on notice. I'm not sure if you have anything.
Yeah, if you can take it on notice and have a look, like how long does it take for financial abuse to be established? Can it happen very quickly, or are there patterns that are revealed about that people should know about, so that we can have public conversations about if we're going to talk about financial abuse, what does it look like? What does it begin like? What are the early indicators of that? In the way that we talk about alcohol abuse, you know, like we know more about it, we start to see behaviours in ourselves or in others that help us identify that. So if you could take it on notice, are there any revelatory points of data that give us a better sense of the shape and nature of the development of financial abuse? Right, and you're particularly focused on women. I'd be interested if you have data about men as well, and particularly with regard to elder abuse, where I'm making an assumption, because I haven't really got any data, that gender abuse seems to be less a part of the elder abuse, that it is men and women who are subject to that more at that stage of their life than in earlier stages. I just find that I can't really get a handle on any data. So anything that you can provide for us with regard to that, that would be good. And can I ask finally, have any of your interactions with the banks traversed the possible creation of products that prevent the opportunity for financial abuse? So at the establishment, rather than sort of reactive clean-up that we're talking about in much of the evidence today, that create products that are actually prophylactics against what we have discerned are abusive behaviours with regard to financial product.
Thanks, Senator. Not yet. The conversations we've started having are actually about what's the data that's being held and how can we use that to understand the experience. So it's much more from that evidence-based perspective rather than the sort of honing of those products. But as I say, it's at the early stage. We're at the early stage of some of those conversations.
So it sounds like there's a fair degree of data poverty at this point of time, and we're peering into the darkness. Is that a fair summary?
And I think it goes to that other point about the what knowledge can be shared. No one is asking businesses to share private or confidential data about customers, but what knowledge does the industry hold that can contribute to understanding the problem? I think that's a really worthy line of discussion.
Yeah, and banks with data at scale can provide data that's de-identified and of no risk to privacy. So that's kind of the transaction that needs to occur. Is that right?
Yeah, it can provide the data or can be doing the analysis and the synthesis about what are they seeing from their customer base that we can then help make sense of.
Thank you very much indeed. There clearly were a few questions I noticed there, and there may be more. Can I thank you for your support for the committee's work and ask that responses to questions on notice be provided by the 26th of July. Thank you. I now invite representatives of Women's Legal Services Australia. And can I ask Dr. Goodborn and Dr. Kane to disconnect? Thank you very much. I I now welcome representatives of Women's Legal Services Australia, and I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, could you please state your full names and the capacity in which you appear today?
Dr. Jenny Gray, Deputy Chair, Women's Legal Service Australia.
Thank you.
Elise Whitmore, member of Women's Legal Services Australia.
I now invite you to make a short opening statement, and my colleagues and I will certainly have questions for you. Thank you.
Thank you, Senator. Elise and I are representing Women's Legal Service Australia today, the national peak body for 13 specialist women's legal services in each state and territory across Australia, including two First Nations women's legal services. We acknowledge and pay respects to the traditional custodians on the lands in which we work.
Yeah, sure.
For me, this is Wajak Noongar Budja. We recognise that this land was never ceded, and the experience of colonisation and loss continues to affect the lives of Aboriginal and Torres Strait Islander women and communities today. We also acknowledge the victim survivors of family, domestic and sexual violence and financial abuse who we work with, and their voices and experiences which inform our advocacy for justice, equality and safety for women. We particularly acknowledge the victim survivors of economic abuse who have shared their stories with us. Women's Legal Service Australia provide a national voice for women's legal services to influence policy and law reform and advocate to increase access to gender specialists, integrated legal services for women. We welcome the opportunity to contribute to the committee's inquiry into financial services regulatory framework in relation to financial abuse. Women's Legal Services provide assistance and wraparound support services to women to ensure a trauma-informed, multidisciplinary and integrated approach to service delivery. Most women's legal services employ financial counsellors, social workers and other supports who help women to regain financial control, particularly where they have been prevented from leaving violent relationships due to economic insecurity and are rebuilding lives post-separation. While some of the legal assistance we provide does not have direct interface with financial institutions, the impact of financial abuse is felt across our services. Financial abuse, as you know, is a gendered issue. The structural and systemic factors that put people at risk of economic exploitation are mostly unique to women, and women are twice as likely to experience financial and economic abuse as men. Many of the women assisted by Women's Legal Services are experiencing financial disadvantage alongside a range of other issues, including family, domestic and sexual violence, sexual harassment or discrimination at work, risk of homelessness, engagement with child protection or precarious visa status, to name a few. Also, as you know, some women are more vulnerable to economic abuse than other groups, notably those from culturally and linguistically diverse backgrounds. In our experience, perpetrators of family, domestic and sexual violence use an array of methods and strategies to financially abuse women through manipulation and coercion. Many of their tactics are inadvertently facilitated, further enabled or unintentionally exacerbated by financial institutions, systems and services. Financial products and methods of household money management that might seem benign on the surface can easily lead to control of women and financial abuse. We'd like to note that this does not apply to all financial institutions, systems and services. We strongly advocate that where it does, financial institutions have a responsibility to engage in the prevention of and response to family violence and family abuse. We recommend the Parliamentary Joint Committee focus on the misuse of financial products in the context of family, domestic and sexual violence and make recommendations aimed at reducing harms to women victim survivors. Today we will talk about our experiences of providing support to women who have lived or are living with financial abuse. All the stories that we share are de-identified. Thank you.
Thank you very much. And there are indeed some extraordinary case studies in your submission to us. I mean, I don't know which one shocked me most. But perhaps I might just get you to speak to the reality of the stolen escaping violence payment.
Yes.
Which I understand was, from what you've written here, the client actually obtaining the support that's provided for such an emergency payment, and then actually being assaulted by the person who'd been perpetrating family and domestic and economic violence against this individual, broke into the home, seriously assaulted her, stole her phone before fleeing, was able then to access her phone and transferred all accessible value from EVP cash cards to his own account and a gambling account. This financially devastated the client, as those funds were effectively all she had to access the fund to purchase vital necessities. Can I put it to you, Dr. Gray, that so many Australians live good lives that these sorts of stories are literally unimaginable to people. Yet the task of this committee is to try and make recommendations in the national interest to deal with individuals of this kind, right? Clearly there's a system response, and in this case there's a system response embedded in it. I kind of want to say that there has to be a moral dimension to this in addition to a technical set of dimensions that the committee might recommend. And I just wonder if there is any insight you can give us in the broad frame that I've just put there for you.
Yes, look, absolutely. Senator, can I just quickly ask, can you see me?
No, Dr. Gray, but we can hear you very, very well.
Okay. Oh, look, I'm very sorry. I think there is some incompatibility with the camera on my laptop, and I can see myself, but I have just realised that I can see that you probably can't see me, so I'm very sorry about that.
No need to apologise. We're here for your good insights.
Yes, great. Look,
regardless.
And yes, okay, thank you. Look, I would... I share your horror at the stories that are presented, the case studies that are presented in our submission. Both of the case studies included in the submission about the stolen EVPs came from Western Australia, although of course this is not unique to Western Australia, and I think talks to the broader point of the ease with which perpetrators of family, domestic and sexual violence can use online tools to gain access to women's finances, and this the stealing of EVP is something that we actually had some trouble redressing through a complaint back to the provider, not a complaint, an appeal back to the provider, and that required some negotiation, which prolonged her accessing her second EVP. But I think Women's Legal Service WA also distributes safe phones as other women's legal services do, and it is not uncommon for these to also be stolen as well. And so they are provided on a basis that women have a means to safely communicate with others, and yet perpetrators can also access these. So I think the theme of the stealing the EVPs is across all of many of the services that we provide.
So when
and Elise might want to add to that. Sorry.
Yeah, when you use these terms, service providers and technology, we kind of need a bit more specific. Like,
sure.
Who are those entities that you're referring to in general terms?
Oh, so the EVP was administered by Uniting WA. So each provider in each jurisdiction in Australia has a different provider who auspices and administrates the payment of EVP. So the complication was that we had to go to Uniting WA, and then they had to go back to the funder, which I'm pretty sure is DSS, to negotiate a second EVP. In this case. And the provider of the phone is Westnet, and Westnet is very accommodating and understanding of women's experiences of having or losing safe phones.
And the technology that can be applied to this, how are we able to call on Westnet and other such providers to interrupt the kind of behaviour?
I am not sure where the actual barrier would lie in terms of either Westnet or Uniting WA, or whether it's the ease with which perpetrators can, well, not the manipulation and the coercion that perpetrators use to gain access through forcing women to reveal passwords and other details that will allow them that access.
Thank you. I'm very sad to hear our current ineffectuality. Senator Scarr.
Thank you very much, Chair, and I certainly agree with the Chair in terms of her characterisation of those horrific case studies, but it also leads one to ponder what the position of those women would be, but for the service provided by Women's Legal Service Australia. So thank you very much for all the wonderful work that your organisation and all of your staff and volunteers do. It's quite inspiring. A few common themes that are emerging across the submissions. One is the use by perpetrators of a system whereby they take an asset's in their name, but the loan document, the finance document for the asset is in the name of their partner. And so when the relationship breaks down, when they want to apply pressure to the partner, abuse the partner, they've got the asset, the partner's got the loan. To what extent is that, in your experience, is that mismatch between the ownership of the key piece of security, which is being financed, and the actual finance obligation? To what extent is that mismatch occurring? Are financial institutions starting to address that? Because it seems to me, if someone's getting a finance for a car and the loan's in someone else's name, their partner, that should beg an immediate question. That should be a red flag, a warning sign, a prompt to take further action. So I'm just interested in what your perceptions are with respect to how financial institutions are addressing such a, on the face of it, obvious mismatch and potential for financial abuse to be perpetrated.
Thank you, Senator. I might be able to speak to that. I think that it is a very common form of financial abuse that we see within women's legal services. I would go further than just that the asset is in one name and the name of the debt is in another. I'm thinking of an example I saw recently where two parties were purchasing property together quite early on in their relationship. She was putting down the majority of the money for the purchase of that property and had sold a prior family home in order to do so. The property was purchased in joint tenants and rather than in tenants in common to reflect particular shares within that property. There was a small mortgage, there was a financial institution involved, and she expressed to me recently that she was quite confused about the difference between joint tenants and tenants in common, and at what point during that process, early in a relationship where she may not have access to the family court system upon the breakdown of that relationship, what it meant for her to own property jointly with someone else when she was the person who had provided most of the down payment for that property.
Well,
it's occurring in...
that's another example. You might just elucidate for other members of the committee what the significance is of someone being a joint tenant as opposed to a tenant in common, because I would have thought there'd be a lot of people who simply don't know the ramifications flowing from that difference. So I'd see it just as legal jargon.
My apologies. So joint tenants is where both parties on the title own the property together. It doesn't allow for the property to be held in particular shares. So a tenant holding a property as tenants in common can allow, or could have allowed, for her to have her payment reflected on the title that she had made an 80% contribution to the purchase price, so therefore she held an 80% share of the title.
So it's a way to secure, to better secure the interest of one of the parties to a relationship to better reflect their financial contribution to the purchase of the property, yeah?
Yes, I would agree with that.
Yeah.
And I've seen it a couple of times recently where the party who is not making any contributions towards the purchase price has been listed on the title as a joint tenant. It's especially alarming where the relationship is new and where, if the parties are de facto, they might not meet the requirements to make an application to the family court at that point.
Yep. Okay, thank you. The second or the next question I have in terms of family law proceedings is we've also heard evidence that those proceedings themselves can be mobilised as a form of abuse in order to denude assets which are being accumulated during the course of the relationship, or assets which have been contributed to the relationship, and the effluxion of time, sometimes during the course of reasonably simple proceedings, maybe just dealing with a family home and superannuation, but sometimes the system can be mobilised in a way that those proceedings take years, and resources are spent on legal fees in a disproportionate manner. I'm wondering if you can comment on that.
Yes, I'm based in the Women's Legal Service in Tasmania, and we primarily work with relatively small property pools. So an example of that might be where there is only superannuation, and that often occurs where parties may have been in a relationship for a long period of time. Typically, mum might stay at home to care for children, so she's not in paid employment. Dad's in paid employment and has accumulated superannuation over the period of that marriage or relationship. And at the end of that relationship, there might only be superannuation to divide. It is quite difficult to divide that superannuation without a court order or something called a binding financial agreement under family law. And if the superannuation is in his sole name, the onus then shifts to the wife or the female partner in that situation to take action, including making an application to the court. And that was the case for a client I had recently, where it became apparent that despite his agreement to split the superannuation on a 50-50 basis at the end of that relationship, he was waiting out the time limit. So you only have 12 months from the date of divorce to make an application to the Federal Circuit and Family Court. And we were getting within weeks of that cut-off date, and we were in a position where we had to make that application for her to get a court to split the superannuation.
Okay, thank you. One last question, and I don't think we've touched upon this area this morning so far, which is the reason I asked the question. That is the interaction of debt collectors and women who are going through extraordinary pressures in terms of relationship breakdown, trying to secure their financial position. And I noted in your submission on page 13 of your submissions that in that context, women can be particularly vulnerable to overreach inappropriate practices by debt collectors. So interested in your further commentary in relation to that and what needs to be done to better address that, because I know the regulators do look at the practices of debt collectors, but from your submission, there's a particular specific issue in relation to the interaction of debt collectors and women in vulnerable positions.
Yes, Senator. So I think that with debt collectors, you see an escalation in some of those harassment type behaviours. An example of that might be the debt might be approaching being 6 years old. So at 6 years, you are statute barred from making or enforcing that debt. And so debt collectors will reach out to the debtor at that point and ask them to acknowledge the debt or make a small payment. And if the client inadvertently acknowledges the debt or makes a payment because they believe they have to, that time limit starts from scratch. And there could have been other options for them in relation to either negotiating that debt, accessing any family violence provisions within the policy of that debt collection agency, or seeking advice about the statute barred nature of debt after a 6-year period.
Okay, thank you very much.
Ms Mascarenhas?
Senator, I'm wondering if it's appropriate for me to, Jenny Gray here, to give an example as well, or to some of the that Elise has also spoken about, particularly in relation to housing, and one bank in particular who have been supportive. Yes. We have a client.
It would be nice to hear some good stories in relation to banks doing the right things.
So this is probably good just to point out. It is ANZ. Okay. So we have a client who is on a disability support pension and lives with significant barriers to participation in social and economic life, and who has lived with violence for many years. She took out a family violence restraining order in Western Australia, and he was removed from the home. He stopped paying his mortgage, the main proportion of the mortgage, when that happened, and she obviously couldn't meet the repayments by herself. So there started conversations around the bank foreclosing on the loan and repossessing the house. Now, it was ANZ who offered to reassist with her location expenses so that she's safe. And lots of banks will do this. We're aware of this. But the complication arises about the lack of housing. And so what we see is the interface between financial hardship and other areas of disadvantage. So her options were relatively limited. The bank did indicate that they would begin litigation once she is safe, so she knows that she is not able to have that liability removed against her. He has given her the option of dropping, recommencing the mortgage repayments, and that if she drops the family violence restraining order, and he allows her to move back in. So whilst in this particular scenario we have a bank who is relatively supportive, the choices for her, the client that we're working with, are pretty limited. And you can see, it's a bit damned if you do and damned if you don't. And so she's really choosing between, ongoing financial security and potential homelessness in the longer term, or living with violence.
Thanks very much.
Thank you.
Thank you.
Ms Mascarenhas?
That sounds like a really hard decision to make. One of the things that you talk about in this submission is around how ex-partners use the tax system to perpetrate financial abuse. I note that in Rebecca Glenn's submission that some of the tax implications that they thought the government could assist with was around the government mandating annual lodgement of tax returns for anyone involved in the child support system, but also delinking the child support and the family tax benefit. I was wondering if you had specific advice on what needs to happen from a tax system perspective to help stop the perpetration of financial abuse.
Thanks for that question, and that is literally a $2 billion question. As you're very well aware, that there are $2 billion in outstanding child support payments in Australia right now. It is incredibly complicated, and even when we talk to experts about how we untangle and devise strategies to ensure the correct payment of child support, that there are so many loopholes in the taxation system, like you've said, that allow him, and it is a gendered issue, to continue not to pay. And a little bit away from your question, we have seen the current amendments, which we welcome very much, to the Family Law Act. And we think that this is an opportune time for the Australian government to be looking at reforms in the Australian taxation system that align with the principles now in place in the Family Law Act, which recognise family violence and put the child at the centre, because we know a lot of his, and there are so many case study examples that services like ours and Elisa's work with, and we hear the stories from women every day, so many examples where women bear the burden way after separation of his of economic abuse, perpetuated primarily through the non-payment of child support. And the onus of rectifying that and appealing is on her, which makes it doubly complicated and also raises the possibility that that might trigger further violence against her as well. There is an exemption for family violence for child support, but it is a minimum payment. So again, the choice is to live on a very low income or to risk appealing decisions for child support. But again, we talk to experts, and experts find it very hard to find their way through to rectify child support payments.
I was wondering about the funds that a woman would need to access legal advice, and I'm wondering if there's women that you don't service because of maybe their assets or something like that.
Yeah, so this is probably common. Elise will have something to say about this, but in Western Australia, we follow the National Legal Assistance Partnership Guidelines, which do allow for exceptions to support women or support clients who might not sit below our income threshold of low income, including poverty, but we do support women whose assets are frozen, exactly as you say, who on paper might look like that they could afford legal services, but who have no access to the family income or assets because he has frozen her out. And that is, again, through all of those mechanisms that you have been talking about and this inquiry has raised.
Do you have a back of the envelope estimate of how much legal advice would cost in the private sector to try and deal with a, say, family tax issue and child support payments?
A lot, and we know how much it cost to take a matter to family court.
Can you put that on the record? Because we don't.
Look, it depends how long the case is, really, and how complicated the case is. But, tens of thousands beyond 100,000 is not out of the question. And so we also know, Elise and I know, that many women choose to walk away from that matter because they simply can't afford it. And Elise might have more to say about this.
I think we might have to take further evidence on that matter on notice because we're going to run out of time. Indeed, I'm sure there's so many more questions because you are actually able to respond in the particular to our questions. We may need to call you back on another occasion to get further information.
Sure.
I'm going to go to the Deputy Chair now, Mr Alex Hawke.
Yeah, thank you, and thanks for your evidence so far. I agree with all the comments that have been made about your work. Just quickly on the, your submission's got several parts about the importance of culturally appropriate responses. I've had a lot of exposure to that, and I have a strong view about the significance of this. I just wanted to give you the opportunity to expand, here about the importance of this topic and recommendations about mandatory training about tackling culturally some of these financial issues as well that come up through different of the cultural challenges that you see.
Great question. Ms Whitmore?
Thank you, Mr Hawke, for your question. One of the issues that I see pop up in our jurisdiction a lot is the ownership of property. It might be between a husband and a wife, but also extended members, usually of the husband's family. And often she will come in for advice upon separation, and there are a range of issues that make it very difficult for her, including some of the cultural pressures to remain married or remain a member of that family within that community. But then you add the additional layer of the fact that she may be experiencing family violence, not just from him, but from members of his family that are co-owners of the house that she owns. The fact that she might not understand the co-ownership structure, she might not understand the value and equity in the property, and then it becomes very difficult to disentangle her from that ownership for her to receive any type of equity or payout from that property other than through an application to the family court joining them as parties. That is something that is a complicated, or can be a complicated application. We are a small community legal centre. We struggle with capacity in being able to provide lawyers to run those types of matters. And it becomes very difficult for her, if we can't act, for her to fund a private lawyer in circumstances where she's not sure that she will receive a payout, and if so, how much.
And thank you. That's exactly the point I wanted to elucidate. So you'd agree that this model, co-ownership, is increasingly an issue. I mean, obviously in Sydney I see it a lot, even in my own electorate, but also in Melbourne, where we've got a lot of migrants coming to major cities in particular, with cultural backgrounds of this co-ownership model. It's in house prices. The combination is leading to this more often. So I imagine you're seeing more women in particular,
Yes.
As you say, with not just one domestic violence perpetrator or one person putting financially abusing. There's perhaps 2 or 3 families that are not taking into account the significant domestic violence or other issues or breakdown within the relationship. They're actually prioritising their own financial needs ahead of a victim's needs. You would agree that's increasingly common?
Yes, I am seeing it more. I've been practicing in this jurisdiction for about 14 years, and it is becoming much more common in the last few years where I've been at the Women's Legal Service.
And so I agree with you, if the private legal model is really, really very challenging, what could be done, practically speaking, or, does your submission address this? I mean, this is a frontier. I think this is quite new in Australia. But what could be done in terms of the construct of the law to anticipate some of these issues with co-ownership models and deal with this better?
Yeah, I think that the submission does list some solutions that relate to banks' awareness of the clients that they're dealing with, the red flags or risk factors associated with particular types of ownership, whether and what obligations they have to explain that the loan and the security, and how that might be difficult to liquidate for her at a particular point. One of the things that I see most common in this situation is that she has just had no idea of what it means to own property in this way, what it means to have a joint and several liability in relation to the loan, and what it means for the difficulties of extracting herself from that arrangement should her relationship break down.
And just before you go on, can I go to the point of product disclosure statements, which are supposed to cover all of these things, and the literacy and knowledge gap when people might encounter this once in their lifetime seems to be something that is not being attended to by any of the major financial institutions. I'd be keen to get your thoughts on that and any feedback you've given back to the banks on notice, but back to you, Mr Hawke.
I think it's a really good question, Chair. I think that's one issue, and I was going to ask a similar question on the financial literacy side, but I think there's that issue that the Chair's raised, and we can hear about that. But as a second issue on that, even if the product disclosure is there, isn't this a weakness of the co-ownership model? I mean, here that where you might have families grouped together, how do we deal with this this breakdown. I mean, even if we had all the best information in the world, you'll still have women trapped in these situations, unable to liquidate or get out. I mean, there's also a regulatory issue here, isn't there, about co-ownership? I mean, that I think will be increasingly prevalent for us.
I think that with cost of living and the housing crisis, I'd be reluctant to say that there's an inherent problem with it. I think that the problem comes with the abuse of it and and where people are empowered and they have information to make choice about their living arrangements, they have sufficient information, and they are that they're in relationships that are equitable in power structure, that these arrangements work for a lot of people. I think that the issue arises in a situation where she doesn't have information and she doesn't have choice, and any documents that she signed, she might either not recall signing them, they might have been signed on her behalf, or she might not have been able to read them due to the fact that they're in English and English is not her first language.
Excuse me, Mr. Hawke, is it okay if I add something to your first question?
Thank you.
Thank you very much. Look, just to your first question about the importance of culturally appropriate and secure frontline workers, I don't think that we can stress how important that is enough. Women, particularly women from culturally and linguistically diverse backgrounds, because of culture and gender barriers, are often unaccustomed to accessing services by themselves and or unfamiliar with accessing those services. And we know at Women's Legal Services, when those women do manage to make contact with us to seek advice, it is absolutely imperative that we hold them, we engage them and we hold them in a way that is safe for them in that very first instant. We only get one go at this and we talk about this all the time. And so it is absolutely essential that frontline workers in financial institutions are aware of the importance of a culturally appropriate and safe response to women, and including, of course, Aboriginal and Torres Strait Islander women as well.
Yeah, no, thank you for that. But I agree. I think that's a very helpful contribution. And again, I'm not sure we're at the standard we probably need to be. I think services have lots of good people who come from those backgrounds, but from a government perspective, we do struggle to get people to understand the cultural issues they're dealing with, which are, I think, at the core of much of the problem when a breakdown happens. So I fully support what you say there. Just back to this point, though, I hear just in the answer that you gave just previously, I hear what you were saying, but I'm trying to elucidate something a little bit different. I understand even if someone is fully informed and signs a contract with knowledge, which I accept is not happening, and that is a core problem first before we get to this point. But even if we get to this point, if we have a structure which has a cultural background to it, and there are plenty of cultures with obvious issues with male dominance, and then you're fully informed in signing this, then there is a breakdown of relationship or violence or other issues within, and there are many families involved in the ownership model. We have a regulatory issue in relation to the ability of a person to exit that model for those reasons. I mean, that's what I'm trying to understand. What could we improve? Not just I understand your points are very well made about the English as a second language, the financial literacy, the ability to things being signed for people. But even if we fix that or we address that, we're still going to have the output at the other end, where I find people are trapped in these situations by the model, and they can't escape this model, even if they were fully informed. Do you see the point I'm making?
Yes, I would agree with that, and I think that points to the need for the assessment of family violence, and in particular coercive control, and to have very well trained frontline workers who can identify and assist supporting her to extract herself from that, whatever that looks like. And I have only recently, and this wasn't included in our submission, but last week was with a group of rural, regional and remote women leaders, and they were telling me about the difficulty of women who live in violent relationships who are in a farming in farming finances, and how you just, you cannot extract yourself from a trust easily, if ever, and it requires the permissions of quite a lot of people, which can include extended family. And they were talking about how isolated those women were in particular because they had no options.
Yeah, indeed. Well, look, if you have any other reflections in relation to this issue, and I think home ownership is integral in cities, in our major cities, this co-ownership model is becoming more common. There is this cultural underpinning of some of these issues from different backgrounds. It would be good to hear any more suggestions or advice you might have in relation to that.
Thank you. And your last comment about farming communities and trust structures being a further impediment goes, if I can, to one final question before we break. Okay. The good news I have gleaned from the Secretariat is when we are in Perth next week, we will be hearing from Dr Gray again. That's great. So we have the opportunity to pick those up, and maybe you might be able to fill out this answer with regard to access to regional, rural and remote services. You talk about frontline services. Well, the ultimate preventative frontline service of a financial product is traditionally the bank, right? We have seen incredible levels of restriction of access to banking physically in regional, rural and remote communities. We've also seen the abuse of technology, people adopting people's passwords, using online banking tools, which are very convenient and very important for productivity, and the fluency that we all have with that is just, everywhere. What needs to be done by the banks with regard to replacement of access to support for people who no longer have a physical place to go and who may be much further down the track of financial abuse because nobody's actually been able to observe it as they came to a branch?
I think that is a very excellent observation, and the diminishing numbers of banks in rural and regional areas and the replacements. You would think that for someone living with violence, a replacement still needs to be a person and not an online mechanism. And I would point to, in Western Australia, Water Corporation have a hardship team, and when someone discloses financial hardship that is linked with family violence, they are assigned one worker, one customer service officer who follows them through. So they have a relationship. They might never meet that person who is still based at the call centre, but they have one person who follows them through. They do not have to repeat their story. And I think that this is an excellent model and that others could look to adopt. And I've heard of many other experiences from women who are absolutely contrary to that every time they make contact, they have to repeat their story. So I think that might be a place to start. And look, I'm very sorry, but I won't be appearing next week in Perth in person. My colleagues, financial counsellors are, so you will get the opportunity to perhaps hear more technical details and stories about the financial abuse of women in intimate partner relationships.
Okay, well, thank you very much, and thank you for your response that goes to the other part of this inconsistency of staff and the multiple retellings that we've heard also as a concern for ASIC in our recent inquiries with them. Can I thank you both very much for your detailed and practical observations, and I just get the sense that we will probably need to call you back at some point to ask further questions, especially as our knowledge goes on. Thank you for your submission. And can I indicate that any responses to questions on notice, if possible, could be provided by the 26th of July. That concludes this session. The committee will take a short break and return at 11:35. Thank you very much. I now welcome Ms Catherine Fitzpatrick from Flexquity Ventures. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Yes, my name is Catherine Fitzpatrick and I'm founder and director of Flexquity Ventures.
Flexquity, okay.
Sorry, I just need help adjusting the chair.
We all do that from time to time. It's down at the right. There you are. Okay, fantastic. Thank you, Ms Fitzpatrick. I invite you now to make a short opening statement and at the conclusion of remarks, I will invite committee members to ask questions.
Thanks very much. Before I start, I'd also like to pay my respects to the traditional owners of the land on which we meet. And I'd also like to acknowledge the terrible impact of family violence on individuals, families and communities, and the strength and resilience of the children and adults who have and who are still experiencing family violence. I pay my respects to those who did not survive and to their families and friends. Thank you for the opportunity to appear today, and I'm very happy to answer questions. I look forward to the discussion. As a former bank executive, I've seen firsthand how the products and the shift to digital services are weaponised as a tactic of coercive control and the devastating impact of financial abuse. I've been part of the finance sector's response, and I've led the Commonwealth Bank's domestic and family violence strategy. I'm the architect of that strategy. I've established specialist teams to support customers experiencing domestic and financial abuse, and I've also catalysed industry-wide efforts to address tech-facilitated and financial abuse. My current role as a social entrepreneur involves leading an independent consultancy which aims to disrupt financial abuse and gender bias through better product and service design, and that's really informed by people with lived expertise. Since we launched the first Design to Disrupt paper in November 2022, which was published by the Centre for Women's Economic Safety, and Rebecca Glenn's here, we have more than 25 businesses across banking, insurance, telecommunications, education and technology have mobilised against perpetrators. They've adopted my recommendation to include financial abuse in their terms and conditions and policies, and really, in effect, that bans the misuse of their products and services for financial abuse. It's setting a global standard for protective measures. But this is just the start. In my submission, I propose 5 actions for the committee's consideration, and that complements the 20+ recommendations that I canvassed in the Design to Disrupt papers on banking and general insurance. The first is to recognise financial abuse as a financial crime, equating its tactics with fraud and scams, and responding with comparable urgency and investment. The second one is to embed the eSafety Commission's Safety by Design framework into the financial services regulatory framework, with a positive duty to prevent the weaponisation and the misuse of products and services, and a clear warning that this risk, which could in the worst cases lead to the death of a victim survivor or a customer, is material and it's more foreseeable, and it should be considered by directors as part of their current duty of care, due care and diligence. The third recommendation is to establish enforceable customer service standards for victim survivors of financial abuse and a sector-wide review of privacy breaches. The fourth is to modernise the regulatory framework to specifically include domestic and financial abuse, recognising the risk of misuse of the financial system and barriers to customer safety and support. And the fifth is to monitor the implementation of anti-financial abuse terms and conditions and other financial safety initiatives. This inquiry offers an opportunity for policymakers, regulators and the finance sector to reimagine products and services to improve financial safety. In my view, it's time to adapt financial services to serve not only those in healthy, equitable relationships, but also those at risk of financial harm.
Thank you very much indeed, Ms Fitzpatrick. Clearly you're a very special witness with your experience traversing the industry and now your corrective to it. Can I thank you for the clarity of your submission to the committee and your very, very clear recommendations. I'm sure my colleagues have many questions. I just want to ask one at the beginning with regard to modernising the law, seeing as that is a challenge that we particularly will be engaged with. Can you speak in a little more detail to your fourth recommendation for modernising the law and what is actually required?
So I think you would start with a review of all the aspects of the financial services framework and how they apply to a modern society. If you look at the Insurance Contracts Act, for example, it has a very detailed description of what is a flood and how you might respond to claims relating to a flood. It doesn't include anything to do with domestic and financial abuse, and yet there are a huge number of claims that relate to property damage that are caused by perpetrators of domestic violence. And what we don't know is some of the figures. Well, we know that there's a number of claims that are denied because of a malicious damage exclusion, which means that you can't smash up the house and then claim on it. In a case of a domestic violence matter, you might have a perpetrator that deliberately damages assets or property, and the victim survivor is penalised for that action and can't make a claim. So the insurers know that, but the Insurance Contracts Act doesn't provide for those kinds of matters. So that would be one example. The design and distribution obligation, for example, that ASIC has, that requires financial services products to be designed in line with the needs of the target market. It does also require you think about customer vulnerability, and domestic and family violence is considered in that, but it doesn't say you need to contemplate the misuse of your products and services for those purposes. And so target market determinations are reasonably new. Most banks, it's quite a tick and flick exercise, and most insurance target market determinations that I've read, also it's a tick and flick exercise. People are not embedding what does it really mean, what is the need of a customer experiencing domestic and financial abuse, and then how do I design a product in line with those needs. So that'd be two examples of where I think there are opportunities to modernise. But overall, the government has the Online Safety Act. It's an excellent piece of legislation. It talks about safety by design, and it says for tech companies, they need to design platforms that are safe, and the onus is on them. In my view, every piece of legislation that the Commonwealth has should include that provision, and that applying that in the financial services space means you have a look at the entire regulatory framework.
And for those sort of following along at home, one of the things that occurs with the consideration of all of our legislation is a few triggers, and that includes the human rights implications. You're suggesting that in the way that lens is required to be applied, a do no harm lens be provided as a requirement for consideration before legislation would pass.
I think that is a really good model. So there are gender impact assessments that are being undertaken at the moment. There's none that relate specifically to domestic and family violence. I think the do no harm obligation is generally about a service provider to the customer. It's not the do no harm between one customer to another. And so if you think about that risk assessment approach, most businesses that I have worked to have a 5x5 matrix of consequence and likelihood. And most of that is about what the business might do to a customer. It doesn't contemplate one customer to another. And so the risk of, for example, me sending a letter to a perpetrator that has the address of a victim survivor on it does not neatly fit into a 5x5 matrix in a business. Similarly, in the regulatory framework, we're not thinking in that context. How are these systems and products being weaponised, and how does that align with another system or product or service that's being delivered?
Is it realistic? Certainly, everything that you say appeals to me. Is it realistic for designers of product to be able to anticipate malign actors? Do we have sufficient knowledge, understanding, data points, access to information to inform such, creation of matrices and also response capacity inside these product creation entities, including big banks, but this goes right down to small entities as well.
Look, that's the reason I'm writing the Design to Disrupt papers, frankly. The first one was on banking, the second's on general insurance. I'm currently working on one related to water and one related to energy, which the regulator in Victoria has commissioned. And I've also been engaged to work with other organisations to investigate the way Service New South Wales services are being weaponised by perpetrators. We don't know all the ways. It's not written in, it's not collated in a way that everyone understands precisely which policies, which processes, which practices are being weaponised, but we should know about that. Victim survivors have been telling us for years. All we need to do is ask them and listen to them. And quite frankly, that's what I did when I wrote the first of the papers. And I took that information and said, how do I translate that into product by product? What does that mean here? And then, therefore, what might you do about it? That's a process that I've undertaken in a social enterprise. And there is a methodology behind it. I've used the eSafety Commissioner's Safety by Design process. Yep. She has an assessment tool that's available for tech companies. We just need to change that and tailor it for other sectors.
How do you characterise the bank's response to the materials that you've already put into the public place?
So a lot of them described it as a blueprint for the industry, actually. I've felt like I was pushing on open doors. I think it helps. I've worked in the finance sector for nearly a decade. I'm speaking the same language. But it's not just the banks. The insurers also have been fantastic, and I've just been going and pushing on open doors. The fact that I've got other sectors like water, energy, telco, education, government services saying, how do we do this? No one wants their products and services weaponised. They're not like the tech companies where harm happens with virtual impunity. People are shocked and people don't want to be part of that system. So I think I would characterise it as I'm very optimistic. Some of them are really wicked problems, hard to resolve. That is why the papers talk about what can you do now without any change, what does the industry need to do, and where does there need to be regulatory change.
So one of the concerns I always have is that in terms of a response, a government response, that it's a response to the problem at the end, and we do need to help people, certainly when they're in those situations. But the great hope of what you're providing us with here, Ms Fitzpatrick, is the opportunity to engage in prevention of the harms that are now profoundly documented, shocking as they are, but now documented and becoming more and more known to the Australian people, which is perhaps providing the context into which you are now landing a desire for change.
Yeah, look, and I think it's a bit of prevention and early intervention. So it's the first part, the papers really are talking about risk mitigation and controls and responses. So how do you fix the loopholes that are already being used to make it much harder to cause that harm? But then the second part is how do you change behaviours? So the recommendation around putting financial abuse in your terms and conditions is to say we want a contractual obligation that says we need you to behave with respect to another customer, and we won't tolerate it if you don't. So there will be consequences. And the reason I made that recommendation is because it aligns with the Our Watch Change the Story framework, which says one of the drivers is you need to challenge those norms and those unacceptable behaviours so that you can change culture. The second one is when we found abuse in payment descriptions, and for my research in 2022, two banks told me 90% of the customers that they wrote to say, we can see you, you need to stop it, or we'll close your account, or we'll suspend your online access. 90% of them did stop. So there's something in a business intervening and saying, we can see you. Sunlight's the best disinfectant to change poor behaviour, isn't it? So there was something about that to then say, put it in your terms and conditions. It also reminds me of after September 11. We all knew you couldn't get on a plane and joke about terrorism. And airlines have got signs up and everyone knows this is the way you behave here. And if you don't, there's consequences. So in my view, that is really talking about perpetrator accountability and behaviour. And we can't keep fixing the problem, and we must provide better support for victim survivors. But until we change the behaviour, we are not going to be able to tackle this problem.
Because the scale of it will swamp us. But just to make sure it's clear for the record, when you're describing what the banks did in response to descriptors, for ordinary people that would be when I'm making a payment, you know, to my mum, for example, you know, I put love you on it. That's a very different message from a negative, hurtful, hate-filled and aggressive comment from a perpetrator to somebody that they have to pay perhaps child support to. So it's in that single description line that we fill in all the time as we move things around, money around in our community. That is the response. 90% collapsing abusive behaviour in that forum because the bank said, I can see you and it's got to stop.
That's right.
What other opportunities in the ecosystem do you see that are likely to be as effective as that particular interruption? Yeah,
so what we do need to do on that particular example is we actually need to evaluate the effectiveness of it. You heard from Anne-Rose earlier about evidence that's required. I am part of a submission to seek funding to do that evaluation, at which all 4 major banks and the Australian Banking Association have agreed to provide data. Unfortunately, we didn't get an ANROS grant to do that, so we would need to seek funding to evaluate. What I do know is that has stopped poor language in bank accounts. It's stopped some of the threats. You know, I read 900 messages sent at a time, including "I want to kill you." That's outrageous from a threat perspective, but also it shouldn't be in your bank account. Like, it's not a messaging service. Other opportunities would be all the different ways that products are misused. So in insurance, for example, you can cancel an insurance policy, a joint insurance policy, by calling or just doing it online. And most insurers don't check with the co-insured to say, are you comfortable with this? Which leaves somebody uninsured. Now, in banking, if you tell someone I'm separating or divorcing, mostly they will say you need 2 to sign on a bank account to protect you from the money. Unfortunately, from the money being withdrawn from your account. Unfortunately, family lawyers will tell people this, and so people will clean out the accounts before they notify the bank. So each product, I think you can say, we know these are the ways it is being misused. Therefore, if you do these things, we will then take action. Some of them are going to be much more complex. A mortgage is so difficult to disentangle, but transaction accounts are not. A credit card is not. So it's really, if you take out a credit card in somebody else's name without their knowledge or consent and rack up that debt, then why should it be up to the victim survivor to have a poor credit record and have to repay the debt when you're the one who caused that problem? Again, it's the victim survivor being penalised. So in my view, with these terms and conditions, a bank can say these are the consequences for you.
Thank you. I'll go to the Dep Chair.
Well, thank you. Just in relation to, I think you've got some suggestions around, in your papers, around online transition, as you sort of say, to rewrite.
I'm sorry, I'm having a little bit of trouble hearing.
Oh, sorry, my microphone today has been a bit funny. So you've got some suggestions in your papers on the online transition in a regulatory sense. I mean, you've mentioned you've got an open door from many of the different institutions that you've been visiting because of your experience, but with government, I mean, are you getting an open door in terms of access to these issues? I mean, from departments and officials, and I mean, the importance of what you're saying is being assimilated by the corporate sector, but government's got a huge role to play here, and we've heard that calls this morning for a new body or some way of coordinating or getting this done. How do you find government in terms of access for your ideas and your papers?
Frankly, my main approach has been with business, because business, when they decide to invest, can move much faster than government and at scale. So if I think about the 27 organisations that have now indicated they're having financial abuse in their terms and conditions, the first one started to do that in the middle of last year. One organisation I spoke to, a telco, they were able to make that change in 1 week and put it into their customer charter. Government doesn't move that fast. However, in New South Wales, as I mentioned, they have engaged the first phase of a project to understand the ways that their products and services are weaponised. They've got the biggest delivery of online services in Australia. They've moved very quickly to do that. We do know that car registration, the use of tolls, they can be weaponised by perpetrators for financial abuse. I haven't had a lot of conversations with the Commonwealth Government, but there has been research that on child support and the ways that is weaponised. We've heard examples of the tax office. The fact that if you're a director of a company, you can look up somebody's address and see that publicly available on the ASIC website. That's a problem for me about privacy for someone who might be wanting to protect themselves. There are a range of different examples from Commonwealth Government service delivery. In my view, I think there's an opportunity to do a full sweep and say, what are the ways your products and services are being weaponised, and then those risk assessments on how you would then prevent that from happening.
So that's a good point. And so you're referring to the New South Wales Government and Services New South Wales. So you think there's an opportunity for Services Australia as well to be looking at the same sort of policy approach?
Absolutely. Given it is so far behind the New South Wales example, in my view, any of the services that they should be looking at digitising need to have a safety by design assessment and need to be designed with that in mind, to future-proof.
Yeah, no, that's something we might have a look at as well. In relation to the, you've got the office in the federal government whose name just escapes me in terms of online and information coordinating across government, federal government. You haven't had any interaction with them either, I imagine, but you're saying your perception of the federal government services is that they're not where the financial sector is at the moment in terms of updating things as fast. No. And look, no, I don't think they are at all. In federal government service delivery, okay. That's really important to us. So your contract with the state government, is that a pilot, or what does that refer to?
It is a pilot, and the first phase of it is to understand lived experience of the ways that New South Wales government services might be weaponised by perpetrators.
Yeah, roughly how long will that take? I heard what you said before, but roughly how long?
About 6 months.
Right, and so then you'll have results available, presumably for the federal government as well.
Subject to them wanting to publish them.
Right, yeah, I understand. You've got your own obligations. But that's good to understand. Okay, and then in terms of some of the points you've made about insurance and other things, and I acknowledge your point about government being slow, but it doesn't always have to be slow. The reforms that we need to make regulatory as well as sort of, you're very inspiring in the work you're doing in terms of the getting in the doors of business and making them do change from this end, but the regulatory end needs to change as well. So, I mean, that's not your particular focus or expertise, but it certainly is one of ours and why we're here. So, what kind of upward pressure can we put on to get those insurance things changed as well as from your end? But I accept this is not your specialty, we're the government specialties, but we need to change these particular regulatory mechanisms as well to facilitate this process.
I think there's a number of regulatory changes that you could make. In the financial services regulatory framework, I think the best way that you could implement safety by design would be by updating the design and distribution obligations to include that as part of the provisions. To the point that Senator O'Neill made earlier around product disclosures, the Financial System Inquiry in 2014 found that product disclosures are insufficient, and that is why you need a product suitability regulatory requirement, which is what the design and distribution obligation is. Because financial literacy is so poor, we don't also have conversations about financial consent. We're talking about sexual consent, but we're not talking about how do you have free and enthusiastic and informed financial consent in a relationship. And I would like to see financial literacy programs and consent programs move in that direction. So the design and distribution obligation is one area. The Insurance Contract Act has there's a number of recommendations in my paper about where that could be modernised. The Privacy Act, there is supposed to be a review of the vulnerability provisions in the Privacy Act. That hasn't yet started. I would encourage that to be expedited. In one way, it provides good protection. In another way, the privacy provisions in there prevent a bank, for example, talking to an authority that can support somebody who is experiencing elder financial abuse. Without somebody's consent, they can't report to that authority, and you might not be able to get that consent. The Privacy Act, so I think that's important. Those privacy breaches that I mentioned about sending victim survivor information to perpetrators, there needs to be a wholesale review of how frequently that is happening. It is happening with regularity across every sector, and every business I speak to has had those instances, which will never be investigated by a death review, because death reviews look at the private sector and the public sector and what the public sector funds. It doesn't look at the private sector and what did the private sector know. So, for example, in a murder case, police might come to a bank and say, where was the rope bought? Where was the gasoline bought? They didn't come to the bank and say, did she ask for a safe account? So
that's because of privacy that's preventing that, the Privacy Act.
That part is related to the regulations for death reviews, which are conducted after every domestic and family violence death. There's a missing link.
That? I mean, I'm not familiar with that, to be honest. So I wouldn't mind hearing a bit more about that.
So a death review is conducted after every death related to domestic and family violence. Those reviews are conducted by coroners, and they have a look at what is preventable. That's conducted in every single state, and then it's aggregated, and there's an overseeing body that looks at it nationally. And has a lot of...
Are they the same reviews in every state, or are they different?
Beg your pardon?
Are they the same reviews? Do they use the same matrix in every state, or are they different from state to state?
I don't know enough about...
Okay, thank you. Continue.
That, but basically that information is aggregated, and we see what's preventable and what are the things that we need to know nationally. Unfortunately, the regulatory frameworks for each of the states doesn't allow you to necessarily look at what did the private sector know. And as someone who has set up a specialist team supporting customers experiencing domestic and family violence, which have vicarious trauma support over my team, and who had specialist training around customers who would talk to them every day about their experiences of domestic and family violence, they are part of a system that is not considered to be part of the system. They're not a specialist women's safety service like the people who've been working for 40 and 50 years, but they are specialists in banking or insurance or other sectors who have this other knowledge and need to be able to connect into the other parts of the system.
So just on this, because I'm sorry to interrupt you, but this is exactly where I want to ask you a question. So is that prohibited, or is it just not provided for in these death reviews? Or because I can't understand why the private sector would be excluded from these reviews. I mean, it doesn't. I mean, is it not provided for in the different acts that construct these reviews, or is it just?
As I understand it, it's not provided for. It's not that it's prohibited, but it's not provided for. So it's not a standard.
Occur. Yeah, and so you're saying your argument is this should be occurring every time.
We should be learning from what everyone knew and put all the pieces of the jigsaw puzzle together.
And then in terms of financial services institutions, there'd be lots of information about what happened, tonnes and tonnes that would be extremely relevant to each one of these situations.
Potentially. I mean, if you look at coercive control legislation that's been in effect in the UK, and I was talking to a service provider over there about what information might businesses have that could assist with the prosecution. One of the examples she gave was if you can access an online account, you can see one person is making transactions, the other person's just watching and just seeing what the other person is doing, and so they're surveilling. That could be evidence of coercive control.
Sure. And does the New South Wales coercive control legislation, in your view, tackle some of these issues in terms of financial?
It does include financial abuse. I guess it will be how it's implemented. And also, a lot of victims don't understand they're in it. And so it's going to be an education process about this is what coercive control is, this is what financial abuse is, and then seeing how that plays out in the criminal justice system. And the UK experience is that it's very challenging.
Right, slow and challenging, but we don't know yet because it's a new act. We will have to wait and see. Okay. All right, thank you. That's probably the end of mine.
I'll go to Senator Pratt, who hasn't asked a question for a while.
Thank you, and thank you for your wonderful submission. Can I ask, with respect to credit records and what government can do to help people repair their credit record, or perhaps even someone who might have a good credit record but has gained it through exploiting someone else's finances, the extent to which transferring that exploitation onto their credit record could become a disincentive for such actions, and what we would need to do to achieve something like that?
I think they're great questions, and I think I've asked the question more than I have an answer for you.
Yeah.
There are too many women whose credit reports are damaged through financial abuse. I did wonder whether you could pass that poor credit record on to the perpetrator.
Yes.
But there will be unintended consequences of doing that. So I think
Such as?
Well, it could cause a reason for further abuse. It could be that if someone goes to jail, for example, for a range of different reasons, they're getting a double jeopardy response by also having that poor credit record put on their put onto them. Having said that, why should a victim survivor have a poor credit record because of somebody else's behaviour? Again, I also agree with you then, why does someone get a good credit record because of somebody else, for what they've done to somebody else?
Well, I guess, but there's also the question about whether they deserve the credit record they have if it's been obtained illegitimately, and whether that can somehow be brought into the judgment of what your credit record actually should look like.
Yeah, I think they're excellent questions. I've not seen that example. What I have seen is where a perpetrator has a poor credit record and so then uses the victim survivor to get access to credit, thus impacting their credit record.
And there must be examples of people using a spouse's or partner's assets unethically to repair their credit record as well?
I don't have any off the top of my head yet.
Yeah, but what kinds of questions, like I know while it's governed by the Privacy Act and has a bit of regulation around it, the credit record itself is in effect a commercial product so that banks and other institutions can judge whether they want to loan money to someone. Surely whether someone is... surely it should be a legitimate judgment of someone's credit record if, you know, they're paying their debts via financial exploitation, etc. What kind of questions should we be asking, and of which institutions, in order to see whether there are some viable solutions there?
I would be... I did a project for the Australian Retail Credit Association. I know they've made a submission and they've included the report that I also did with Centre for Women's Economic Safety and a number of others. That had some very good examples of victim survivor experiences of the credit system and the credit reporting system, and their recommendations. I would be talking to them and any credit provider, plus also the credit reporting bureaus, about what are the inhibitors there. I would also talk
but I guess credit providers don't want to be providing credit to someone who in effect doesn't have the means for that credit, because they're gaining illegitimate access to someone else's finances.
I agree, but credit reports are made by credit providers on an individual. And so there is provision in credit reporting around hardship. There's provision with how that relates to domestic and financial abuse.
Okay.
So there are potential opportunities to improve that process. The report that I was engaged to write, it was intended to help ARCA answer some of those questions with credit providers, and I think they would be best placed to say, how would you respond to that?
Okay, and should it be, so it's not just people with bad credit records, it's also the extent to which people with good credit records are affecting someone else's finances.
Yeah.
And does it cover that?
We didn't look at that in that particular project.
But we could take the lessons from that project and I guess essentially ask for the commissioning of new work around getting some further answers to that.
Potentially, yes.
Thank you. Thank you, Chair.
Thank you. Senator Scarr.
Thank you very much. And thank you for your evidence today. Thank you for your submission, and thank you for all the work that you've done in this space in your current capacity and also in previous capacities. So it's extraordinarily impressive. So thank you very much. I want to give you an opportunity, Ms Fitzpatrick, to walk us through this very helpful diagram, if you could, just so we've got... this is on Senator Pratt. This is financial abuse equals fraud diagram.
Thank you.
On page 5, just so we've got the explanation on the Hansard record, I think would be very useful. So if you want to walk us through the diagram.
Sure. So one of my observations is that the tactics of financial abusers use are very similar to fraud and scams, and yet the way that we respond to victims, survivors, diverges. So this infographic is trying to show where the similarities are and then what happens when they diverge. And when you look at then the financial impact and the number of people that have been impacted, my view is that financial abuse should be treated as and considered a type of fraud. I also believe that scams should be treated as fraud as well. So, and the left-hand side of the diagram, it talks about perpetrator tactics. So fraud, you might have unauthorised access to an account, for example. Scams and financial abuse use very similar tactics of social engineering. So in scams, you might see a grooming, or say in a romance scam, you'll have a grooming of somebody, control, degradation, isolation or exploitation. They are very similar tactics that you will see happen in financial abuse, with that coercive control, that grooming of somebody, the love bombing that you hear about, then the manipulation and coercion. You do what I am asking you to do, or you don't get any access to money. The cost of each of those varies. So from a fraud perspective, we know the data says that there was $677 million lost to fraud, affecting 1.8 million Australians in the last reporting period. For scams last financial year, the figure lost to Australians was $2.74 billion, and that affected 601,000 people. The individual people who lose the most money out of scams are people who lose it to investment scams, and that's a big amount of money, and in my experience that tends to be men. The financial loss from financial abuse has only ever been estimated, so this is taken from a Deloitte report, but the financial loss to individuals is $5.7 billion. So that figure is vastly more than what is lost to scams. And the number of people that it impacts is $2.3 million, and we know they're primarily women.
2.3 million people.
People, I beg your pardon?
That's all right.
Thank you.
You're giving us a lot of heavy-duty information here, Ms Fitzpatrick.
Sorry, I know I've tried to simplify it, but it's 2.3 million people. Thank you.
2.3, I mean, those figures are quite staggering, aren't they?
They are.
2.3 million.
And mainly women.
Mainly women suffering financial abuse over the course of a 12-month period, yeah?
No, that's in total.
So the 5.7 billion is over a 12-month period?
I beg your pardon, yes.
So
Over a 12-month period. So these are all 12-month period figures.
Right. So
that's an estimate, yes, $5.7 million.
Estimate of 5.7 billion in a 12-month period, estimate of 2.3 million people suffering over a 12-month period.
Yeah.
And presumably a lot of that, has there been any research done on the prevalence of victims who were repeated victims, if you know what I mean? So presumably a lot of that 2.3 million would have suffered financial abuse the year before, and perhaps even the year before, if you know what I mean.
There's not enough research, so
Okay.
no. That was a one-time study, that one.
Okay. And comparing that to fraud, which is 1.8 million, so an additional estimate of 500,000 people, but also an order of magnitude nearly 10 times as much being lost to financial abuse as opposed to fraud.
Yep.
Okay. And to what extent is there a crossover between financial abuse and fraud? So some of the scenarios, case studies we've been provided, when you're reading them, and I tend to put a legal lens on these things, there has been fraud. So it potentially falls within under two rubrics as fraud and also financial abuse. Is it a case that financial institutions, when they look at the circumstances, because there's a domestic dimension, they're just more likely not to consider it fraud? Is that a fair comment?
Look, I think we're learning more about financial abuse. It is a conversation that I have had a number of times to say, why don't we consider this to be fraud? If you take out debt in somebody else's name without their knowledge or consent, that is fraud. So that's a very clear case, and you would see most organisations might waive the debt if they find that is a situation. I think it is about a cultural belief that if a stranger does something to you, and then you're blameless, but if you love somebody and then they take advantage of you or they try to control you, then you're partly to blame. And so you'll see the second part of the infographic shows this divergence. So fraud goes to the fraud team. And I'll give you an example in banks. So fraud will go to a fraud team. There's monitoring over accounts to look at those transaction patterns. There's interventions, there's friction put into the system. Scams, we're now starting to see that, but there's also a bit of blame on people who are scammed as well. Partly because banks don't want to have to pay the cost of, repay the cost of scams, because there is some, in some cases you are doing things where you've been manipulated to do it, and in my view, scams are fraud because of all of these social engineering tactics. I shouldn't be complicit in a fraud because somebody has tricked me into sending money to them. It's just a classic scammer, It's the same, but that also goes to a team that's usually aligned with the financial crime team, and now we're starting to see more blocks and interventions there. And scams are also much more complex because it's not just financial services, it's telcos and it's tech companies. There's an attempt to recover the money in both of those cases, and in scams you may or may not get a refund. When it comes to financial abuse, it goes to the hardship or the vulnerability team. So it's not treated as a crime. In a way, it's good because you've got those teams are really treating you as somebody who needs sensitivity and empathy, and they've got more training these days around what is domestic and financial abuse, how do we provide for your safety, how do we have those conversations and refer you to the right people. But in another way, when it's debt, it's too bad, so sad, you've got this debt, you need to repay it. It's not, you are a victim of crime, and therefore, how do we restore you to where you were before that crime? So, and then there's a whole lot of other provisions, so credit reporting corrections and those sorts of things that might happen. I've not seen a bank try to recover the money from the perpetrator of financial abuse like they would try to recover the money
You have
from
not
fraud.
seen that, and you've
No.
been deep in this. You've not
Yeah.
seen one bank or one example of the justice of recovering the debt from the person who caused the problem because of financial abuse. Not one.
No.
I'm so shocked by that.
Because it's supporting the victim survivor. Partly it'll be because there's a safety issue as well. So I've been involved in cases where we had a mortgage, he stopped paying the mortgage, she was the guarantor, and he said to her, if the bank comes after me for not paying the mortgage, I'm going to go after you, and he had access to guns. So we were in the position where technically we couldn't talk to her because she was the guarantor. And then if we waived the debt for him, he got a benefit because of the threat to her. And if we tried to sort it out for her life, that was challenging as well. And so it was really, these are really wicked, complex issues. And despite the ASIC report that talked about the hardship problems, I know there are people working inside all of these organisations who are dealing with these kinds of matters every day. So it doesn't surprise me they haven't necessarily gone after the debt, for example. But I also wonder, why don't we? If we make it a standard approach and say you're misusing our products and services, therefore this is one of the consequences to you, at the very least your credit report's going to be damaged. You can't do it on an individual basis because of the potential safety issues. But if it's a systemic response, it might be different.
Because the other systemic issue, and I share the Chair's surprise with respect to someone with your depth of experience and knowledge not being aware of an issue of action being taken by a financial institution against the perpetrator for the benefit of the victim, because we've had other submissions that have told us one of the barriers to victim survivors leaving, say, a domestic violence situation is because they don't have enough access to financial security. They don't have the financial security to leave. And by reclaiming funds which have been fraudulently or through financial abuse taken from a victim survivor, you're undermining the victim survivor's ability to leave the relationship. So it's actually compounding the issue for the victim survivor. That's a fair characterisation, isn't it?
It is. There are a number of cases as well, as you'll see on here, where debt waivers are provided, so we relieve people of the debt. But it doesn't mean that that's necessarily recovered from the perpetrator.
Okay. And I was reflecting on the...
This might be the last one.
Yeah, sure. Just in support of your recommendation for conducting a comprehensive financial safety review of the regulatory framework, and that issue around the example you gave, malicious damage under the Insurance Contracts Act, that a perpetrator actually deliberately damages, destroys an asset of the relationship in order to victimise the victim survivor. Are there any insurance, and feel free to take this on notice, are there any insurance companies that are alive to this issue and have adjusted their terms and conditions to take into account that specific scenario, or is it something which really does need a legislative response?
Yes, there are 3 companies now that have addressed that by introducing a conduct of others clause, which gives them flexibility to pay a claim that might otherwise be denied through a malicious damage exclusion. There were 2 until we published the paper, the Design to Disrupt paper. There is now a 3rd, and I know a number of insurers are looking at this.
So who are the... Sorry, I'd just like to give a call out. I'd like to reinforce good behaviour. Who are the 3 insurance companies that have modernised their policies to take into account this phenomenon, and who should be congratulated for doing so?
Well, Suncorp was the first mover. The second one was Allianz, and the third one is NRMA, a division of IAG. I know a number of others are looking at it, but yeah, I would definitely be congratulating them. They've provided flexibility and have been paying claims to victim survivors.
Excellent. Thank you. Thank you, Chair.
Thank you very much. I'm going to go to Ms Mascarenhas next. Thank you.
The order of magnitude of financial abuse being about $5.7 billion. I think the Women's Legal Service indicated that about $2 billion is associated with child support payments. If we have a systemic response to recover some of that money, do you have a sense of what the order of magnitude would be? And to some extent, I'm also astounded that when you have an insurance claim and there's you look at liability, your insurer will go to significant lengths to make sure that they can recover the money. $5.7 billion on the table. It's extraordinary that we don't have these tools to try and recover that money. And if you've got some observations on that.
Yeah, the first point about child support, I haven't thought about how that might address the magnitude of financial abuse. But what I would say is when credit providers are assessing income in order to provide a credit product like a mortgage or a credit card to a customer, child support is not treated as 100% of the income. So if I were to receive child support, because it is a form of income that is not guaranteed like a job, it is not considered like that. And APRA says you shouldn't necessarily because it's not a reliable source of income. That's a really systemic problem that we don't enforce child support, and it means that somebody who is trying to rebuild their life and get access to a credit product is disadvantaged even more by the system that says because we don't collect it, because it's not enforced, you're going to be penalised even more, even if someone is paying you, and you can show that. So that's one point about fixing the child support system as well. The second part of your question, I'm sorry, I've went on my rant.
The was kind of about insurers will go to significant lengths to recover funds and
Yeah, my point about that would be, and to some of the questions you were asking earlier, where's the opportunity for innovation? So if I'm a woman and in my lifetime I'm more likely to experience domestic and financial abuse because I'm a woman, where's the financial product, the insurance product that says we'll provide you with financial protection in the eventuality that might happen, so that you don't have a poor credit score, you are able to repay your debt, you are able to stay in the house after a separation or divorce, which is when financial abuse may start. You'd have to be really careful about how you price that product and whether it would disadvantage women because of that experience, like a young driver has to pay a higher premium, for example.
So are you thinking like a life insurance type policy?
I don't know what kind of policy. The insurers would be able, they could design whatever policy they like. You'd have to just do it in a way that didn't have unintended consequences. But in my view, there's a market opportunity waiting to happen for half the population.
That's a pretty big market. I just want to ask a couple of final questions. You mentioned in your submission 26 businesses across banking, general insurance, telecommunications, education and technology have put perpetrators on notice using really the work that you've been doing. I think you corrected that, but did you say 27 at some point? Have you acquired a couple more, or 28 or 29?
We're up to 27 at the moment. Not all of them are published on the website. And some of them we are working on it, and it's going through the process, and a number of them have actually delivered it.
Okay, so the publication of the entities that are engaging in this work with you to redress the financial abuse is public knowledge.
It's on the website called respectandprotect.au, and every time a business commits to doing it, their details go up there, and it's either got coming soon or we've got an example of the terms and conditions. It also includes testimonials from victim survivors from the community sector asking that businesses move on this, and testimonials from the businesses that have moved about why it's important to them.
Well, let's just make sure that people really know that they can go to respectandprotect.com.au and find out who are the leaders in this, because we've been brought up, to think of stranger danger, and we've certainly improved our scam awareness. But this reality of intimate danger is something that we have to just change our attitudes towards. Love doesn't make up the ground for any form of abuse, and it's a perverse form of love that's got abuse embedded in it. Yeah. Thank you. If you could take on notice in your page 5 mind map for us of the hidden connections, could you also give consideration to elder abuse and how that might be similar or different in any way from what you've already provided us evidence about?
Happy to do that. It's not my expertise, but I'll suggest where you might be able to find that information.
Wonderful. Well, can I thank you very much, Ms Fitzpatrick. I think everybody has found your evidence most elucidating and actually given me some considerable hope that change might actually not be that far away and that we can drive it, which would be a wonderful outcome, I think, for the Australian people. You have got some questions on notice. I would ask that, if possible, you provide them to the Secretariat by the 26th of July. They will be in contact with you to assist with making sure that you're across the detail of everything that we're still seeking. Thank you.
Thank you.
And I now invite our next witnesses to come forward, and apologise for being a little late in getting to you, but we didn't want to lose the opportunity of Ms Fitzpatrick's evidence here. The committee now welcomes representatives from Relationship Australia, and I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Absolutely. Thank you and good afternoon. My name is Nick Tebby. I'm the National Executive Officer with Relationships Australia.
Thank you.
Hello, my name is Dr Susan Cochrane and I'm the National Policy Manager for Relationships Australia.
Thank you very much. I now invite you to make a short opening statement, and at the conclusion of that, I'm sure senators and members will have some questions for you.
Thank you. And before I begin, I'd just like to acknowledge the traditional owners of the lands that we're meeting on today and pay my respects to the Ngunnawal people and their elders and other families that have strong connections with the lands on which we are. Relationships Australia is very grateful for the opportunity to appear before the committee today. As you would appreciate, domestic and family violence is endemic to the families who are seeking our assistance when they're separating or already separated, as well as among the individuals and families who approach us with other diverse concerns, including common comorbidities of domestic and family violence such as substance misuse, harmful gambling and mental ill health. Our domestic and family violence services include those delivered under the Specialised Family Violence Services program funded by the Department of Social Services, as well as services designed for men, including programs to support parenting capacity, men's behaviour change programs and tailored programs such as Respectful Relationships for Indigenous clients. We also provide children's contact services and specialist elder abuse services and some other non-Commonwealth funded specialist services for intergenerational violence and abuse. As I've already said, across all of these programs, violence, abuse or neglect within a family, as well as intergenerational abuse and child maltreatment, may not be the reason why clients are contacting us. Nevertheless, it is often below the surface. Practices such as universal risk screening offer multiple touch points at which people can and do disclose their experiences of exposure to and of choosing to use different forms of violence and abuse. These touch points are vital opportunities for effective interventions at all points, from prevention through to recovery. And various services provided by the Relationships Australia Federation, from counselling through to family law mediation and dispute resolution, parenting programs, gambling help services, case management services and mental health services, including Headspace and family mental health support services, all adopt universal screening as a way of identifying and responding to these sorts of comorbidities. From the National Office of Relationships Australia, we've made contributions to a range of recent inquiries focusing on domestic and family violence, including abuse and neglect of older people by their family members, which can be found on our website and include ranging from the Australian Law Reform Commission's inquiry into family law, the 2020 inquiry by the House of Representatives Standing Committee on Social Policy into family, domestic and sexual violence, various inquiries into Australia's family law system, the National Plan to End Violence Against Women and Children, and most recently the federal government's work on amendments to the Family Law Act in 2023. In our submission to this inquiry, we've made several recommendations aimed at ending financial abuse. We recognise that this form of abuse is often accompanied by other threats to safety, including coercive control, emotional and psychological, as well as physical and sexual abuse. We've paid particular attention to the experiences of older people, as well as women and children, and the circumstances of vulnerability and intersectionality. We feel that the range of recommendations made present practical opportunities to prevent financial abuse, to empower victim survivors, and to support recovery. And we look forward to your questions.
Thank you very much. Did you want to add anything, Dr. Cochrane, at this point?
Nothing to add. Thank you, Senator.
Excellent. Okay, I'll go first to you, Ms. Mascarenhas.
We've talked a lot about intimate family violence and financial abuse from that context, but from my understanding is that you have more expertise of financial abuse of older people. And it seems that we have some structures in place, such as enduring power of attorney, that is facilitating financial abuse. Can you talk to that in a bit more detail? But you also talk about some of the differences between state and federal laws and the need for harmonisation.
Thank you very much, Ms. Mascarenhas, for your question. Just going back a bit into the first part of your question, when we wrote this submission, I was informed by the submissions already published on the website, and I noticed that there was a bit of a gap in relation to financial abuse of older people. So it's not the circumstance that we have more expertise in relation to elder abuse than intimate partner violence, but it was at that stage, it seemed to be a bit of a gap in the evidence, and I really wanted the committee to have the opportunity to consider abuse and neglect of older people within this circumstance. And just to recall the previous witness's evidence, where she talked about the parallels between financial abuse of intimate partners, scams and fraud. A lot of those patterns can also be seen in abuse and neglect of older people. Now, you've raised the question of mechanisms like enduring powers of attorney and financial elder abuse. Now, enduring powers of attorney, like many other mechanisms, can be used for good or for ill. It has been our position for Relationships Australia position for some years that enduring powers of attorney can be a very powerful protective mechanism, including to protect people and enable them to continue to exercise their autonomy in circumstances where they might not otherwise be able to do so. It can also be abused. One of the big factors that enables the abuse of enduring powers of attorney for both older people, and I'll also mention people with disability because it's the same consideration, is fragmentation between states and territories. Fragmentation does not just result in inconvenience, fragmentation across family violence, child protection, financial abuse of intimate partners and older people is a cause of danger. Fragmentation enables abuse and enables that abuse to continue to be perpetuated across Australia. So that if we did nothing else, harmonisation or at least consistency across jurisdictions in relation to enduring powers of attorney would be a powerful protective mechanism, particularly if it was supported by education and training resources for principals, for their attorneys, for witnesses, and also for people in the third parties who rely on those instruments. And, you know, particularly talking about, you know, the front counter people at banks, the people on the phone line with insurance companies. They need to be empowered and resourced to recognise abuse, and also empowered and to recognise where a valid instrument has been made or not been made. We certainly have a number of clients of our elder abuse services whose abuse has been enabled by the fact that we don't have consistent laws, we don't have a national register. Now, I personally, in my private capacity, have been arguing for more consistent laws about powers of attorney for more than 20 years.
What is the resistance in your view, Dr. Cochrane?
In my view, to be really blunt, it is the gap between political will and administrative won't. It's been on the agenda of the Senate, of the Standing Committee of Attorneys General since 2003, to my personal knowledge, and we have sporadic interest in progressing, and then interest falls away. So it's a lack of, on the one hand, administrative will, but that lack of administrative will to iron out these inconsistencies is enabled by a lack, if I may say so, of political ambition and engagement in these areas. To be further blunt about this, the fact that this committee is taking an interest in financial abuse is the most exciting thing I've seen for many years. I may lead a very boring life. That may be a really low bar, but it really does.
We might share that particular illness with you, I think, in terms of this matter.
Can I perhaps just add to my colleague's comments there? I mean, there's no denying that there are complexities surrounding the notion of achieving harmonisation in these laws. Each of the states and territories do adopt or have adopted different approaches to things from qualification to be a witness for an enduring power of attorney through to the obligations of the attorneys and so on. And I think that's one of the common issues that we hear from various sources that's holding up progress. I think what's disappointing about that is that that seems to have been allowed to outweigh the sheer urgency or the need for this harmonisation to occur. And I think it's quite disappointing to think that complexity, which I think there have been plenty of models put forward for how this complexity can be overcome, is somehow still being allowed to essentially stymie progress. And I think the committee has the benefit of the Office of the Public Advocate of Queensland's submission with a proposal for what that harmonisation could look like, and that's certainly something that we would support. And in very many, I would say, too many to count, consultations at the federal and state levels, the same advocacy networks, the same groups, including Relationships Australia, have been putting forward these opportunities and options, and yet it just has not seemed to progress to actual action being taken.
I think there's a structural ageism that operates to enable the persistent deprioritisation of these issues over the years. Because in other areas that are equally complex and equally high stakes, we do see governments being able to come together and iron out their differences. We had the benefit of hearing earlier this week from Commissioner Robert Fitzgerald from the Human Rights Commission, and he points to the example of the Australian Health Practitioners Regulatory Agency and the ability to come together as a nation to advance that. I'd also point to the ability of the Standing Committee of Attorneys General to come to agreement on model defamation laws, as noted in the SCAG communique from September last year. So it's possible, given the engagement, given the will to do it. Complexity does not thwart us in other areas, nor should we allow it to thwart us here, because we're looking at $175 billion a year of wealth transfer over the next 2 decades. We do not want that leaking out of the system through abuse.
And is it your evidence that the change that you recommend, which is the harmonisation of rules around enduring power of attorney, would prevent the forms of domestic violence and financial abuse that we are discussing today?
It is not a complete answer. And part of that is because we don't have a culture of having discussions around advanced planning, and that's something that we also canvass in our submission about normalising those discussions as we normalise discussions about getting your driver's licence and other rites of passage like that, getting a passport. So it won't be a complete answer for that reason, but also it won't be a complete answer because abusers are really clever and they will find other opportunities, but it is in our interest, from the point of view of social and economic cohesion, to ensure that our systems are as hardened as possible against abuse. It will never be the only answer, but it's something that we could do.
And we could. You're indicating we should. And why is that? Because of, what's the scale of impact of this potentially? We don't know.
And the reason we don't know is because we don't have a really rigorous evidence base yet on, for example, taking elder financial abuse as the first instance. We don't have a really good evidence base in Australia, or for that matter internationally, about the prevalence and nature of abuse and neglect of older people, its drivers, what makes people at risk of experiencing or more risk of experiencing financial abuse, or at more risk of perpetrating financial abuse. We have, in relation to abuse and neglect of older people, the landmark study by the Australian Institute of Family Studies in 2021 that indicated that each year 14.8% of people over the age of 65 will suffer some form of abuse. The highest prevalence of subtypes at that stage was emotional and psychological abuse at 11.8%, I think, and 2% of financial abuse. But I would also caveat by saying, first of all, emotional and psychological abuse is often a grooming tool or a leverage to be able to enable financial abuse. Secondly, there were several limitations of the AFE study that are indicated in their report, including that study did not look at people living in institutions such as residential aged care, nor did it look at people who were experiencing cognitive impairment, which we know to be a risk factor for all types of abuse. In addition to the AFE study, the Royal Commission into Aged Care Quality and Safety indicated a figure in the realm of 39.2% of abuse each year within residential aged care. So just to take that back for a minute, because I noted Senator Scarr's question to the previous witness about numbers, that 14.8%, Senator, translates to around 660,000 older people each year who will experience one or more subtypes of elder abuse.
Last question, and then I'll go to you, Senator Scarr, if you have a question, and then come to you, Senator Pratt. Thanks.
In relation to the power of attorney issues, I feel like often it's like case studies that help illuminate. From your vast experience, is there one particular case that demonstrates financial abuse and how a legislative instrument would have stopped that financial abuse from occurring? And you can take it on notice if you like.
Perhaps we should take on notice, I mean, from across our federation where services are provided to support older Australians who are experiencing elder abuse, there are a very large number of examples of this, and I think we could tap into our network.
Right.
I recall one, and you may wish to help, that occurred in relation to a number of adult children of an older person, and one such adult child having the power of attorney and using it, as you know, is all too common in these situations, to control the assets of their parent, unbeknown to the other adult children. And it was only when it was discovered that they were attempting to sell the parents' house and encouraging mum to move in with them that the other adult children got involved and said, what's going on here? What are you doing with those assets, and why? So in cases like that, very much an anecdotal example, but they occur right across the services we provide for elder abuse and are all too common.
Another example that I'd use that shows perhaps the interplay between psychological and emotional abuse and financial abuse was where the older person was living in supported accommodation, and often in the past aged care facilities have required residents to have an enduring power of attorney in place before they are given entry into that accommodation, and that's something that I know the Royal Commission looked at. And in this case, that older person had given a power of attorney to one of several adult siblings. And then the person who had the power of attorney then used that to deny access to the older person by the other siblings. And also said to the residential aged care facility, no visitors for mum. It just confuses and upsets her. So, and this is not uncommon. I just should say, I can see the expressions of surprise, and sadly the use of powers of attorney to isolate is not uncommon. So that's the emotional, psychological abuse. Yeah. And then that person who was the attorney was then able to perpetrate financial abuse and bleed assets away until somehow, the how is not revealed to us. Other siblings became aware and were able to challenge that. We'd also have instances where our clients have suffered because there's a lack of a national register for enduring powers of attorney. So what can happen is, you know, we're a country that has its fair share of natural disasters, and often crucial documents are lost in those disasters. And we had a client up in the Northern Territory who had made a power of attorney in favour of a person. Then there was a disaster, and another person came forward and said, oh, no, I've got a more recent power of attorney, which was executed in Queensland. And so then the whole matter became a fight between whose power of attorney won. A national register would be of assistance. Now, in fairness, I should say that I think it was in 2018 or 2019 the then government started work on a national register. However, that was against the advice of the sector. We said you might want to sort out the laws first and make sure we've got some kind of national consistency. And the government, no, it's fine, go ahead. And so for 3 years, we all worked in good faith on a national register. And then it was decided, you know, that's not going to work, we need to harmonise the laws first. So we lost 3 years there. And during those 3 years, people would be suffering from financial abuse.
Yeah, thank you. Senator Scarr, and then I'll come to Senator Pratt, and we want to try and wrap up here, I think, by no later than 10 past.
Thank you. Well, good on you, Dr Cochrane. Good on you. Can I congratulate you for your passion and for providing added impetus to finish something that has been on the agenda since 2003. And as you're speaking, the words of our former colleague Senator Kay Patterson, who served as Commissioner on the Human Rights Commission, were resonating in my mind as I asked her what when she came to the end of her term, what was one thing the Legal and Constitutional Affairs Committee should focus on, and she referred to this issue of enduring powers of attorney. So hopefully...
the spotlight's on it again.
Spotlight's on it, as it should be. One of the other associated matters, to some extent, is this development of the reverse mortgage financial product. So I'm wondering if you can provide some context of that, provide some commentary in relation to that phenomenon, the emergence of that financial product in the context of elder abuse, because I think it's pretty clear you can see, especially with house prices where they are, pressure being placed on parents, grandparents, to enter into a reverse mortgage, which instead of benefiting the owners of the property is in fact being used to benefit other family members.
Most parents want to help out their adult kids, and in a situation where we're seeing home ownership and the Australian dream of home ownership becoming more and more elusive to younger generations, I think that is not surprising, and I think that has to be seen against that prediction from the Productivity Commission of $3.5 trillion of wealth transfer. That's going to be part of it. And that's why we say in our submission that we expect the risk of financial abuse to rise sharply in coming decades. It underlines the importance of fostering more social cohesion, including cohesion between the generations. We see so much clickbait that is ageist, that is, I saw an article a couple of weeks ago that just horrified me, where a financial advisor was saying to older people, just move overseas where it's cheaper to live and rent your properties out for local. And I thought, that was just staggering. I found that a really distressing position to take. It's looking at older people simply as a resource to be leveraged rather than as a treasured and honoured part of our community and recognised for innate human dignity that we all have. I think the risks of products like reverse mortgages, it's going to increase because parents will want to help their kids, and this committee is a potential lever for putting some barriers into that very, very natural desire to make sure that it's not exploited. Mr Tibby?
Thank you. A piece of research that Relationships Australia conducted 2 years ago and conducts regularly is called Relationship Indicators, which looks at the state of relationships across the country and what are some of the common pressures that relationships are facing. And in that study, which is a nationally representative survey, it found that 20% of respondents were saying that financial and money matters were directly impacting their relationship at that time. And I think that goes to the point you've made, Senator Scarr, that cost of living, finance and the economic pressures of society are only increasing. We're very interested, that survey will be conducted again in August, and very interested to see how that's changed from 2022 to today, because I think if you look at the media reports and other reports, it's only getting worse. I think when you add that sort of pressure that's happening in society with the very real situation that Dr. Cochrane mentioned of parents obviously wanting to be there to support their children, and then throw into the mix the psychological and emotional abuse that we're seeing more and more. And I just want to highlight one particular example of that we hear a lot through our services, and that is the concept of contact with grandchildren, or as we often hear, grandchildren alienation or grandparent alienation. This idea that grandchildren are used then as a bit of a bargaining chip with the older parents of, well, if you support us financially, we'll make sure you still have access to your grandchildren and that you're able to spend time with them. But if you don't help us out, then we won't. That's a very real example of what's happening to older generations, that particularly and specifically because of the situation Dr. Cochrane has explained of, the way they are viewed as a resource rather than necessarily a treasure, is when you combine that with the pressures that people are facing, it results in some very disappointing and I think totally unsatisfactory relationship pressures and struggles.
And I would come back to my comments earlier about institutional, structural, baked-in ageism that are in so many of our laws and our social commentary as well, that incentivises seeing older people as resources to be leveraged. And, you know, the Australian government over many years has not taken a positive stance on an international convention on the rights of older people. But I do feel that such a convention would be useful in enabling older people to be recognised as rights bearers with innate human dignity for the duration of their lives. And it really is a matter, I mean, if we don't do it for our own naked self-interest now, we could try and do that for the benefit of our grandchildren and their descendants, so that we don't end up speaking about the use of older people as sources of financial security through abuse of instruments like reverse mortgages, like enduring powers of attorney.
Is there anything else that... Last question, yeah.
Sorry.
Thank you, Chair. Is there anything else that falls in that category of elder abuse where there are particular vulnerabilities? So we've got enduring power, and feel free to take this on notice, enduring powers of attorney, reverse mortgages. Does anything else leap to mind?
It can be a day-to-day thing. It doesn't have to be a big transaction like a reverse mortgage. It can be as simple and as slippery a path as I'm ducking out to the shops to get some stuff for Mum. I'll fill up the car while I'm at it. She won't mind if I use her credit card to fill up the car because she knows I'm going to get shopping for her. And then there's that it can become an increasingly enticing path, and not necessarily with malicious forethought, but just a sense of entitlement that I'm doing this for Mum, so look, I might get some stuff for the kids while I'm at it. She wouldn't want them to go without.
And that's particularly, I mean, one important point to note in that sort of example is that often the abuser, the perpetrator of the abuse, is not only not doing it from a particularly malicious perspective, but also because they themselves are often under a huge amount of stress. And Susan explained the typical sandwich situation of an adult who is both caring for their ageing parents and their children, and caught in the significant financial pressures and consequences that brings. And so I think it's really important to note, as Susan has said, that not all of the situations of financial abuse necessarily come from a position of malicious intent and desire to harm, but rather often through not having enough support in place for those people themselves, not actually understanding what are the drivers of perpetration of financial abuse, and not being able to then educate people about how they can, first of all, I suppose, educate people about what constitutes financial abuse, and secondly, what needs to be done to avoid it.
I mean, so that we do come back to the idea that, you know, as well as having consistent laws about enduring powers of attorney and a national register, having information and education resources for the principals, for attorneys, for witnesses. Sometimes what happens is that an attorney, you know, might be an adult child. They don't necessarily have legal qualifications. They probably won't. But they might not understand things like conflict of interest. They might not understand the nature of the fiduciary duty. And so having that kind of resource available would be something that could be done, which would be done much more easily if we had nationally consistent laws. But having greater resources available. I know there's some discussion about making people who get powers of attorney have mandatory training. I don't feel a lot of attraction to that, because I think we want to incentivise people and support them before we turn to more punitive actions, although I wouldn't rule that out, you know, in the long term.
Thank you.
Thanks very much.
Thank you. You've made a very compelling case. I'm interested in how we uplift the demand to get the powers of attorney reform coordination done, and then to ask, it seems to me that you would have looked at a whole range of practical solutions that you weren't able to implement for lack of that reform in the course of previous work done, and I think technology is probably moving even more quickly to say that there are probably even now more powerful tools, for example, with new banking products to alert a greater variety of family members, to and allow people with decision-making disabilities at least some control in terms of being able to make withdrawals for themselves with certain limits on them, and a whole range of things, particularly, for example, if you're dealing with a family member with addiction or whatever, that the benefits of that can work both ways, particularly in terms of also making it easier for people to uphold their responsibilities as someone with that enduring power. Could I ask what steps you would like us to take in terms of making recommendations in that regard?
I think that this committee is very well positioned to influence the central agencies like Prime Minister and Cabinet, Treasury and the Department of Finance to prioritise these matters. One of the limitations that the Commonwealth Attorney-General's Department faces in these kinds of projects is the lack of real leverage over the states and territories. And I mentioned before that Commissioner Fitzgerald alluded to the Australian Health Practitioners Regulatory Authority. One of the tools that is available to the Commonwealth Department of Health is funding, and the Commonwealth Attorney-General's Department does not have that leverage. So I've referred in my submission, in our submission, to looking at transferal to Treasury. There is precedent for that in various law reform projects that have had heavy commercial implications in the past. So that would be one option. But in terms,
it's got to that stage in order to get that leverage of the states. I presume
I've been talking about this for 20 odd years,
and there's been lots of media about this kind of exploitation.
Absolutely,
as well.
And there's support in the private sector as well. I mean, the Banking Association is a very strong advocate for harmonisation and for getting action on this. And Senator Scarr mentioned the former Age Discrimination Commissioner, Kay Patterson. Absolutely, a strong advocate. I think there are not necessarily surprising, but disparate groups within society who see this need and would support such a call.
Yes, Dr Patterson and Anna Bligh have been on a unity ticket on this now for some years, and that gave me a lot of hope, because usually when an institution like the Australian Banking Authority speaks, then the Banking Association speaks, then they do get an audience. But we are still having this conversation. But I did want to turn to Senator Pratt. You mentioned some practical tools. And in terms of prevention, identification, response and remediation, Relationships Australia is funded by Commonwealth and in some places by states and territories to engage with the community with a range of services, and that includes some community education and outreach. The Commonwealth funding, regrettably, is only in some very isolated places, so it by no means covers, there's no geographic equity in your own state. I think, Senator Pratt, you're from WA. There's services concentrated down in the Peel region, but not more broadly. In Queensland as well, postcode lottery rules. If you're experiencing elder abuse in Queensland, you have some very limited choices. And we offer services that centre the older person and that are driven by the older person and their will and preferences. We certainly work hard to ensure that supported decision-making rather than substituted decision-making is a reality. We offer services around that speak to particular comorbidities that might be affecting the older person, including their own physical health and any issues that they may have with social isolation, as well as with the older person's consent, any issues that the family members and the perpetrators might have. Gambling addiction is another one that I'll mention. Sometimes what we've seen happen is we'll see the breakdown of an intimate partner relationship and a protection order made against the perpetrator. The perpetrator then goes and moves back in with mum and dad and takes with them whatever comorbidities they've had, including a gambling addiction, including alcohol and other drug addictions, including mental health problems.
Yeah.
So we try and we can wrap around the whole family and offer warm referrals if needed, or services from within Relationships Australia to speak to that.
It's about affecting long-term change, often in elder abuse cases, as I'm sure you may have heard. The older the older persons don't necessarily want to end the relationship if it's their child that's the perpetrator. And so often a direct legal response, a criminal response, is not what they're interested in. That actually serves as a barrier to even seeking support. So a lot of our services are more about, as Dr. Cochrane has said, coming in and working with the whole family to affect change and lasting change. I think what's really critical to note is that those services are not available everywhere. And even where they are, there is a great limitation on abilities to refer as well. And a common example of that, where legal intervention is required, in some locations, including an example I can recall from our Western Australian member, it was absolutely essential to bring lawyers into a matter where elder abuse and financial abuse had occurred. But the legal bill, because those parents were not eligible, the elders were not eligible for legal aid, was going to be in the sums of tens of thousands of dollars, and that just prohibited taking any further action. And so we need a service landscape that actually empowers people to seek help when they need it, knowing that it's available where they are and no matter what they need. And I think this is an area where ageism and a range of other issues, we know the budget is not infinite, but where we need to be able to sew together a service ecosystem that actually is there to support older people when they face these issues.
Not to mention the fact that those legal bills perhaps could have been more efficiently spent on early intervention.
Absolutely.
In any case.
Yeah.
Thank you. Thank you, Chair.
Thank you very much. That concludes this session. I thank the witnesses for appearing today and for your evidence. Of course, there are a few questions I think I noticed, and there'll probably be a few more. If you could provide a response by the 26th of July, that would be much appreciated. The committee will now suspend, and I think we'll stick to time if we can, colleagues. Return at 2 with Commander Helen Schneider from the Australian Federal Police. Thank you. See you at 2.
Thank you.
Thank you. The Parliamentary Joint Committee on Corporation and Financial Services inquiry into financial abuse will recommence. I welcome Commander Helen Schneider from the Australian Federal Police. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you.
No.
Yes.
Yes.
Thank you.
Maybe to my colleagues.
For the Hansard record, will you please state your full name and the capacity in which you appear today?
My full name is Helen Elizabeth Schneider. I'm the Commander for Human Exploitation with the Australian Federal Police, representing the Australian Federal Police.
Well, thank you very much. Thank you for bringing your expertise to us today. Can I invite you to make an opening statement? And, of course, my colleagues and I will have questions for you. Thank you.
Chair. And thank you to the committee for the opportunity to appear here today. Firstly, I should like to show my respect and acknowledge the traditional custodians of the lands on which we meet here today. I pay my respect to elders past, present and emerging, and I'd also extend that respect to Aboriginal and Torres Strait Islander peoples present today. The AFP is absolutely committed to protecting Australian lives, livelihoods and Australia's way of life. As the Commonwealth's primary law enforcement agency, the AFP is responsible for investigating money laundering offences and plays an important role in Australia's anti-money laundering and terrorist financing framework. The AFP continues to target Australian and offshore money laundering organisations, transnational and serious organised crime groups and other groups dealing with illicit funds and property, as well as professional facilitators and their criminal clients. The AFP strongly supports reforms that will provide tangible operational benefits for law enforcement, enabling us to respond to the threat of money laundering and terrorism finance more effectively and to deprive criminals of their illicit wealth. The AFP also leads the Multi-Agency Criminal Assets Confiscation Task Force, which is the main Commonwealth authority responsible for investigating and litigating asset confiscation matters. and the AFP greatly benefits from the financial intelligence gathered under that regime. However, where the AFP readily identifies financial abuse is in the Human Exploitation Command, which oversees the AFP-led Australian Centre to Counter Child Exploitation, and in parallel provides the strategic lead for human trafficking, slavery and slavery-like practices. The Human Exploitation Command is supported by operational teams around the country, including our human trafficking investigation teams, our specialist joint anti-child exploitation teams and child protection teams. Financial sexual extortion or sextortion is a form of online blackmail where an offender coerces a victim into providing illicit images or videos, then threatens to share those images or videos unless the victim complies with their demands. In the last few years, those demands have been of a monetary nature. The AFP-led ACE is responsible for responding to sextortion of children and young people under the age of 18. And sextortion thrives on creating fear and apprehension in our young victims, which has led to underreporting of this crime type and significant health and wellbeing concerns for our young people who are affected. The AFP-led ACE, in partnership with AUSTRAC, have commenced Operation Huntsman back in 2022 in response to this first mass monetisation of online child exploitation through sextortion of Australian youth. The ACE-initiated financial action has resulted in the closure of several thousand Australian bank accounts used for moving sex-extorted funds offshore, significantly reducing the number of Australian child victims being targeted. The joint operation between the ACE and AUSTRAC demonstrates the AFP's ability to innovatively respond to emerging criminal trends and adapt to changing circumstances. The AFP, through the ACE, continues to collaborate with Commonwealth, state and territory and international partners to maximise operational impact, disrupt international criminal syndicates who are profiting through child exploitation, and to remove those victims from harm. The AFP also recognises the links between modern slavery offences and financial abuse, and has worked tirelessly across government and frontline law enforcement partners and sectors to raise awareness on the indicators of human trafficking and slavery offences, in particular through our Look a Little Deeper program. The AFP continues to build public awareness and encourage community engagement to ensure we reflect the interests of the community we represent and serve. We are obviously committed to growing a high-performing, innovative and future-focused policing agency that holds the confidence of our community, government and partners, and we will remain relentless in obviously keeping Australians safe. Obviously, I welcome any questions from the committee.
Thank you very much, Commander Schneider. And clearly you're a very productive policewoman because you talk quite quickly.
Oh, sorry.
Get through a lot. I wonder if somebody from your team might actually provide us with a copy of your opening statement, because there's a fair bit of detail there.
Yes.
If they could do it soon to an email, we might be able to get a copy in front of us to interrogate while we have you before us. If it's possible to work with the Secretary to get that copy to them now, they'll print it off for us. I'm shocked in parts of the evidence today about the breadth of forms of financial abuse and the innovation that's happening. Clearly, technology is a critical part, and you spoke about sextortion. Could you speak to the interface between the AFP and the financial service providers, particularly banks, with regard to identifying individuals who have behaviours that indicate that sextortion might be occurring?
Yes, I can. So we work quite closely with the banks in relation to human exploitation. You might have seen earlier this week we signed an agreement with the ANZ. We are embedding an ANZ's analyst into our intelligence fusion cell in the ACE, and we work quite closely with our intelligence fusion cell with industry. So the banks have been able to devise their own in-house built mechanisms to detect financial activity or transactions that are suspicious or indicate, financial abuse, and are able to report that. We've had some excellent success quite recently with direct referrals into our intelligence fusion cell, where we've been able to then directly interact with members of the public and stop that sextortion happening in real time. So,
okay, this is a really important thing, and I don't want to ask you any questions that would reveal anything that might give people who use this form of abuse any comfort or any ideas about how to get around systems. But they're constantly going to be innovating. We know that. What has changed that has made that data now observable to banks, and what has changed with regard to the bank's behaviour that's delivered these recent outcomes?
Well, we have had standing relationships with the banks. I can't speak to the bank's processes internally in relation to their commitment to technology that enables this kind of detection. But certainly from my perspective within human exploitation, there has been a growing relationship over the last few years where, in particular with even modern slavery offences, we've engaged through AUSTRAC and other agencies with banks to discuss and work through conferences, even for example, around what are the financial indicators in relation to human trafficking or different forms of modern slavery and human trafficking offences. I'm not sure, it could be a technology question, and that is really, I guess, for the banks to answer what investments they've made. I know that, for example, there is certainly a commitment to partner with us in relation to human exploitation investigations and offences and to help us with that crime type. But I can confidently say that that is definitely the current environment.
Mm. And when did that change or improve?
From my experience in the current crime type, there has been constant engagement with a number of banks. Obviously, that's not all banks, that's just a number of banks that we've worked closely with.
Okay. The problem with so much of this behaviour is the resistance to report for a range of reasons, financial, emotional, practical ones, like you haven't got access to a phone because you are being held in slavery. Are we at a point with that technology that now that impetus for the victim survivor to push the system is actually being met by a wave of the system being able to see the transactions and actually put a lifeline out to the person who's experiencing the abuse?
I think we're on the precipice of that position at the ACE in terms of, and I think that will continue to grow for us. Clearly with sextortion, coercion, threats are used as part and parcel of that methodology, which tends to mean that the cycle of offending continues until either it's picked up through a technological detection or, you know, a member of the public finds, or we have a child that self-harms, or there's a need for, you know, a response like that. So ultimately it is a blended situation. I think it depends on where a victim might be or where they might be located in Australia. For us, obviously, the financial institutions play a key role in helping us detect this and work with this and report through to AUSTRAC suspicious matter reports and transactions. But we need to appreciate that with this offending, it's not just the, I guess, the Australian banking system in itself that is used as a mechanism to pass funds. These type of crimes include payments by cryptocurrency, they include payments by gift cards, in-game credits we have seen. So there are different mechanisms for making these children to pay. So we need to be a bit multidisciplined in how we look at the issue from a law enforcement perspective.
So sex is the product, but the multiple forms of payment make it more complex.
That's right. Operation Huntsman was effective in hardening the Australian banking system to offshore organised crime that were targeting Australian youth. And those other systems of making payment are more clunky for organised crime. So I think it is really been a great financial disruption, Operation Huntsman, but it's been partnered with a very, very prolific prevention and awareness campaign with many partners, and it's been partnered with our engagement with our offshore partners in relation to targeting organised crime at the source.
Can I just put to you, in recent weeks I've been in a number of communities in Western New South Wales, and it's been reported to me that a form of financial abuse that is now being observed is the exploitation of young people for sex in return for purchasing things at the shop for them, even down to the level of a hamburger was one of the examples that was put before me. It's not just a form of financial abuse, it's a physical abuse situation as well, but there's a financial dimension to it that is extraordinary. Being paid in goods or food is beyond anything that I could have ever imagined would be happening. Are you aware of this problem?
It would probably, Chair, be more a situation for our state and territory partners that would be front-facing to that issue. Certainly when it comes to, the umbrella of offences that sit under the modern slavery bracket that we look at, there is definitely elements of financial abuse in many aspects of those, whether it's debt bondage, forced marriage, and deceptive recruitment and, slavery. There, I think from a Commonwealth perspective where we're seeing, but obviously we definitely see exploitative behaviours in our operational outputs that cross over. We definitely see crossover of exploitative behaviours between online child sexual exploitation and modern slavery. So I think it is fair to say that it's not unsurprising to me, but something that my state and territory colleagues would probably have more data on or know more around that issue.
Thank you. I'll go to you, Senator Pratt.
Thank you very much. Can I ask, with respect to the sex industry specifically, if the extent to which organised crime can be removed from abusive from being able to perpetuate abuse where there are properly regulated employment relationships and you're better able to distinguish someone who's in a coercive situation and participating in a black economy with organised crime, and the significance of the law reform that's happened in various places around the country, is that yet having an effect in removing organised crime from parts of the sex industry?
I think from AFP operational experience, obviously sexual servitude is still connected with organised crime. For us, I can't speak to what obviously my state and territory police partners are seeing when they're responding to these issues. But from our perspective, there is no doubt that there is a connection between human trafficking offences like that, where we've typically seen women targeted into those industries. There are mechanisms when we do respond to investigations, even working with our other government partners, but we have officers specifically trained in indicators of human trafficking, which would include sexual servitude indicators, because there are specific indicators for specific offences under that umbrella of offending. So we are working very hard in training our frontline responders and training our state and territory partners to identify what could be the difference between someone consenting to be in a situation and someone not. There might be, we've delivered our Look a Little Deeper program, which purely is for frontline responders. We've completed the rollout of that program last year, and we've managed to deliver that to over 16 agencies, including all our state and territory partners. So certainly my hope is that those skill sets and that capability will help with identifying the difference in those situations.
With the case of dowry abuse in Australia, the previous inquiry that I was on in the Legal and Constitutional Affairs Committee in 2018 saw examples of women married to Australian citizens and married in India, then all of their dowry and financial assets taken and then being dumped back in India with the shame of a broken marriage and all of their family assets stripped. Are you aware of those kinds of situations, and in what tools does the AFP have to get involved?
So unfortunately, forced marriage represents the highest reported crime type under our modern slavery offences. Last year, we received 340 reports that related to human trafficking, slavery and slavery-like practices, and 90 of those related to forced marriage. We see a strong nexus between forced marriage offending and exit trafficking, and the AFP has a number of things at its disposal to try and address that issue. We've worked very hard in the prevention space, particularly in raising awareness in schools, because we see a lot of the victims, over 50% of the victims are young women and girls. They are the highest victimology cohort, under 18 years of age. And we have a number of opportunities. We obviously look to work very closely through mutual assistance treaties. We work with partners offshore for repatriation and retrieval of those victims. We can work with our state and territory partners around guardianship orders. But one of the key things the AFP continues to commit across whole of government is our participation in the Standing Council of Attorney General's working group on the civil remedies around this issue. But we also perform the role of referring these victims through to the Support for Trafficked People program, which is a key part of our assessment when we meet these victims. We have a fairly low threshold in assessing the risk because we need to protect these people and we push them through. But obviously there's a lot happening in this space in terms of further supports coming through for victims of forced marriage.
At the time, though, it may not have been a perception in the eyes of the new spouse that it was a forced marriage and that they thought that what they were getting into was is a legitimate marriage. How do you go about supporting victims in those circumstances?
Well, there's the Support for Trafficked People program. Obviously, do you mean the partner who's then affected that's not been in a forced marriage? Sorry.
No, I mean the person in the forced marriage. You know, they're perhaps married, found in India. The family's got much excitement that this marriage is about to take place and someone's migrating to Australia. They might come in, have a legitimate marriage overseas, but come in with their spouse on even a tourist visa or a visitor's visa or a student visa, and they find themselves stripped of their assets. Our inquiry saw many such examples.
I think one of the key issues with forced marriage is it is highly underreported because a lot of the victimology that we see, the majority of our victims are, like I said, young women and girls, but victims who are Australian citizens who, have been forced to marry or have been not arranged, but, without consent to marry someone within their community enclave or someone that's known or related to them. So as a result, that adds an extra challenge in those victims coming forward. And if we do offer support, a lot of them don't want to go down any kind of prosecutorial pathway or criminal justice system.
Because they could lose their whole family in that context.
We make it really clear in how we talk about this more publicly to encourage these young girls to be recognised within their community groups, schooling groups, and then there's a number of supports that our investigators can put them in touch with. The issue for us too is the Support for Trafficked People program, is something that offers tailored support. So depending on that individual's situation, they might need legal advice, health, housing, finances, employment. So that help would be tailored through the Support for Trafficked People program.
I guess I'm interested in whether AFP can have oversight where the financial or domestic abuse is not where someone doesn't actually qualify as being trafficked, but there are intersections with Australian visas that make them open to exploitation, for example. Threats of cancelling your visa or dobbing you into, often when there's no foundation for, there's no truth about someone's power to actually do those things when they lie to their spouses about, I can get you deported and this kind of thing.
Our human trafficking investigators are obviously specialists in their training, so when they speak to these victims, they do run through all the options available to them. We're very victim-centric in how we approach it, and because we want to minimise harm, we can't just walk into households either and obviously remove these individuals, because we could create a further domestic harm situation for them. So all those conversations around options for them are put to them. what I would say is a lot of times I think forced marriage is masked by other situations like responses by our state and territory partners to domestic violence. It might be sexual offences.
Yes.
So a key part of responding to this issue, which is a complex one, is making sure first responders understand the indicators of human trafficking so they can have these conversations. Part of our Look a Little Deeper program is really about answering 4 questions. What is human trafficking? What are the indicators? Where would you likely come across it? And how would you respond with that victim if you did?
In the context of this inquiry, which is also looking at financial abuse, when you see forced marriages, trafficked people, or it's not yet clear the extent to which it is or is not a forced marriage, can you look to evidence of financial abuse, and what kinds of evidence do you see?
So with Commonwealth investigations that we would conduct, obviously it would be tricky for me to answer on behalf of State and Territory Police with what they're seeing, but we can conduct financial inquiries as part of any investigation. That might involve looking at any payments made, depending on the type of the human trafficking offence. It could be a debt bondage situation, slavery, people underpaid. So for us, we can conduct inquiries with banking institutions, obviously victim statements around what have been their access to finances or the controls over them. So all those would be part of, evidence in chief interviews with victims. We can make inquiries offshore through our international network.
So extortion of foreign relatives, for example.
So we can make, obviously it depends where we're operating in the world, but we have a fairly extensive international command which allows us access to make inquiries with law enforcement. We will need to rely on mutual assistance treaties depending where we are to collect evidence from offshore jurisdictions. But that is certainly an option open to our investigators, in terms of putting together a case or as part of a full investigation into what's occurring.
Thank you, Chair.
Senator Scott?
Are there any additional tools that you think the AFP requires in order to pursue this work? And I don't want to put you in a difficult position, but in terms of commenting on policy matters, but I'm just interested to know, maybe I can put it this way. Have there been any recent reforms that have assisted the work you undertake in this space, and things which we need to be aware of as lawmakers?
So the AFP certainly contributed with other government partner agencies to the targeted review of the legislation in relation to divisions 270 and 271. We always provide our operational insights about what we're seeing to help inform policy and legislation around that. So that has been a recent body of work.
Okay. So is there anything in that nature, any processes which are occurring now in terms of looking at various legislative reforms that the AFP is following from that perspective?
Well, the AGs leads the targeted review, and that is an ongoing process. So we have obviously contributed to that. I think from the child exploitation side of the house, we have robust laws that can be applied to the current scenarios that we're seeing. But I think as technologies change moving forward, AI, end-to-end encryption, and what that operational impact looks like, which is still really to be assessed, there may be a need to obviously engage with policymakers around what we're seeing.
Okay. Thank you, Chair.
Thank you. Ms Mascarenhas.
I'll jump back onto the topic that Senator Pratt was talking about and around child marriage and the lens of financial abuse. So I'm going to say that I'm naive and I didn't realise, I thought that you needed to be 18 to get married in Australia, but I understand if you're over 16 and if you've got parental permission that you can get married in Australia. Do you see many cases of marriages between the ages of 16 to 18 where maybe children have been pressured into child marriage effectively for financial gain for maybe their family or something like that?
Yes, that's my understanding is correct, like yours. So, but as I understand, you need a specific court order to understand that individual's, that child, or between the age of 16 and 17's free and full consent. But they must marry someone who's 18 or older, as I understand. I'm not aware of any of those specific cases that you reference occurring. So. Yeah, I can't comment on that, sorry.
The other question I was going to ask was around when you were talking about human exploitation and bank accounts that have been closed associated with that. Do you have a sense of the size of the dollars associated with that or the number of people trafficked?
So the bank accounts I was referring to was in relation to our sextortion response.
Okay. Yeah.
So that is really essentially targeting what we call money mules positioned here in Australia who are funneling sextorted funds back to offshore organised crime, which is predominantly in Nigeria. So that's more on the sextortion side of the house. And
do you have some dollars associated with those funds? And maybe that's a question on notice?
Yeah, I'm not aware if we can see if we have that data.
And can I clarify that you shut down the accounts? Did you take the money from the accounts?
No. So when we identify those accounts, working with obviously banking partners, AUSTRAC, action is taken to disrupt those accounts. It could be that money's already flowed through those accounts offshore, but as soon as we've identified them, then those there's been in excess, I believe, of 1,500 bank accounts that have been shut down. But that money may have already flown outside of Australia or been moved out of Australia.
So could you take on notice if there were funds in any of these accounts when they were shut down? And what are the protocols around that?
Sorry, can you...
were any of these accounts shut down with funds in them? And if so, how much? And then what happens if you do happen to interrupt a business, a money mill, sending dollars back to crime syndicates in Nigeria? What are our practices around acquiring that money and where does it go?
Yes, I can look into those figures for you and see if we have that data.
Thank you. Back to you, Ms. Mascarenhas.
For one of the submissions that we had earlier today, it was from the Women's Legal Service, and they gave a case study of a marriage, an international marriage, a marriage breakdown, and then the woman working for free in a business for 12 hours a week, which to me, when I read that, that sounds like slavery. Do we have a sense of the scale of maybe marriages that result in slave work from a paid work perspective? That's not the right choice, from an economic development as opposed to domestic work.
I don't have, and we wouldn't have those stats. Obviously, I can say we definitely see the connection between exit trafficking and forced marriage. Some of the slavery matters we've seen have been related to domestic, in domestic household situations. I guess for us, some of the forced labour matters that we're seeing, we are considered a destination country in terms of human trafficking. So I guess some of the forced labour is often connected with things like potentially debt bondage or deceptive recruiting. So it's hard for me to give you a breakdown in relation to marriages and work and that.
So you described us as a destination country. Are there particular reasons for that from a legal framework?
I think we're seen as probably a lucrative country. We're in there's certain industries where we see, trafficking in persons for forced labour and things that are more predominant, such as industries like agriculture, fisheries, manufacture. So there are industries that are more high risk, I would say, from operational history. So it is just, that can be a more organised type of criminality, whereas forced marriage tends to be a familial or community enclave type scenario.
I think that's
That's all.
Thank you. We received evidence a little earlier today by Ms Catherine Fitzpatrick from Flequity Ventures, and she gave us a map, and I'm happy to provide it on notice to you, which talked about how fraud and scam basically is perceived and the scale of impact. So for fraud, over a 12-month period, she said it was 677 million and 1.8 million Australians impacted. For scams, $2.74 billion and 601,000 Australians impacted. And that engages legal action and awareness and the justice sector. But when it comes to financial abuse, a very different model, same sort of thing, grooming, control, degradation, isolation, exploitation, all the things that you would have with, scams operating are actually happening, but they're happening with somebody with whom the person is intimate. And the financial loss that they have from sexually transmitted debt, ending up with, adverse credit reports, doesn't follow the same escalation to police engagement and criminality, and nor does it end up with recovery of funds. And the victim survivor ends up suffering, financial abuse, financial difficulties, hardship, credit report problems, etc. With regard to what you do, I get the sense that you're picking up these pieces at the end of a process. One of the things that was recommended by Ms Fitzpatrick was that the design principles to make sure that it's impossible for people to get basically into this situation, to make it far less likely anyway that they would be in a position where they're going to be abused. The kinds of financial abuse that you've spoken about in your evidence today, what design elements need to be changed further upstream to better improve prevention and therefore reduction in the kinds of crimes that you have to respond to?
Well, if I look at it twofold in relation to the work we do at the ACE, so online child sexual exploitation, it's my opinion that with technology, things like AI, end-to-end encryption, all those challenges mean that prevention needs to be a capability in its own right, and it means that this is a broader issue than just a law enforcement issue. It's clearly a social issue, and prevention in households needs to be a non-negotiable requirement to ensure that when people are sitting behind closed doors, or vulnerable individuals who are online, who might be engaging in conversations that result in outcomes you've just described, have the tools available to them, or can sense check that this could actually be a type of criminality. I know, for example, in relation to sextortion, on our ACE website, on our AFP-led Think You Know website, we actually have posted examples of what sextortion looks like on real reports we've received into the ACE, so that the general person, the general mum and dad, the general trusted adult will know what that looks like. Children know what that looks like. We've done a lot of work in campaigning, putting things on Snapchat when we really saw a dramatic increase in sextortion, really targeting teenagers themselves with animations of what sextortion looks like and how to report. I think
Have you seen a reporting increase as a consequence of that?
Well, when we did that campaign, which was over school holidays, we got about 5 million impressions on that ad, and we did it at a time when we thought youth would be online. And just last year, at the end of last year, we did a targeted campaign to teenagers in conjunction with Meta, No Filter and Kids Helpline, targeting a really renewed sextortion awareness campaign for kids who are using Instagram, WhatsApp and Facebook. I think we have to be relentless in continuing to take that approach. I know we run a very aggressive back-to-school campaign every year about things like sextortion, and last year we included forced marriage because we know schools might detect that. So I think this education prevention piece is really critical in, empowering individuals to be self-aware. I think there's other, obviously, law enforcement regulatory bodies such as e-safety who do a lot of work in relation to probably romance scams and things like that. But our state and territory police would be most likely to respond to those scams. The AFP does lead our Joint Policing Cybercrime Coordination Centre, and a part of their remit is prevention and awareness. I know they've done some work around scams and work with the National Anti-Scam Centre as well. So I really feel like with the challenges moving forward, that prevention and awareness has to be a capability in its own right, and it has to be, everyone's business.
And what does a capability look like in prevention and awareness, in your view?
I think it has to be enduring. It has to be
like sunscreen every day.
Absolutely.
Right? That's sort of permanence of mind.
Yes. Yeah? Well, we often, and we talk about this very continuously through our Think You Know program, is it has to be regular conversations throughout a child's journey online, because that journey will change and the threats that they've faced in the age brackets that they move through will change as well. So when you're a child, you might be more at risk of online grooming, playing a game, but as you move into your teens, you might be more at risk of sextortion. So, the risks that might change over a child's digital experience as they grow older is different. So we need to have regular conversations, and we work closely across government and with our partners around, one talk at a time. We participate as a collective in this kind of messaging. I think consistent messaging is important, and I think ongoing messaging is important. And I think we need to appreciate in any crime, which all the crimes I've talked about today, where deception, coercion and threats are an element of that offending, it will always be underreported and always be a risk. So we need the community to be able to, and people who are around these vulnerable people, to be able to identify that this is going on. Because these people are not always in a position to self-report, or are obviously often threatened that if they do report that they'll be in trouble, or that they themselves have committed an offence.
So coming back around to the first questions that I asked really about the technological visibility now that is embedded with AI tools for the goodies, shall I say. Not everybody will think of their bank that way, but banks and other trading platforms for other forms of currency, etc., have an opportunity to observe incredible amounts of data, to digest that and identify. How engaged do they need to be, and how broad does that engagement need to be for us to create the static on the line necessary, so that it's not a report that we respond to, it's a prevention that just blocks the behaviour?
Yeah. I feel like and I reiterate what I say, I really feel like we're getting to that point now with quite a few of the big banks. They do have in-house designed, tools to detect suspicious behaviour that might be akin to sextortion. One of the key parts of the role that we play at the ACE is when they are reporting, those things through in real time, we always provide feedback that, yes, that tool is working, yes, it's worked, we've detected something. So it's important, I think, that information exchange between law enforcement and banks to make sure that the tools that they're using to detect these suspicious transactions are fit for purpose. I also think, if we do see changes in methodology around this kind of online offending, that we're sharing that with the banks so that they can actually make sure they continue to design and build in-house mechanisms for detecting these types of suspicious transactions that are linked to victim abuse and obviously financial abuse.
It's a while since I've sort of thought about setting up an account with kids, and I guess the question is, are there now digital locks that can go onto accounts where parents would have to be a signatory to prevent people from being extorted, young people in particular? Are there any products of that kind? Are the banks talking about anything like that?
I haven't had those discussions with banks, and I'm not sure if they exist or don't, but a key part of our, conversation around prevention to parents with sextortion is, regularly checking your child's account for suspicious transactions or transactions that you can't make sense of. So
I don't know what the rules are about young people and having their own accounts. I expect if, 14 and 9 months and you're working, that you'd have your own account, there'd be a degree of independence that is really powerful and a wonderful thing to experience, right? Yeah. But I suppose in the environment that we're in, where we're seeing malign actors come in where people can't observe, there needs to be some kind of protection. If it's not the parents, then perhaps it's now the responsibility of the entity that's providing the platform that creates the risk.
Yeah. And I guess I can't really answer what rules I have in relation to guardian requirements for child bank accounts, so I'm not across that. And I haven't had those conversations with the banks.
With regard to financial abuse of people who have been lured to Australia to do a particular kind of work and then end up doing something completely different, and too often with women, sexual servitude, what are the banks doing about that, or telling you about that reality? Do they have any insights? Do they have any information that flows through to you about those sorts of situations?
I've not seen any intelligence from the banks in relation to those situations.
Okay. When individuals set up sex services and have a workforce where there's no payment going to those individuals, surely that must be observable in some way.
I'm sure it would be observable in some way, but probably not by an agency like ours unless we were brought in to investigate a situation.
Which
and then
is a post facto, and we want a
Correct.
pre facto response.
That's right.
A system, rather.
There's probably other agencies that would better be able to answer the reporting requirements for, wages. For us, it would be an after-the-fact situation where we're coming and conducting an investigation. We make financial inquiries.
I guess where we see the risk embedded, and you named horticulture. So if you're running a horticulture business, you're running a sex services business, that there might be some contractual arrangements you might have to have with a bank that are a little different from other lower risk industries, where if it becomes known that you are not paying, there's a trigger of some sort to engage with the AFP. Are there any of those design elements anywhere in the banking system, to your knowledge?
I know historically there's been discussions around some of the financial indicators of human trafficking. Might be payments all to one individual and then multiple individuals take money out. So there's different indicators for different type of human trafficking offences. I know through the Fintel Alliance, historically there's been some intelligence reporting, but there's always scope to look at what we're seeing currently and to continue to work in that space across agencies. But there has historically been some intelligence reporting in relation to human trafficking indicators and finances and what that might look like for banks. So I think through those kind of mechanisms there are discussions, but there are across crime types as well, not just related to human exploitation.
Because if you could have a look at the evidence we got from Miss Catherine Fitzpatrick, there were the opportunity for change in the contractual relationship with the bank, where there would be breaks and potential recourse to action if you used your account in a way that is at odds with what the law requires. And then there is some sort of a trigger point in the financial transaction system to make sure that you just can't use the bank in the way you're currently using it, which is grossly exploitative of could be quite a large number of individuals, or it might be just a single individual.
So banks, if they have their own, if they detect anything like that they put through suspicious matter reports to AUSTRAC, and that's their reporting obligation. So there is mechanisms in place to report transactions that are suspicious or might be indicative of certain criminality. We work with AUSTRAC in relation to referrals. We do across crime types. We can get referrals from AUSTRAC and other agencies, but that is the requirement of banks to report that through to AUSTRAC. So AUSTRAC might have more information on, what they're seeing in relation to this specific crime type come through.
If we haven't got AUSTRAC on our list, we might actually have to think about calling them, because it's quite important information. Obviously, there's been some questions about dowry, and there were also questions earlier from the Deputy Chair, Mr Hawke, about multi-generational mortgage holding and somebody not being just in a relationship with one financial abuser, but perhaps a whole family with one person who's married in, so that the money's pooled to purchase a property in a high real estate price environment, but the capacity for moving is pretty small. Is that a situation of financial abuse that the AFP might be involved with, or is that much more of a civil matter?
I think if it's linked to like a domestic violence or fraud, it's probably likely to sit more in the state and territory space, or unless it's sort of a civil dispute over property, then it could fall into another sector. It's not really in the remit of the AFP.
Where would it, if this involves community connections to other jurisdictions, is that when it triggers the AFP's engagement?
It triggers AFP engagement when it justifies a Commonwealth offence that we would have jurisdiction to investigate. We do work closely with our state and territory partners, because with any offending there could be elements of state and territory offending, or combined with Commonwealth offending. But we're more likely to get involved if it triggers a Commonwealth offence that we hold primacy for investigating.
Could I ask you to take on notice then the sorts of particular types of financial abuse that trigger your engagement, and maybe give us a comprehensive list of what they are, and if possible a few examples?
Yeah, no problem.
Wonderful. Thank you very much. Can I thank you very much for joining us today, Ms. Commander Schneider, and we have some questions on notice there. If possible, if you could provide responses by the 26th of July, that would be helpful for the committee. Thank you.
Thank you.
I now welcome representatives from the Department of Prime Minister and Cabinet, the Department of Social Services and Services Australia. Thank you. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full names and the capacity in which you appear today? We might start with you, Ms. Rahman, is it?
Thank you, Chair. Padma Raman, the Executive Director of the Office for Women in Prime Minister and Cabinet.
Thank you.
Thank you.
Thank you. Kirsty Faishny, Deputy CEO of Program Design in Services Australia.
Thank you.
Afternoon, Chair. Patrick Burford, Group Manager of Communities in the Department of Social Services.
Tim Crozier, Branch Manager, National Policy, Ending Gender-Based Violence.
And Ben Peoples, Group Manager, Participation and Family Payments in the Department of Social Services.
Thank you. Thank you very much indeed. Do any of you or all of you have opening statements that you'd like to provide?
No, we don't. No.
Okay. Well, I'm going to go straight to my colleagues for questions. We have allocated, I think, time. Let me just double check my little list here. Got an hour, I think, for this session. So I'll go straight to you, Senator Pratt.
Thank you. I might begin by asking Services Australia and DSS, in the context of the history, for example, of the cashless debit card and the smart card, there was a lot of money invested in merchant blocking, etc., some of which could be applied to the banking sector more broadly. Have you been able to harness any of those technological innovations and work out how to work with the banking industry and other regulators about, for example, how someone who might like to opt into those kinds of financial protections but is not might actually be working and might be getting family payments, or may not actually necessarily have interactions with the social security system at all. Nevertheless, there are innovations there that could be applied. So we know banks can block liquor or tobacco or limit cash withdrawals. I guess I was surprised to see a history of that being focused around people's social security accounts rather than actually being able to protect Australians, including those inside the social security system, more efficiently.
I'm happy to start, Senator. The programs that we've delivered there has been in the context of the cashless debit card and now the enhanced income management that's been made available for people who volunteer, who's come off that card. So it has been only in the context of those people on some form of income support. I will say, and that is, as you said, the technology through what was the previous cashless debit card and then now the enhanced income management smart card to allow for certain products and merchants to be blocked based on that technology and product level blocking. So we haven't really explored what would be available for those who aren't inside the income support system. However, in some consultations I have heard people say this would be great, something like this would be great for people in full-time employment and the like as well. So that has anecdotally been heard through the time, but the context of the policy, we haven't actually had direct discussions with banks about replicating such capacity for people outside that system.
Okay, so it could be possible, for example, for government this committee to recommend to government that work be done. And I guess in the first instance, you could say, all right, so if someone's receiving an aged pension, they've got a child living at home with them with an addiction, that they could. And we've heard from Relationships Australia earlier today about the kinds of supports they like to put in place, but there aren't necessarily protective banking solutions really available in that kind of situation yet. How can you help us phrase a recommendation to government around those issues?
Ms. Fagan.
Just some thoughts around that, CS Kirsty Faishni. I think Treasury is coming, so it is an area that I would certainly think they could start a conversation, considering they have got the banking sector as a key stakeholder in there. I take exactly what Mr. Burford has said on if it's outside of if it's an income outside of what the government is providing, then yes, it is going to have to be led by the banks. But I think it is an area, from what we've seen in the cashless debit card and now into the smart card, there is functionality there that may be of value to others if they wish to be able to somehow opt in.
And Senator, just to also flag, and there's quite a few people across the country, mostly in the Northern Territory, still on the original income management scheme. No new entrants will enter that scheme, but at the moment, similar type arrangements that's been done through relationships with particular merchants, so not done by the technology, but done by relationship with merchants, attempts to facilitate the same sort of protections or blocking of certain items as well.
Can I ask, have you had any conversations or dialogue with the Commonwealth Bank? Historically, they have been the bank that, for example, people living in West Australian remote communities would use because it's, it was the government bank and their social security, for example, has remained attached to that. But they don't seem to have their policy offerings to those populations are the generic ones that are the same to everyone else, rather than being able to look at the specific circumstances that financial exploitation or abuse might occur within, that clearly the department responded to historically with these cashless debit cards. Is that something that you have looked at in these contexts?
Not in the context of the cashless debit card and income management, as Ms Fashanu mentioned. I guess it's been around the...
But I guess I'm saying you understand the issues.
Certainly do.
But I guess I'm asking if we're going to have products developed that can support a broader subset of the population, but also not have, racial stereotyping or opt-in jurisdictions attached to them. How do you get banks to begin to understand these issues and offer products? And have you specifically spoken to the Commonwealth Bank about that?
Yeah, so not on that specifically, Senator, but we do work with them with regard to financial counselling. We do work with other banks in partnership with non-government organisations regarding saving programs and financial literacy programs. So we could talk about that later, but there are engagements in the terms of broader financial wellbeing and literacy. But in terms of specifically the technology and those protective mechanisms, that might actually be better for Treasury to actually touch on in terms of that relationship.
Right. And could you ask Treasury or yourself to, I guess, use the kind of insights that the Department of Social Services or Human Services has to see if banks can apply that lens to banking so that exploitation can be identified?
We can certainly connect with our colleagues at Treasury, yes.
Thank you. Thank you, Chair. There's lots of other things to ask, but I'll rotate the call.
Exactly, thank you. Ms Mascarenhas.
The two questions. I'm curious to understand from a Services Australia perspective the tools that have been the most useful from, let's say, a client's perspective at supporting someone going through financial abuse, but also what gaps exist that could help Services Australia be more effective at supporting victim survivors.
As I wait for, and possibly Ms Robinson as well, to come to the table. So yes, for Services Australia, the majority of our way of working is to train staff to identify where financial abuse may be happening and to understand those situations which are more likely to possibly lead to financial abuse, and in doing so then have a referral process to support the individual who may be undergoing the abuse. So on that, I just thought this is the reason, so we've brought some of our service delivery colleagues as well as our program colleagues to the table. We have a number of ways that we do support customers who may be experiencing financial stress as opposed to financial abuse, but we have a very strong social work network who are engaged closely where we do suspect there may be financial abuse occurring. And I just might ask Ms Robinson just to expand a little bit. No?
Oh, no, I was just going to add what my next question was going to be is whether you have flags in your systems to see financial abuse as well, and if there's things that could happen to make it easier to see those flags. So you can answer all of that.
Very happy to talk to that. So,
Ms Robinson.
Yes, Jodie Robinson. We have a significant network of social work services that support our frontline staff in Services Australia, and we receive around just under 100,000 referrals a year in relation to family and domestic violence. So our social work services, the response is really varied and depends on the customer's presenting circumstances, but broadly it's about working with them to understand their circumstances and undertake safety planning and assist them where there's risk that exists right across all the ways that family and domestic violence is perpetrated. So in relation to financial abuse, there's a whole range of mechanisms that we can support the customer to utilise, and it's very broad. We do have indicators in our system. We have a range of indicators in our system, and including in relation to family and domestic violence. So that information is evident to all of our frontline staff when they're engaging with the customer, and it really triggers the staff member to be thinking about family and domestic violence in the context the customer's presenting, and to refer back through to social work services as well. So some of the things very practically that we would assist customers with might be things like putting a password onto their account. So if they're engaging with us via the phone, they use that password. That's an extra protection. We talk to them. We have publicly available information about if they're separating all of the steps that they should work through in order to do that safely. So relates to establishing, ensuring their identity is safe, separating their records, letting us know about family domestic violence, all of those types of things. Our social work services also provide specialist assessments as well across a range of our payments and services. So crisis payments is one of those, but we also do exemptions from the maintenance action test for child support, and we're involved in terms of debt recommendations for debt waivers, for example. So the role is fairly broad, and it really does depend on the customer's presenting circumstances.
And I might just add some of the challenges we have, and we have raised it in other Senate committee hearings and such, is around what you were talking about there with flag and the ability for the flag to present to the service officer. We do collect the information in a range of different ways in a range of different systems. So I think it is fair to say that it is not a consistent approach, which can be challenging for us. But I would also say that there is work underway at the moment, and working with the community as a result of some recommendations that have been provided in other fora around how do we more consistently identify vulnerability, noting that as an agency we don't classify vulnerability as being enduring necessarily. It can be transient and depend, as Ms Robinson said, on the circumstances presenting at the time. But we are keen to look at how we can actually drive consistency within what are not necessarily, systems that can accept consistency, but how do we lift that so that we can provide the staff with more, with a clearer indication when somebody might be presenting, and equally remove those indicators because of the transient nature at times. What does that look like? So we are actually doing some work in that space at the moment. Did you want to say any more on that? Don't have to.
Afternoon, Senator. I'm Tony Piazza, General Manager of Families, Indigenous and Tailored Programs. Just leading on from Ms Vashni, we're currently doing a range of consultation with external bodies such as EJA, financial counsellors, ACOS would be another. We've recently held an event within the agency as well that has a very big theme around vulnerability and how we actually better manage that with customers who present with vulnerability, noting Ms Vashni's comment about being transient in nature, how that flows through our system and the type of engagement that we should be having with customers. And that will also go to our design of services, whether they be new or changes to existing ones as well. I'd probably just add that.
Do you also have line of sight of elder abuse within your products?
It would fall under, so just to step back ever so slightly, so we would consider financial abuse and elder abuse to be a subset of family and domestic violence, and staff are trained with that knowledge. On elder abuse specifically, one area that I am aware of, so we have what we call aged care specialist officers who are supporting people who may be looking to move into more assisted care or looking to consider what supports might be available as people are getting older. And I do know that as part of their consideration in those conversations is to look at what's being presented to them and consider is there any risk here that there could be elder abuse or financial abuse happening in the conversation, and if there is, then they would do exactly as Ms Robinson said, and you start to look at the referral to the social workers for a little bit more. But it is through some of our aged care work that we would certainly have an eye on elder abuse.
I'd probably just add, we have a lot of obviously training packages for our staff. In terms of this context, two of the most significant and mandatory training for all our staff is around vulnerability and also around family domestic violence. And the elder abuse componentry probably comes under that vulnerability training, and there's a whole range of modules that are mandatory for our staff to actually complete. And that's obviously about staff uplift, that we can actually try and identify some of these signs, which helps us if necessary, put flags on or text against customer records.
Thank you. So many questions. In terms of perhaps somebody in the country, there's social work has been mentioned as a sort of a wraparound type service. One of the things we know from health inquiries is the vulnerability of communities that are further from the cities. You know, if you want to have a mental illness, make sure you live in North Sydney because that's where you'll get the service. Social workers are equally ill distributed across the country. We've got blockages in the workforce. The loss of proper training, planning over the last decade has resulted in a mismatch of the need of the country with the skills that are readily available. ASIC, their submission to us, I don't know if you've had a chance to have a look at that. We know that they're concerned about hardship engagements with banks, what's going on there, people having to retell their story, re-traumatised over and over and over. Given the constraints for social workers, given the different capacities of systems across which you have to work and no harmonisation really there, what does it really mean if I walk into Services Australia at Hay? I mean, I don't even know if there's one at Hay. I've been to Hay, but I don't know. I haven't looked for Services Australia. But let's just say, for the argument's sake today, I go to Hay and I go inside and I meet, you know, somebody fantastic. They've done all your vulnerability training. How likely am I to get a social worker to interact with me in Hay?
Yeah, so we have over 600 social workers across the country in over 200 of our service centres. And
how many service centres do you have?
So we have a bit over 300.
So 2/3 are covered off?
So 2/3. And so there's a couple of things. We also have social workers networked right across our phone networks as well. So regardless of where you present, whether that's in a service centre, on the phone or through our digital channels, in fact, there are referral pathways through to our social work services.
Okay, so let's just say, Hay, this non-existent Hay one, right? Yeah. I go in there and there's no social worker actually allocated.
Yeah.
Can you talk me through what would happen to me, what signals I would be giving off to people to go, oh, look, this could be a financial abuse situation, and then what's going to happen to me in one of those centres where there is no one?
Yeah, so all of our staff are trained in the risk identification and referral model, and so across all customer interactions, our service officers are trained, and it's mandatory training across all of our staff, to ask a question along the lines of, are you or is anyone concerned about your safety? So that's one of the very proactive approaches that all of our service officers take. And then, you know, our service officers are well embedded in community and are actually quite good at identifying some of the signs related to family and domestic violence. So,
which are what, Ms. Robinson?
So a whole range of presentations that could actually. There's a range of servicing patterns that could exist. It could be.
So that's data that you would have about interactions?
Data, but also the types of services and payments that they've sought over time.
Okay.
And the arrangements that they might have in place in terms of potentially some nominee arrangements that we would be
concerned about. Okay, so can you be a little more specific about what that looks like so I understand what you're saying?
Yeah, sure.
Yep.
Okay, so a person might present, for example, in a service centre, and a staff member might be triggered by things like frequent changes to bank accounts related to the payments that they're receiving. It might be that their payment's going into a bank account and a person is accompanying them to appointments all of the time or into the service centre all the time. It may be that they're unable to speak on their own behalf. It may be that there's a nominee arrangement in place where someone is allowed to contact the agency on that person's behalf, and that person's, you know, seeking information or seeking types of payments like advance payments, urgent payments on a frequent basis that we would become concerned about. It's quite varied in terms of the things that our staff might see and that then might trigger a referral to social work services. So we can, and staff do, put people on the phone in our service centres directly to a social worker.
If I'm there by myself...
If they're there by yourself.
I might be able to do that. But if I've got somebody beside me who is absolutely controlling me, then what happens?
So what they will often do, our staff will phone one of our social workers and consult with them, talk about the types of behaviours that they've seen, and then the social worker will be able to give some advice about appropriate approaches. We'll review the information that's held on the customer's record, and if we are significantly concerned, we can even do things like release information to police if we think that that's warranted and there's serious concerns for someone's safety. Again, it's very dependent and individualised on the person's circumstances and their presentation at the time.
Okay.
We also have social workers embedded in...
Sorry, just before you go on with that.
Yep.
Is it possible, given the system differences that might be operating around an individual, that, at Hay, with this one interaction, something's been signalled, but it's not contemporaneously signalled with all the other government entities that they're engaging with, all the different systems across government, and that correspondence or communication in some digital form might go to the perpetrator of financial abuse accidentally?
We have seen occasions of that historically in the agency, and where they're identified, we absolutely work to respond and support the victim, and then we use that information to continue to strengthen some of our systems in the agency.
So where are you with system correction to make sure that a vulnerable person who comes in is identified, doesn't have an increase to their risk because they've engaged with their government? They're going to leave the easy questions for you, Ms Fakeney.
No. They're for all of us.
Yeah.
Services Australia. And they're not unknown. Of course, there's always a risk of staff error around these, but we are a large organisation. But I would say some of the broader risk is, yes, the opportunity for there to be, whether it's tell us once or lined up, but we do detailed work to try and minimise where we can see systemic areas of risk. And we've done some work around separating safely and a few other areas, but I assume that's where you were going to be heading.
Mr Piazza, separating safely.
It's a package of work that the agency's undertaken over about the last year and a half to 2 years. And I suppose the context is partners have split up, and it's ensuring that our systems have recorded that correctly, so that we're not, in the example, Senator, I think that you mentioned, we're not inadvertently sending correspondence to the other party that could perhaps use that information to do harm on the individual. We've worked through a series, I think it was about 18 recommendations that we actually worked through. Our systems aren't linked in terms of if you make a change here, it'll flow through in the proper sequence in terms of changing addresses for partners and if there's children involved and those types of things. So we've worked through a very procedural basis, step by step, that staff need to follow. And it is complex. It's not a simple process. It has seen and we've mentioned that yes, unfortunately, there has been instances in the past where the agency has provided information to an individual that's it shouldn't have, and this work has seen a marked reduction in terms of that occurring within the systems that we're working on. And I say within the systems, I suppose when considering, effectively we have three major systems within the agency: the social security system, child support system, and the health systems, and they don't necessarily share that information for a variety of reasons. A lot of them have to do with legislation and privacy, as neatly or as well as what one may hope.
So I come into Hay, let's go back there. the social worker engages in some way, there are now there's a flag on my system, on the social services system.
There may or may not be. It will depend. It's very individualised. It'll also
So
depends.
assume that there is,
Yep.
and then the next thing is, how are you going to let child services and health services know, is that your responsibility? Or if it comes to any one of those three systems, who takes responsibility for prioritising and actioning the next phase of system response? And on how many instances, will this happen per annum?
So this is the training that the staff go to, which is if they are making changes in one area of a customer's business, they do need to consider, do they need to make changes to, say, Medicare details to reflect what's being told for the other, and they will need to consider if there is a child support case relevant to this, what does that look like? So there is a requirement to consider the customer as a whole, not the customer as a member of certain programs themselves. We very much take a whole of customer view to try and ensure that these things do happen. Sometimes it can just be trying to work out what changes are required based on the circumstances that are presenting. For example, not everyone would need to move to a new Medicare card. It may just be being sure that we're aware of why they've come in and what they're looking for and what other system changes may be required at that time.
Right, and it's 3:20 on a Friday afternoon. I'm at Hay. This is happening. Yeah. When's all this going to be triggered? And it sounds like there's a series of protocols that we've followed. Yeah.
Yeah, at the point of contact.
Yeah.
So as Mr. Piazza was saying, there's significant procedures for staff to work through with the customer. That information is also publicly available to the customer themselves, so they can access it. And there's a range of steps that we talk people through and that we action for them on their behalf within our systems. And it goes through their Centrelink information. As Ms. Facioni was saying, it goes through their Medicare. We talk to them about their MyGov account. We talk to them about opportunities to strengthen the protections, such as the use of passwords and changing passwords. So there's a number of steps that we talk through with people, and we action that on their behalf. And we also take their advice around the timing of doing these actions so that it doesn't alert a perpetrator to those changes in the system, so that they can speak to us about doing that at a time that's going to mean it's safe for them to do so.
So I've positioned myself as a good actor in this, coming in seeking assistance. But if I'm a malign actor, can I just trigger the same responses and then actually cut off access to services for the person I'm abusing?
I didn't quite hear the beginning of your
So I positioned myself
question.
as a good actor,
Yes,
right?
yes,
Coming in
yes,
genuinely
yes.
in need, seeking
Yes.
support. But the system's going to respond to what I give it. If I'm a malign actor and I show up at 3:20 on a Friday afternoon and I pretend that I'm a victim when actually the perpetrator, can I set in train the same sort of processes?
The first engagement with anybody that presents at a service centre, including in those rural areas, is to establish their identity. And so that's the first step. It's critical that you can appreciate that we're maintaining people's identities safely in our systems. And so there's a series of questions that people work through in relation to their identity, and there's additional identity questions that we would ask if we are concerned, and depending on the presentation.
One of those questions wouldn't be, are you financially abusing your partner, right? But you've got to have some way to actually make that discernment at some point in this process, surely.
Well, if a person, for example, if we were concerned that the person didn't match the identity of the record,
that's
the
a big
individual,
red flag, yeah, right?
Yep, then we would absolutely do that. So that would be a really big red flag, and I think all of our staff are very cautious about engaging in activity in our systems if they've got any concerns about the person that's presenting, because it's fundamental to maintaining our systems.
So these are complex human interactions. They really rely on human insight and endeavour to be able to be discerning, because there's no system that can actually capture that complexity, really, is there?
Our staff are a significant front line, I think, in detecting this, absolutely.
Okay. Do you believe that your staff have sufficient skills to identify financial abuse at these points of interaction?
I think that is part of the training. Whether it's sufficient, I would say it's...
I was a teacher, so I know there can be the curriculum, there's the delivery, and then there's reception, right? There could be a big breakdown.
And part of me goes, we would always look to improve if we think there are better ways to identify financial abuse, and we would certainly take any advice around them. But part of the training is exactly as has previously been advised, is to look for the triggers that could be the reason for it. So child support is a very obvious area that we would consider looking a little bit more if someone was in the middle of or had an active child support case.
So I've got an article here posted 25th of June 2024 by Alison Branley and Connor Duffy, which takes us to the child support payments, and I think the Secretary will provide you with copies of that now. While that's getting to you, I note the final line of the article says, well, actually, the final three parts give a bit of a frame of what's going on, that Services Australia have indicated 168,000 parents referred to the ATO included anyone who had not lodged a tax return in the past 5 years, were referred multiple years in a row or had historical debts. The ATO spokesperson said in the second 6 months of 23, it made almost 1.5 million attempts via texts, emails, letters and phone calls to contact taxpayers with outstanding returns who had child support debts. And finally, it says in the recent federal budget, the government allocated $5.1 million for a series of reforms, including review and compliance in the child support scheme with a focus on collection and enforcement. So let's talk child support, tax return manipulation, and the capacity of the system that you operate to respond to real and practical despair, need and abuse. What can you tell me?
So Ben Peoples from DSS. And as referenced in that article, there's a whole range of reforms that are underway, so I can provide a bit of information on those if that would be helpful, and then can talk a bit about lodgement and compliance arrangements within the scheme, with perhaps some assistance from Services Australia, noting a lot of this would also go to Australian Tax Office as well.
Yes. Well, the article does talk about multiple tactics used to avoid these payments. When you see these tactics, are they part of what triggers this sort of social support response? Like how clearly can you see financial abuse indicators out of the other systems across government?
So on the child support side, and I'll defer, so we have a strong working relationship with the ATO, which is what's basically been outlined here, as to where there is systemic failure to lodge tax returns, which means where there is an active child, or even an inactive, quite frankly, child support case, where they can go through what's called basically the non-lodgement process, and the ATO will specifically be looking for those. So we have system to system absolutely around the ability to identify in our side people who are non-lodgers who have an active case, and to work with the ATO in one way to see whether we're able to secure funding for the child via the tax return process. But we also have the ability to, to use other methods within the system in absence of those lodgements until such time as we are able to use the tax system. But I might actually ask Mr Piazza just a bit more detail around the way we work on that.
Thank you.
Thank you. Thanks, Senator. You're probably aware, 95% of customers in the child support pay their liabilities.
Because happily most people do love their children.
Yeah. We do have, as Ms Fashni referred to, there's the non-lodgement of tax returns. We have a lodgement enforcement program that the ATO run, and where people haven't actually lodged their tax returns, that information will be provided to them. And generally people have a year to lodge their tax returns in that space. I suppose to give you, and sometimes there's very valid reasons why people don't lodge their tax returns. I mean, if you look at the 21-22 financial year, within the child support space, 88% of customers met their tax obligations. We do have a range of ways to assist us in detecting and enforcement measures for those who do fail to pay, and they include deductions from wages. You may have heard refer to the term single touch payroll.
Yes, single touch payroll's changed that dramatically. Yes,
absolutely. We also have the ability to garnish through tax refunds and also bank accounts. And there's also the ability for the agency to issue departure prohibition orders for individuals if they're leaving, travelling overseas. And on top of that, we are able to pay penalties in terms of late lodgements.
Okay. Mr Peoples, did you have anything further to add?
No, the department's doing some work with Services Australia and ATO, as well as part of the response to the Joint Family Law Inquiry in regards to a number of areas. We've established a child support stakeholder consultation group and a child support expert panel, and that child support stakeholder consultation group is taking a strong focus on compliance arrangements, given it is so important to a number of those stakeholders, and there's work underway between those agencies that I've mentioned as well to look at how compliance is working within the scheme, looking to see if there's options to prevent debt arising in the first place, and how the accuracy of incomes is used in child support assessments, looking at different compliance options, particularly around persistent failure to comply with tax lodgement obligations, and how powers for different agencies work as well. So there might be that work's undertaken over the course of this year, and it may be an opportunity we can provide further information to this committee as that work progresses, and draw more information together.
Thank you. In this article, if you could flick over to the page that features Catherine Devine, it just starts at the top, says cash is a huge problem, particularly for tradespeople. It's a big problem. The Women's Legal Services Review found there was even a website where paying parents were advised how to legally minimise their taxable income to reduce child support payments. How do you respond to that reality? What can be done about such sites? Are there reports made by you to relevant regulators about these kind of websites that actually undermine this whole system?
I'm not aware of a referral process. We work very closely with the regulators, and I know we've got ASIC coming in a little bit later. Part of me would say bad people like to do bad things, so unfortunately there will be things such as websites like that. What the enforcement element is, I wouldn't know to be able to say take it down.
Okay, well, perhaps you might take that on notice and see if there's any protocols around that, because we have, for scams, we have reports that people can notify, and there's some pretty dodgy things going on in that area, but we found a way to respond. And I guess if people are absolutely helping people avoid their financial responsibilities and perpetrate abuse, then we should be able to shut that sort of stuff down.
We do rely on intel, I suppose, for want of a better term, from some of our advocacy groups. So we do work closely. We have a reference group for child support specifically, so that they can raise areas of concern. So we have open channels for things to be at least raised, whether we're able to be the ones who can enforce it or not. There are open channels with them, including across a range of the advocacy groups that are representing either single mothers or single fathers, quite frankly.
Yeah, and I guess the question is whose responsibility is to take that action, right? So things can be reported in a meeting, or can be, but then what happens? Like what is the outcome? If you can find out, whose ultimate responsibility is that? Because the figures we've got here, 22-23, the enforcement program, according to the ATO, led to 73,426 tax returns being lodged. And importantly, just so we get a sense of the scale of this, 21,000 child support debts being recovered. I wonder how many children those failures to report and failures to provide have had on children and their life trajectory, to say nothing of the ongoing financial abuse post-separation that is embedded in the practice. So it's a pretty serious situation. Have you got any innovation on the horizon in terms of being able to prevent and interrupt these sorts of practices very, very early on?
I think what I'd say, Senator, is certainly as single touch payroll continues to expand.
It's a new tool, yeah.
It's a very, very new tool. And as what we are seeing is some of the larger employer groups coming on to that. And I think that's certainly having a role to play.
Mr Piazza, would you be confident that those numbers would be beginning to decline as a consequence of the increasing use of, wide use of single touch payroll and its capacity being met?
Which numbers, Senator?
The 21,000 child support debts recovered. Do you think that those numbers will decrease or increase over a period of time?
I probably couldn't comment on that. I don't know what the trend or what that 21,000 sort of referring to, or as in the timescale and things like that.
Yeah, perhaps take on notice what's already becoming apparent with the use of single touch payroll, and how effectively you think that is interrupting financial abuse. That's probably a cleaner question.
Yeah. And I also take note of the comment you made around, and has it reached capacity? So are there still opportunities for single touch payroll to be used in a way that might, whether it's financial abuse or more broadly around supporting people in reporting income across a range of programs? I was actually going, thought you might.
Yeah, and Senator, there was some legislation that was passed last year, the Social Services Legislation Amendment Child Support Measures Act, which introduced a range of additional powers in relation to child support compliance. One of those was providing for Services Australia to be able to initiate employer withholding arrangements to collect unpaid child support, particularly when a case has ended, as well as some tightening of things like overseas departure rules and things like that. And so we can provide some more information about what some of the progress since that legislation passed, but it is expected that there will be around 18,000 parents who will have child support captured as a part of extended employer withholding arrangements, and so that will reduce the risk of that group growing and hopefully kind of have access to more debt arrangements.
Some of the examples in some of the materials that we've received, case studies, indicate paternity, identity, resistance, and the cost of trying to determine paternity in cases where there is clearly a great distance now between the mother and potential father of the child. What's happening with regard to that? Because that's another form of financial abuse, and we've got examples here in our papers of people who just give up because it's too hard.
So I think that was an issue that was raised through the joint family law inquiry, and things like the evidentiary requirements for these issues. It's an area that we're looking at. We've got that kind of stakeholder consultation group which we're testing a few ideas with, and it's probably something we'll be looking to do over the next period of time. There's some requirements that exist in policy, some that exist in legislation, and we'll need to work across government to determine some ways to respond to those recommendations.
I'm just going to ask the Secretary if they can provide you with a copy of, it's a single page of a submission that I strongly recommend that you have a look at. It's from a social enterprise called Flequity Ventures. It's the work of Miss Catherine Fitzpatrick. And this mind map, I'll call it, is a bit of a reveal of her insights with regard to fraud, scams, and then financial abuse. I don't know if you're familiar with any of this work, but you can see Australians rightly have been very, very engaged in awareness about scams because of the way technology has changed access to people's lives for scammers. You can see the scale of that: 601,000 Australians who are impacted by scams to a dollar value of $2.7 billion. Fraud, same thing, and you can see what happens. Financial crime teams get involved, or scam teams, and then there's trying to get money back, etc. The fraud is 1.8 million Australians, 677 million. But if you go down to the bottom, the financial abuse, which is the focus of this inquiry, the scale of it is the impact on 2.3 million Australians, and the amount, $5.7 billion. Now, I would posit that over on the right-hand side, external supports is a really big part of where you are in the equation, that people actually end up with you. And as Ms Mascarenhas noted earlier in some of the evidence, we heard that $2 billion of that $5.7 billion is actually unpaid child support payments, part of the whole ecosystem of financial abuse. Banks are certainly becoming more and more engaged in frauds and scams, seeing it's their responsibility. If you look at her diagram here, that whole financial piece is missing. There's no scam team, there's no financial crime team, there's no financial abuse team as such in this diagram, where there's an attempt to recover monies from those who might abuse. This is, I think, I'm putting to you as part of the ecosystem that you're working in, and it seems that you have a fractured relationship in terms of one of the critical players, which is the financial services providers. I'm interested in your response to this, which I'm happy for you to take on notice. But you know, at first flush, this is you're in that bottom section. What do you think about what she's observed here?
I don't think I'll offer an opinion around something that we've just been given and don't know the veracity behind it. But the concept itself, I agree that there needs to be a stronger focus on supporting people understanding that they may be in a financial abusive situation. Yep. I think at times, and similar to some of the steps that need to be taken to educate people around that there is fraud out there, there are scams out there. It's the same. How do you start to educate and support people to understand, actually, this is not good, and what are my opportunities? And then it goes to where you're talking, I think, what's the ecosystem that needs to be strengthened maybe, that wraps around that, that supports people. So we do work closely with financial counsellors, we do work obviously with the social network, we do work with the banks, we work with the regulators. Is there opportunity? I suspect so, yes, to continue to improve and strengthen. What are the opportunities there to give people the supports that they need, whatever those supports might be, to address the abuse that they may be under, and
or indeed to prevent it with a few dissuading elements. Yeah. So one of the things that Ms Fitzpatrick put to us is if you have a look at contracts that people sign around insurance, there are very clear definitions about what flooding is. There are no clear definitions about what financial abuse might look like. But she did indicate Suncorp was a first mover in terms of identifying if somebody put in a claim against a perpetrator of domestic violence. Now it's very clear that people can get repaid for that, whereas once upon a time you were attached to the perpetrator, therefore you were ineligible. So this is quite a significant shift in terms of contractual responsibilities for engaging in a financial product that relies on a modern definition of what financial abuse might be, and that then becomes the trigger for the capacity to seek recompense or redress from the perpetrator of financial abuse. So I guess the idea is to come further along this road, right back here to a preventative point, that would lead to far fewer than these 2.3 billion Australians being impacted, far less than of the $2 billion that ends up being disputed around child support, being interrupted by early practice. Now, there's a website called respectandprotect.com.au that she referred us to. She's working across the banking, general insurance, telecommunications, education, technology sector. She's also doing a pilot with New South Wales Services Australia, and made it very clear to us that there's a big gap between the engagement with Services New South Wales and Services Australia at this point of time. So I just point you to that very innovative work, which to me it looks quite hopeful, and is garnering more support as it goes. So if you would have a look at that submission, perhaps even maybe have a conversation with Ms Fitzpatrick, and give some feedback to the committee about where you see some of those ideas potentially being able to work with systems that you have in place, or upgrade to systems with those sorts of changes. Finally, from me, your submission highlights the National Plan to End Violence Against Women and Children 2022 to 2032 as setting the national policy agenda for addressing violence against women and children for the next 10 years. My question is, does it specifically address financial abuse? Mr Crozier, I'm glad we didn't bring you here for nothing.
So it is referenced, so financial abuse is considered one of the forms of domestic and family violence. So it is very much recognised within the National Plan. There are a number of things that I guess happen through the National Plan in terms of delivery through the action plans. They go more to the overarching forms of abuse, and of which financial abuse will be included. So just to sort of give you some examples, there is and these particularly go to education, I guess, awareness raising and training, as well as also support and referrals. So, as I mentioned, the National Plan recognises financial abuse, but the national principles for addressing coercive control, which sort of sets out that shared understanding of what the common, I guess, features and impacts of coercive control, very much sets out examples around financial abuse within that document as part of the awareness raising. But there's also 1800 Respect, which is the counselling information and referral service. So that will provide counselling, referrals and information around all forms of family, domestic and sexual violence. But there is a specific tool in there, which is the 1800 Respect Financial Abuse Toolkit, and that sets out what is financial abuse, what are the signs, what are the options for support. There are other things such as DV Alert. DV Alert is the training program that's for predominantly for frontline workers. And again, this is around all forms of family, domestic and sexual violence, but it will also cover financial abuse as well. So it's mostly around embedding financial abuse amongst all forms of domestic, family and sexual violence.
So if I hear you correctly, this is awareness raising. There is also commitment to response capacity when people are in the situation, which of course, you don't leave anybody without need, but it's kind of harm minimisation. You want to start with prevention, you want to move to early intervention, and then harm minimisation when required. And it sounds like most of what you've said is harm minimisation.
That's correct. So if somebody calls up, for example, into 1800 Respect around financial abuse, they'd either receive information through that call, or potentially be referred to another service where they might refer.
And I guess the evidence we're receiving is people have so little agency at some points in that journey, that no amount of offers of support or offers of descriptions to help you clarify for yourself that you're being financially abused is of any assistance at all, right? So if it's depending on where you are in the scale. So if I can leave it with you to think about what interruptive practices, what innovation offerings through association with banks and financial service providers can Services Australia and the Department of Social Services and the Department of Prime Minister and Cabinet think about to interrupt this process right at the beginning? What sort of contractual obligations need to be embedded in the things that create contexts where financial abuse occurs? Is there something about, before people marry? Is there a period of time? Are there products that need to be created by the banks that, if you've only been in a relationship for a short period of time, that there are mortgage practices that provide products that are going to be safer than others? To share the responsibility for interrupting early, and to have a way for your people at the front line at 10 to 4 now at Hay to be able to interact with a bank in a hurry, not just your own internal systems, to actually be able to get, can I get a quick readout of any indicators of financial abuse or domestic violence that you can see from the data that you've got? Those sorts of interfaces, because technology is changing what can be done, what can be seen, and I have some fears about surveillance, but I'm also absolutely mindful that surveillance for protection is something we shouldn't be overlooking. So if I can ask you to think about those and come back with a further response rather than a description of where we are, what change we need to interrupt financial abuse early, what tools you need, what allies you need, in addition to support from regulators and banks in a let's have a nice conversation way. I want you to think about way beyond let's have a good conversation and let's identify how do we prevent is really my question to you. I understand you've got a question, Senator Pratt.
Yes, I wanted to ask Ms Padma Rahman, in terms of the work of the Office for Women, there's a lot of work to do coordinating reform across agencies, and I wanted to know what approach the Office for Women was taking to that.
Thanks so much, Senator Pratt. Great conversation to be part of, and I did raise my hand because I wanted to say that following National Cabinet on the 1st of May, there was a series of tasking around how we can do better across family, domestic and sexual violence. And one of those elements of that tasking was to set up a rapid review to look at what more can be done, especially with a focus around homicide, but more broadly around family violence. And you'll be happy to know that that panel has been discussing very much the safety by design principles that Catherine and others have, it was first developed by the Safety Commissioner, but is being applied. And we're thinking about how do you apply that to government systems. The Office for Women has a coordinating role across, and in the last budget it was made clear that we have a coordinating role across government around family, domestic and sexual violence. While DSS is responsible for the implementation of the national plan, we've been given more of a coordination role. And I think some of what we've been talking about today comes squarely within that coordination role. And I think even when we were talking about the banks earlier, we engage frequently with the Commonwealth Bank and other banks. And I think the office is in a good position to even the point that you put to Treasury, we could do some of that joining up of the banking sector and Treasury to think about things like what happened during COVID, where women, we saw a sharp increase in financial abuse, but we also saw women being coerced into taking out their superannuation, for example. And this is a system that clearly sits within Treasury, and we've heard very, very disturbing accounts of women left with zero balances because they were coerced into reaching into their super. We know for a fact that women have lower super retirement savings for a range of reasons, including the fact that women are largely in lower paying work and do most of the unpaid caring work. So I think the office plays a really crucial role. We now have a strategy, the Working for Women strategy, a 10-year strategy to reach gender equality. It very clearly recognises that we need to work across 5 areas, and the first area is ending gender-based violence. To be able to get to gender equality, we need to not just work on ending gender-based violence, but looking at paid and unpaid care, looking at women's economic insecurity, looking at women's health and women's role in decision-making and representation. So we've got a framework, and I think we're very well placed, even though we're tiny, we're well placed as an office to be looking at where we, as government, can better coordinate. And systems abuse, as you've talked about, is something that we're very, very clear on how the Commonwealth has levers around its systems to ensure that systems aren't weaponised. I mean, unfortunately, I think someone said bad people do bad things, but we also know that wherever there's a system and you've got a perpetrator, they'll try and use the system or weaponise the system to perpetuate the abuse or the harassment. So I think we need to be very conscious as the Commonwealth Government to be looking at our own systems. And we stand in a good position to be able to do that.
Thank you. Thank you very much.
Thank you.
Senator Scarr, are you happy to move on to the next witnesses, or have you got questions?
No, I'm happy to move on.
Thank you. Thank you very much.
I have plenty more questions, but we've probably exhausted.
We have, indeed.
Today.
Thank you. Can I thank you all for being here? Hopefully that triggers some further interactions between all of us. There are a few questions here that I didn't get to that we'll send in on notice, particularly with regard to submissions from others around matters like the Privacy Act of 1988, issues, suggestions about a new coordinating body. The question is, do we need another one, or is perhaps the Office of P&C doing that kind of work already? So a few questions of that nature as well. Thank you very much.
Thank you.
I now welcome representatives of the Treasury and the Australian Securities and Investment Commission. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names, the capacity in which you appear today? We might start with on screen. We'll start with you, Commissioner Kirkland.
Thank you, Alan Kirkland, Commissioner, ASIC.
Miss Abbott.
Danielle Abbott, Willama Noongar Yoga and Senior Manager of ASIC's Indigenous Outreach Program.
Sorry, Miss Abbott, did you just speak a language then?
Yes, Willama Noongar Yoga. So it's
fantastic.
My traditional country.
Thank you. And can I just alert Hansard to the reality that we expect that to be in the Hansard in accordance with the standing order from 2019. Mr. Dorman.
Yeah, Michael Dorman, Senior Manager within the Strategic Surveillance Team at ASIC.
Thank you.
Shabani Iyer, Acting Assistant Secretary, Member Outcomes and Governance Branch in Treasury.
Thank you.
And Rob Preston, Assistant Secretary, Banking, Insurance and Credit Branch.
Thank you very much indeed. Now, did Treasury have an opening statement?
No.
No. But ASIC you do, and we'll give you the chance to read that into the record. Thank you.
Thank you, Chair, and thank you for the opportunity to appear today on behalf of ASIC. ASIC administers and enforces a broad range of legislation relating to the provision of financial products and services, including credit. Our regulatory activities include law enforcement and other regulatory activities, such as undertaking targeted reviews of financial products and services. The laws that ASIC administers include broad conduct obligations that may be relevant to a situation where a financial firm responds poorly to a consumer experiencing financial abuse. It is, however, important to note that there are no financial services laws explicitly directed towards how financial firms should treat consumers experiencing financial abuse. Noting that context, we have made an effort in our submission to provide examples where issues relating to financial abuse have come up in our work on a range of issues, and I'll briefly touch on 2 areas of our work covered in the submission. The first is our recent end-to-end review of the policies, processes and practices of 10 large home lenders in responding to consumers experiencing financial hardship. Our review culminated in Report 782, Hardship, Hard to Get Help, Findings and Actions to Support Customers in Financial Hardship. As part of this review, ASIC found that lenders were not doing enough to support vulnerable consumers, including those experiencing family violence and financial abuse. In ASIC's submission, we've included a number of case studies from our report that relate to consumers experiencing family violence and seeking assistance from their home lender. These case studies highlight that home lenders are not always providing consumers in deeply stressful situations with sufficient levels of care and support. Mr. Dorman, who's appearing with me today, led that piece of work and can speak to the case studies and to our broader observations in more detail. The second area of our work that I would like to mention is that of our Indigenous Outreach Program, the IOP, a dedicated team that's been part of ASIC since 2009. The IOP is a specialist team working across ASIC to provide advice, insights and support to ensure that the needs and requirements of First Nations investors and consumers are understood and addressed appropriately, effectively, and in a way that's culturally sensitive and responsive. ASIC published its first Indigenous Financial Services Framework in February 2023. The framework outlines key learnings relating to First Nations people's access to and engagement with the Australian financial system that inform our work. ASIC has also hosted a series of workshops for industry on barriers to access and issues of importance to First Nations people in the financial system. Relevantly, a workshop in March focused on identifying and supporting First Nations consumers who may be experiencing or at risk of financial abuse. This workshop showcased real-life consumer experiences and highlighted best practices that could be broadly adopted across the financial services industry. Ms Abbott leads the IOP team and will be happy to speak in more detail about its work. We recognise there's growing community interest in the way in which financial firms are responding to the needs of people experiencing financial abuse, so we will be closely following the progress of this inquiry, and we now look forward to answering the committee's questions. Thank you.
Thank you very much. In the first instance, can I go to your review, finding that most lenders had an organisation-wide policy and staff training on how to identify and handle consumers experiencing vulnerability, and we've heard from the Services Australia and DSS that they have those sorts of policies as well. But you went on to identify a range of issues with how lenders were actually in practice implementing or failing to implement the recommendations around treating vulnerable people, engaging with them. Can we just get on the record what the sticky points were? What were the findings? Just let's get that straight up.
I might let Mr Dorman speak to those findings specifically around vulnerability, Chair.
Thank you.
Yeah, thank you. And so if I go briefly to some of the root causes for those concerns that we saw. So really, we saw those policies were in place, but they weren't always consistently followed. So a lender may have had a process in place that said that in most cases, or in general, a customer experiencing family violence or financial abuse should be referred to a specialist team who could provide individualised care and support to that customer. Didn't see that referral was always happening, and there are a couple of reasons for that. One key issue that we observed was really inadequate monitoring and oversight. So quality monitoring and oversight activities often tended to focus on individual customer interactions rather than considering a customer's end-to-end experience. That's really important when you're dealing with a customer who may be experiencing vulnerability. A vulnerability may be apparent from one interaction, but not another. And it's only by looking at that end-to-end customer journey that you can really understand where there may have been opportunities for improvement in how you deal with that customer. We also note that staff are often dealing with significant volumes. They operate under key performance indicators. That means despite the best intentions, they may not always have the time or capacity to just get it right for customers.
So to be clear, before you move on from that, Mr. Dorman, the KPIs are about volume, and in a volume metric, there is little regard for what you identified as inadequate levels, insufficient levels of care and support. Were there any KPIs around care and support?
So in the report, we do outline that that there were very minimal KPIs or performance indicators that were directed towards customer experience and outcomes. Most of the KPIs that we saw relating to the hardship functions tended to focus on operational efficiency or credit risk management.
So the KPIs are flowing in the direction of enhancement of bank outcomes, not enhancement of the experience of this vulnerable person who is identified as vulnerable and therefore should be triggering some sort of response that meets their need as a primary purpose of the engagement.
Certainly there was less focus in the upwards reporting to the senior management and other stakeholders on, there's less focus on that than there was on indicators like the number of customers who are in arrears and whether they've been able to restore the customer back into making their repayments. There was less focus on customer experience and outcomes compared to things like average handle time for calls, average wait times, things of that nature.
Do you think they're measuring the wrong things, Mr. Dormer?
I think operational efficiency and credit risk management are important to measure, but there also needs to be equal focus to measuring customer experience and outcome, including focusing on the measurement of those matters as they relate to vulnerable customers. I think what's important to note is in reporting about the overall portfolio, you can often miss out on pockets of the customer base where there may be, divergent and poorer customer outcomes arising. So if you're looking at if your reporting is focusing on the entire customer base, or maybe only 1 or 5% of your customers are experiencing acute vulnerability, they may be lost. Like the customer experience and outcomes for those customers may be lost in that sort of that reporting that focuses on the broader portfolio.
I think there's been a fair bit of discussion in the public place about the social licence to operate, and I'm all about people making profit, and but not at the cost of the common good. Clearly, the questions I've just asked for the witnesses who've left asked to figure out how they can create a preventative structure and set up product offerings that would have more prevention of financial abuse embedded in it. But there is an opportunity for these banks to, enhance social good and indeed build long-term relationships with people who, having faced a shorter period of adversity, can become long-term massive assets in that business over time. There's a bit of short-termism, it seems to be embedded in the evidence that you present to us in this report.
I think that's probably a fair observation. I would say that through our review, the right intent is there. Certainly, there is a desire across all of the banks that we reviewed to play that role. They will recognise the role that they have in preventing and minimising the impact of financial abuse and family violence on their customers. But there are a range of practical challenges that mean they don't always execute in practice in the way that they intend.
And your report was a result of observing 10 lenders, only 10 lenders. How many lenders are there?
I'd have to take that number on notice, but I would say that those 10 lenders account for the vast majority of home lending in Australia. There were 10 lenders. There was also another lender that we did a very similar review on, a major bank preceding this review. Between those two reviews, we're covering over 85% of the home lending market.
Okay. And did you have some small players amongst your sample because the technological capacity of different scaled banks and financial service providers would be quite different?
We did. We included 3 non-bank lenders in the review who are very different in scale to, say, a major bank. We also included 4 regional or mid-tier banks, and we included 3 of the 4 major banks.
Okay. Now, my last question before I move on to other colleagues is there seems to be a very big gap between identifying people who are at risk and providing support at that point and a consideration of how we use innovation to create products that have prevention embedded in them to stop the flow through, so that the response capacity is lessened because the products provide more protection from the beginning. I'm going to ask you, perhaps on notice, to have a look at the submission from Ms Catherine Fitzpatrick and associated works that I've referred to with the previous witnesses for envisioning a financial abuse response and structure that more properly echoes the models of how we're responding to scams and fraud perpetrated by strangers, and take some of the mind and cultural practices and expectations there into the more intimate situation of financial abuse, which is highly exploitative, but tolerated, it seems, and almost blaming the victim for being in a situation and certainly having terrible impact on the victim. So if you can have a look at that, financial abuse equals fraud, it's quite a significant mind shift around who is responsible, what does a product fit for the 2024-25 year look like in comparison to the current offerings of products that we know are enabling financial abuse to occur. So it's less about the systems of response to financial abuse after the fact and more about it before the fact to prevent and lower the seatbelt on analogy, if I can put it that way. Over to you, Senator Scarr, and then I'll come to Senator Pratt.
Thank you, Chair, and thank you to everyone for joining us today, and thank you for all the work that you do. If I can, just whilst I remember, if I could ask you all to take on notice, if you could have a look at Ms Fitzpatrick's submission, which the Chair alluded to it, we found it, well, I think I can say that, we found it quite compelling in many respects. There are a number of recommendations made in that submission. I'm keen to understand, A, whether or not any of those matters are currently in train through any processes currently being undertaken by Treasury or ASIC.
It was really to say will design and distribution obligations, which look at the products themselves, but not the misuse of those products, and whether safety by design should be incorporated as an obligation.
Thank you. Back to you, Senator Scarr.
Well, Senator Pratt, as always, was absolutely on the money there, and that's contained in recommendation 2 of Ms Fitzpatrick's submission. And there are a number of other points which were made, including recommendation 4, where Ms Fitzpatrick called for a comprehensive financial safety review of the regulatory framework, everything from the Insurance Contracts Act through to other pieces of legislation in this space to see if they were fit for purpose in terms of protecting people from financial abuse, particularly people in very vulnerable situations. So one of the examples that Ms Fitzpatrick gave in the insurance space was under the Insurance Contracts Act. There's a definition of flood, but there isn't a definition of financial abuse, and you could have circumstances where one member of a relationship engages in malicious damage of an asset which is under an insurance contract, and the other, the victim survivor, is deprived of the benefit of that insurance contract, just to give you one example. So it'd be very interesting to have your detailed response to those recommendations, and also an indication as to whether or not any of the things suggested are currently in train, in whole or in part. If I could ask ASIC a number of questions, and Treasury should feel free to, if you've got anything to add in relation to these questions, please feel free. I found it very interesting that ASIC's submission actually touched on a number of examples and issues which have been raised by previous witnesses, including firstly in relation to the issue of financial elder abuse and powers of attorney. So I'm wondering if you could provide some commentary in relation to the review that you discuss in your submission. Provide an update as to whether or not there's been any subsequent reviews since 2020, and perhaps if Treasury could maybe give an indication from your perspective, happy for you to take on notice, if you're aware of any movement in this respect. We did receive some passionate testimony earlier today that this issue had been on the agenda since 2003, and to have uniform laws dealing with enduring powers of attorney, etc. So I think we're keenly interested to get an update in that regard. So if I could go to ASIC first in relation to the commentary you provided on financial elder abuse and powers of attorney.
Certainly, Senator. So that was a piece of work done several years ago. It was looking, because ASIC doesn't have any, has limited jurisdiction, I guess, in relation to powers of attorney. We can only look at particular aspects of those relationships, and what we were looking at was where there were opportunities to reduce the possibility of harm to older people by financial abuse in those situations. We found that in general, the policies that ADIs or banks had in place were inadequate to identify financial abuse. That there was poor record keeping in relation to the disputes that they'd seen, and there was an over-reliance on frontline staff to identify issues. And we found that, I guess with a similar theme to some of the financial hardship findings, where policies did exist, they tended to be reactive and focused on staff identifying issues where they're identified. We haven't done any specific follow-up work since that piece of work, but we are obviously watching the issues coming through this inquiry, and those will inform some of our decisions around future priorities. And we do note there have been a range of other calls for reform in this space in recent years, and if there were to be any processes initiated to look at reform in this area, ASIC would be a really interested participant in those processes, given the observations we made in that previous piece of work.
Okay, so there hasn't been any further work undertaken that you're aware of by ASIC in that space since that useful study or review was undertaken?
As far as I know, there hasn't been any more work of any substance in that issue, in relation to that issue.
Okay, thank you. Does Treasury have anything to add?
Limited on enduring powers of attorney. So I understand that they're made under state and territory law.
Sure.
And so I think that, as we understand it, there's in October 2023, the Attorney General's Department started a consultation process focusing on elder abuse and having greater consistency for enduring powers of attorney. So it might be better to focus questions on reform in terms of harmonising it to that department, because they have carriage of that matter.
Yep.
Would it be worth, I noted you gave us a bunch of questions on the Ms Fitzpatrick's submission, which I confess I'd read the CWES submissions, but I didn't realise the name of her, I didn't relate the name of her company to her name, so I only read it today. We're certainly aware of some of those issues that have been raised. So, and I think it's fair to say that when it comes to, say, the Insurance Contracts Act, the ICA, Insurance Council of Australia, and also the Council of Australian Life Insurers both recognise that there are challenges when it comes to the operation of the law with certain contracts, with certain relationship breakdown issues. So in general insurance, that might be things about how the distinction between how people are treated under a joint contract and how they can be affected by poor behaviour by their partner to sort of stop paying for a general insurance cover, and there are other related issues in the life insurance space. So we're certainly aware of those. These are issues that Treasury will provide advice on from time to time, and we engage with stakeholders on those matters. We don't have there's no sort of active piece of reform relating to that issue. I might note as an aside, there is an active area of reform when it comes to the flood definition, but that is entirely unrelated.
Yeah.
But yeah, so
I was using,
no,
you know, the context in which
and I
was
might just note that Insurance Contracts Act is really trying to think about governing relationships between the insurers and the insured, and to ensure that they're fair and there's an utmost duty of good faith. So it's really quite a foundational piece of law which tries to think about how parties relate to each other, and that's sort of why we do have things like definitions of flood in that, because that really you can have insurance over flood, and that's why it can be quite important to have those sorts of things defined.
But it's interesting, isn't it, Mr Preston, that it looks at the situation between the insurance contract is a contract of the utmost good faith. I remember that from my insurance lecturer back at law school. But you have a relationship between the insurer and the insured, but if you have a joint insured, there's also that relationship between insured A and insured B, and the fact that what insured A does can prejudice the rights of insured B with respect to their relationship with the insurer. So it's a more complicated dynamic in terms of the commercial relationships between the relevant parties. And as you say, the Insurance Contracts Act is simply looking at the relationship between the insured and the insured holistically together as a group, and the insurer, as opposed to what happens when that relationship between the insureds breaks down, and how the insurer should respond to that. That's the point, isn't it?
I think that's right, and I think I thought the both submissions of those two peak bodies of the different strands of insurance both pointed to the fact that they've definitely experienced, or their members experienced, challenges and issues with economic abuse relating to those terms. But I think they did also, and I think quite reasonably, point to that there'd need to be a lot of care and consideration before thinking about trying to unpick and change some of those terms, because they are quite fundamental to sort of the contract piece that underpins insurance.
Absolutely, and I agree with that. So as I understand what you're saying, Mr Preston, there isn't at the moment, and this is simply for us to get an understanding as a committee as to what processes may be in train, so we can consider whatever recommendations we may choose to make to government. But as I understand it, in this space, issues are considered as they arise in different contexts. There isn't currently a process being undertaken where all of the relevant regulatory framework is being analysed for these particular issues, with this lens particularly applied in terms of financial abuse and whether or not each piece of the puzzle needs to be recalibrated to take that into account. Is that a fair comment?
That's a fair comment, yes.
Okay. My friends at ASIC, reverse mortgages, and again, this was another issue which was raised by previous witnesses, so I was very interested to see that ASIC has undertaken work in this space, but this was work that was undertaken in mid-2017. Has anything been done since then in relation to reverse mortgages? And I guess I say that in a context where property prices between 2017 and 2024 have exploded in many cases. So the potential quantum of the problem has grown by an order of magnitude in terms of, in particular, elderly people being pressured, taken advantage of to obtain reverse mortgages for the benefit of those who apply that pressure.
It is another area where, similar to the report that the work that we spoke about in relation to powers of attorney, where we did an important piece of work that I think revealed a number of problems, and we made our views clear to the industry in an attempt to drive better practice, but we haven't done any other substantial follow-up work on that issue since that piece of work.
Okay. And my last question just in this space, because as I was thinking about this, another area of potential elder abuse came to my mind, and that is a situation where one of an elderly couple passes and they could have a close family member who's the executor of the estate of one of the parents, say, who's passed, and seeks to leverage that position in an unethical or abusive way to the detriment of the surviving parent. Has ASIC done any work in that regard to see how financial institutions respond in a deceased estate context where, say, a child of a deceased parent is the executor and is given a lot of power in that context, which could be used to the detriment of the surviving parent?
I'm not aware of any work specifically on that issue, Senator, and it is one of those complex issues that crosses over between state and federal law. So if we were looking at that issue, we look at it from the perspective of the obligations of the banks. So are they complying with their conduct obligations in terms of the transactions that they allow to occur, for example? If there are concerns with the performance of an executor, under state laws or under trust law, that would generally be something that would be a matter that would be considered under state law. So it wouldn't be something that ASIC would have a specific role in relation to. So it'd really only be around the bank's conduct that we might have some sort of role.
So specifically in relation to that, has any study, and that's what I was thinking of from ASIC's perspective, has anything been done to look at what the procedures and protocols of financial institutions are in that context and whether or not they've got appropriate safeguards?
I don't believe we've done a specific piece of work in that area, Senator, no.
And I guess the only other comment I'd make, this is probably a comment rather than a question, but as Senator Pratt in particular would know, one of the areas this committee does encounter from time to time is where you've got different regimes at different levels. There is sometimes a question as to who's doing what and liaison between the two different levels and whether or not things fall within the gaps. But with that, I'll leave that there, Chair. Thank you.
Thank you very much, Senator Scarr. Over to you, Senator Pratt.
Thank you. Your submission is very comprehensive and highlights the complexity of the task in reforming these areas. I think on page 8 of the submission, you highlight that if we as a committee can identify ways in which financial firms can better support consumers, we might wish to consider mandating requirements. Now, I would contend that you have probably already identified many of those ways, but in part it's the lack of mandating that can sometimes get in the way, although I do acknowledge you have significant buy-in with banks in getting them moving, for example. What should we have regard for, noting that you say it is complex and requires careful consideration? What would you like us to have regard for in our recommendations if we're to support giving you further regulatory muscle in upholding consumer rights, in protecting people from financial abuse?
So, as I think you've acknowledged in that question, Senator, it would require law reform. So, obviously, that's ultimately a matter for the government. That is, if there were to be specific obligations on institutions in relation to how they deal with customers experiencing or at risk of financial abuse. I guess the observation I would make from other areas where we have specific obligations, such as the financial hardship obligations, which we've spoken about with the committee today and on other occasions. Some of the characteristics that mean that regime can be effective are that there's a really clear trigger for the obligations. So in the case of hardship, it consists of a customer giving a hardship notice, telling a bank or a lender that they're unable to meet their obligations. That then triggers so it's a clear trigger, and that trigger is clearly defined. Then there's a really clear obligation on the lender. So in that case, the lender is required to respond within a particular time frame. And so that means that it is very easy for us to then do what we've done with that recent report and go and examine how well banks are complying. I think it allows us to set clear regulatory expectations for lenders as well about the detail of how that applies, which is what we've done with that report. So I think that would be the two key observations I would make, is these sorts of obligations are most effective where there's a really clear description of the circumstances where they apply and a really clear description of the obligation.
And can I ask, in the context of your Indigenous financial services framework, the extent to which you've got triggers that can be, I know design and distribution obligations have been used recently by ASIC in relation to the misuse, in relation to centre pay businesses, but how might a specific lens on financial abuse within Indigenous communities, where do you need specific regulatory muscle to assist there? Like we have gender lens on when bills go through cabinet, etc. When new regulations, for example, are drafted, what are there demographic groups that you must have specific regard to, or might be tweaked in the context of different cultural groups or women, for example?
So I let Treasury answer the question about the legislative process, if there's something that they're able to add. I would say just on the design and distribution obligations, because as you know, we have used them in relation to harm experienced by First Nations consumers. There are some limitations on how they can apply to financial abuse, as I think other witnesses to the inquiry have noted. And I think a few key things I would say about them are that they don't require a product issuer or distributor to think about whether a product is suitable for an individual consumer. So they tend to look at what happens to groups of consumers. And so unless there's a sign that there's sort of widespread harm, then those obligations are less likely to be a regulatory tool that we can use. So that's a particular challenge in relation to financial abuse, where I think we're often talking about a range of quite unique individual situations about how consumers in their individual circumstances might engage with a particular product or provider. So I think that's a real restriction for us. And in our Indigenous financial services framework, it is a very principles-based framework that sort of guides out, I guess, articulates our thinking and our understanding around some of the historical and cultural factors that affect First Nations people's engagement with the financial system and some of the principles that ASIC uses in our work in that area. But it's not regulatory guidance as such, and it doesn't have it doesn't impose any particular obligations on institutions. It's more a framework that sort of articulates our thinking around those issues in terms of First Nations people's engagement with the financial system.
Yeah, if I look, for example, though, to the case study on Mary living in a remote community, her card was compromised, and what she has to do is incredibly inconvenient, and she's kind of, I guess, identified as one of those outliers in those design and distribution obligations. But if, for example, you were to look at the large, almost monopoly, for example, that the Commonwealth Bank would have within many of those communities for those types of services, could we not actually look to using those design and distribution obligations to really say that the banking services that you're offering and aren't all that viable for a great many consumers, and it is exacerbating their financial vulnerability when it comes to financial abuse.
The design and distribution obligations, in the way in which they exist in the law at the moment, really look at how products are designed and distributed.
Yeah.
So individual products, they don't go to those issues around service delivery or issues around minimum levels of service that might be provided by institutions. So it require a change to the design and distribution obligation regime in order to, or another type of law reform in order to grapple with some of those issues around service delivery.
But something like safety by design, potentially you don't want to have a principle of safety by design introduced, for example, to your basic Commonwealth bank account, but it still not be able to respond to the issues that would be faced by someone in a remote community. How can we think about those issues to make safety by design culturally relevant to the kinds of issues that you highlight in this submission?
That's a very big question, and I think I wouldn't want to do it justice with a glib response or a short response, but I think the sorts of factors that we, and I might ask Ms Abbott to add a little bit of detail to some of the thinking that her team has done in this area, but I think that the thing that we generally say based on our the work of our Indigenous outreach program is it's really important for institutions when thinking about how they design products and deliver services to realise that there are some really unique factors that shape the way in which First Nations people engage with the system. But I might just, if you'd like, allow
yes, please, Ms Abbott
to add detail.
Thank you. I think when we think about identifying financial abuse and how that impacts on First Nations consumers, that's really what we've attempted to highlight in ASIC's submission, that there are many cultural factors that go into how money and resources are used across families and communities. So if we're looking at considering any kind of mandatory obligations, understanding what that difference looks like, so that if we are thinking of clear triggers and then clear obligations that flow from those, considering the distinction and how that would look and apply within a First Nations community would be really, really important. And the only place we would get that from is talking with First Nations communities themselves.
Yes, and you do highlight that in terms of abuse not being conflated with protocols of sharing and collective resources.
Yes, absolutely.
Thank you, Chair.
Thank you. Ms Mascarenhas.
So we keep on referring to Catherine Fitzpatrick and a graph that she has, but basically what we've been explained to us is that the order of magnitude of financial abuse is in the order of $5.7 billion, which I think is quite a significant amount of money. From the tools that we've got from a recovery perspective, what our understanding is that for Ms Fitzpatrick's extensive experience in the banking sector, she does not have any examples at all of banks trying to recover money from financial abuse. And when I think about scams, when I think about fraud, we have tools that are in place to try and obtain that money back. Or if I think of an insurance claim and an insurer trying to obtain money from someone that is liable for a particular thing, what tools do you think you need to help recover this money? And maybe that's in the jurisdiction of ASIC, maybe it's not, but...
Look, anything that it would be a significant change for ASIC to play that sort of role. So our role in general at the moment is about, similar to some of the observations in relation to that were made a moment ago in relation to the Insurance Contracts Act. Our role is in relation to understanding how firms are complying with the obligations they have to their consumers. And so the extent we might sometimes get involved in, I guess, ideas such as recovering money, it might be where there's a clear evidence that there's been misconduct that means that consumers have suffered financial loss because a firm has failed to live up to its obligations. And then we might seek court orders requiring compensation, or we might seek agreement from the firm that they will compensate those consumers. But it is typically about the relationship between the firm and the consumer that they have a contract with. So any extension into those sort of notions of financial abuse where you're bringing in other relationships that sort of in one sense overlap with that relationship with the financial system, in another sense exist outside it, would be a significant reform. And I think we're watching the evidence of the inquiry really closely. Obviously, any of those reforms, they would be a matter for government because they would require law reform.
And maybe a follow-up question, which might be to Ms. Abbott. I'm conscious of all of this money that's out that's not being used for, I don't know, its initial intended purpose. But what would be some of the things that government should think about to make sure that we're being culturally sensitive to our first Australians?
Yeah, I think starting with talking to community about what that could look like on the ground and hearing from diverse views and voices as part of that conversation. I think there are a lot of complexities that go with any return of money into community, and some sensitivities that can arise with financial abuse flowing from large sums of money coming into community. So being really clear on setting up surrounding supports as part of that. For example, a lot of the large-scale redress payments that have gone into community have had a lot of wraparound service supports on the ground, engagement with banks so that they're aware of customers coming in seeking larger sums of cash than usually available, ensuring that financial counsellors on the ground are alerted to when those payments will be coming in, so that if there are instances of financial abuse, that those service providers have an idea of timing so they can equip resourcing to any issues that do arise from that flow of money.
I'm conscious that some of the banking industry has been quite innovative at looking at how to deal with financial abuse, and I feel like there's this balance between mandatory and voluntary codes, and a part of me loves making sure that we're seeing people continuing to be innovative to see how they can deal with some of these wicked problems. Whether this is to ASIC or Treasury, but do you have an opinion on mandatory versus voluntary codes and the need for this, considering the scale of this problem?
Well, I think, you can jump in, ASIC colleagues afterwards. So governments have the ability to create mandatory codes within the financial sector. There are currently none. So the existence of that ability was created post the Hayne reforms, and I think from my memory of the explanatory memorandum of what it was pointing to as some of the things you'd be having regard to when thinking about making a code mandatory, it would be kind of particularly egregious behaviour, or perhaps an inability of industry to get a voluntary code together and be taking action. And there are a couple of other examples as well. And so I think there is a question about to legitimately ask as to whether or not the action of the financial sector would meet those sorts of thresholds as outlined in the EM. I think there is a balance that we need to seriously consider around innovation, the fact that sometimes the behaviour that you're wanting to stop is sort of digital and is fast evolving, and sometimes that means that the actions of those near the coalface, that is to say financial services firms, can be more flexible and adaptable if it is on a voluntary basis. So there's some sort of reflections that the government would probably want to have regard to when thinking about whether to make a code a mandatory or to continue in a voluntary sort of system that we do have. Oh, and just one other observation. I mean, I think it was interesting. I think it was Ms. Glenn this morning was sort of her reflection of where the banks are faced in terms of the global frontier, and I think she was reasonably positive. I think there is a lot of action happening, and say some of the I think the excellent work stopping things like abusive messages through the text associated with payments is sort of an example of positive action that is being seen through voluntary codes. So I think when we would be thinking about policy advice, noting that it is a matter for government, you'd be wanting to think about, well, what's the differential addition that you'd be expecting by going from what you're seeing in a voluntary basis to a mandatory basis?
Cool. Does ASIC want to add?
Yes, from the ASIC perspective, the thing I would add is that even where codes are voluntary, our view, as articulated in our regulatory guidance, is they need to have teeth. I'm paraphrasing that. That's not exactly what we say, but we say that they need to be developed in a transparent way with appropriate engagement with stakeholders. They need to have appropriate oversight mechanisms with an appropriate degree of independence, and there need to be compliance mechanisms, including the ability to apply penalties. So I would just make that additional point, because I think that those voluntary industry codes can play an important role here, but it will always be our role that they need to be effective and they need to have effective oversight mechanisms.
I note that we have one more minute, and it's an open question. If there's one thing that you think that we should do, you're welcome to share it right now.
Is that asking for an opinion?
It probably is asking for an opinion. I mean, yeah, well, I think it is useful to have exercises like this. I mean, one of the things when we provide a kind of a care and maintenance role when it comes to thinking and stewardship of the pieces of law that exist, and some of these things are challenging to work on, because they're legitimately complicated. So I think it is valuable to sort of have a light shone on this issue, because it is a tricky one to work through at times.
And in that vein, I would say we're following the inquiry very closely. We've read some of the submissions from some of the groups you've mentioned, like the Centre for Women's Economic Safety and Equality, and they're excellent contributions to the debate. And I imagine that the report of the inquiry, but also the ongoing evidence from witnesses, will be quite useful to us in our work.
Great. I notice ASIC gave the tick off to the ABA new Code of Conduct. Do you think that the Code of Conduct is sufficiently robust yet flexible enough to incorporate any changes that might come through from this committee with regard to changes of practice for more early intervention and product delivery that has risk awareness to a level that it can prevent some of the avenues, the easy avenues to perpetrate financial abuse?
Well, that version of the code has now been finalised and will take effect early next year, but it won't be too long, and we can provide on notice the dates. It won't be too long before the ABA needs to initiate the process of reviewing that code and thinking about how the next version of the code may need to evolve. So I think the report of this inquiry will probably be an important input to that process, and I imagine that a number of the advocates that feed into the code review process and ultimately put views to ASIC, if we're asked to approve another version of the code, we'll be looking closely at the committee's report.
Hopefully the implementation of recommendations from this committee might precede the next code. They could be that quickly enacted. I've just been spending a little time looking at the respect and protect.au website, which it starts off with this statement: financial abuse is a hidden epidemic in Australia. It's when money is used to control another person and is a reason many women face the stark choice of violence or poverty. Perpetrators misuse services like banking, insurance, telecommunications, energy and water to threaten victim survivors or accrue debts in their name, leaving them financially decimated. Businesses may unintentionally help financial abusers without proactive steps. Their products may be weaponised as a tactic of coercive control and manipulation. There are a number of menu points that drop down where people can go and see which businesses have already signed on to this, and where individuals and businesses can say, well, I'm going to join this push. Why businesses have acted, and amongst them is Hume Bank, which I saw a number of branches for when I was out recently in the seat of Farrer. Hume Bank explains why they've made the choices, and each of the 27 entities that have engaged, I think there's only 25 up here, but there's 27 entities that have engaged, have said, we all have a role to play in making our community safer and removing the ability for abusers to use systems, products and services as weapons is a step in the right direction to a better tomorrow. We want to send a clear signal that our bank will not be used by those seeking to engage in unacceptable abusive conduct. And this seems to me quite a significant step change in the attitude of social responsibility about determining not to have their product abused. And I think that that will certainly drive some change, and I'm very interested if ASIC might have a look at this website. Most of them are G&C Mutual Bank, Hume Bank, IMB Bank, National Australia Bank, Optus, well, but maybe that's not one for you, Suncorp, Westpac. It looks like things are moving in terms of those sorts of public declarations for a change of attitude that even supersede the work that you did with the 10 banks. So can I thank you for your attendance this afternoon and invite you to respond to any other of the submissions, but particularly the Flequity one, about your ideas, how that would intersect with the work that you do, where you see innovation possible, really, rather than explaining what we currently do. How do we interact with new models, new technologies, new discourse practices and community expectations to deliver product fit for the 21st century? Can I thank my colleagues for their hard work in preparing for today? I want to particularly thank the Secretariat. There's a lot of work to get these things up and running. I also want to thank Hansard and Broadcasting. Responses to questions on notice should be provided to the Secretariat by Friday the 26th of July. And now the committee stands adjourned. Have a great weekend, everyone. Thank you. Thanks, colleagues.